Milord, may I have your lordship's leave to mention in regard to item number 91 of the days list for an upgradation, Milord? Milord.
Forget it. Just forget it, Mr. Dutt. Upgradation we are not allowing. Let us go serially. Yes.
Mention one matter for hearing lordship. Paper book has already been
Hearing we are
filed.
not taking up now. Yes.
For hearing of order 41.
Order for 10.
Lordship, I was mentioning for release Mr. Chakravarti is okay.
It will appear as to be mentioned.
My for admission. I'm great. He's pending from 2023.
Need not say 2023. Admission. All right.
Lordship,
Yes.
my lord, may I be...
Lordship,
One by one. Yes. From that side. Yes.
2019 matter, my lord, for hearing.
Please forget it. Just forget. We'll dispose of more matters and then we'll take up.
As your lordship.
the discussion.
Yes, please. Applications and order 41 you can hand over slips.
My
Order
lord,
41 application just hand over. Why
Application.
wait for me?
deeply obliged, my lord.
Thank you.
Application.
Niche, like.
Please use the microphone, ma'am.
Lordship, may I be permitted to mention one matter for inclusion, Lordship?
What is the matter? Application, order 41?
FAT.
FAT means many things. Application,
Application, Lordship.
you are sure? If you are not sure, come back tomorrow. We take up mentioning every day. Yes, call on the list. Yes. For filing of notes?
No,
Why do you mention?
it was fixed. Yesterday, my lord, just what your lordship noticed that the order, your lordship please to
Oh, that FAT.
FAT and FA.
It was appearing in the list otherwise. কি হয়েছিল জানো কালকে? ও অন্যটা চলে এসেছিল আচ্ছা কারেক্ট করতে
In the order, my lord, your lordship had FA. It should be in FAT. Otherwise, the
বুঝে we are correcting that order and directing FAT to appear in that.
FA in the list.
In the order dated April 16, 2025, comma, the number of the appeal was erroneously mentioned as FA 151 of 2016, whereas actually the appeal is numbered as FAT 151 of 2016. First of next para, let the order dated April 16, 2025 be deemed to stand corrected accordingly. Pushed up. FAT 151 of 2016 shall be listed tomorrow under the heading for hearing.
Get for him.
Thank you.
Lord, I mentioned this for minor corrections. Kindly have a look to last page. I have noted down. ওই একটা এই আছে আর কি, ওটা 50% নয়, enhanced amount পুরোটাই জমা হয়েছে।
ও আচ্ছা লাস্ট পেজে মেনশন করে দিয়েছে
Last page, it will be respondent the subject. The entire decreed amount was deposited. We have withdrawn 50%, balance 50% is lying. So this is required to be corrected.
After the pronouncement of the resolution for the respondent, gross object from
সিরিজের দিকে তো একটা কারেক্টেড অর্ডার হবে বলছেন স্যার
ঠিক আছে।
Mirror, may I pray one thing? Mirror, kindly have a mirror before passing the order. Mirror, kindly have a come to page 19. Mirror. Page
just let Justice Kumar finish.
Out of which 50% has been withdrawn.
He's the author, so let him have it.
We both.
and mirror
Other things are
no.
okay.
Mirror, kindly come to page 19. Item number Roman 4. Mirror,
19.
yes, page 19. Your lordship has directed everything, but unless a time limit is fixed, they will not do anything. No time limit is fixed. These are the two humble prayer. But they really still states. Normally, they do not do anything.
One thing, my lord, in
No, the
this
time
matter, in
time
this
limit
matter,
For initiation of proceeding and passing the hour.
my lord,
Otherwise, you know what they
that-
will do, when they will do.
for that whether you are in agreement that time limit will serve any purpose. How can we bound the entire procedure within a certain time?
No,
How much time
unless your lordship
will a
fix
collector
the time, they will never do it.
my lord, in this
They
matter,
will
my
never do it.
lord, in this
6 months, 1 year, whatever your lordship.
Mr. Bera, you are already having the compensation which was previously paid.
Yes.
So we cannot direct them to do it within a time limit or initiate
Within
proceedings.
3 months or
It's
6
the
months,
discretion of the state when they start it.
Suppose
is
you
better to go
they
and,
do not do anything.
place your
The matter will remain forever. If they do not initiate any proceeding, what
If
will
within a
be the
reasonable period they don't, then you can come up before us. But this is not a, I mean, they have been directed to initiate a fresh proceedings.
Yes, but that must be concluded within a certain period. Otherwise,
It's very difficult to give a timeline. They are also hard pressed.
The separate
Whatever
proceeding
your
is
lordship
decided by ALM.
will, my lord, that
Not
anytime 6 months,
the
1
proceeding.
year, whatever your lordship.
টা বড় জোর একটা বলতে পারেন যে initiate
Well,
within such a
Preferably within certain time,
Which
to
is-
kindly add that.
Get fresh proceedings.
My lord, in this matter, what happened, my lord, in this matter, apart from these awardees, there are so many awardees, they have accepted the award, they are enjoying the money. And inter proceedings be quashed. Then one of the award is also.
Your
will
lord,
come.
my lord has not quashed the entire proceeding. My lord has quashed
Well,
so far as the
My
petitioner's
lord, I
facts are
understand
concerned.
under the award, there are several awardees, they have
They
accepted,
had challenged and
no, they have accepted the award.
that was wrong.
এটা pass করে দিন, এটা করে দিন আর এটা দেরি করলে আপনি এটা অনেক ম্যাটার পেন্ডিং আছে লিস্ট
Take down. This matter appears in list under the heading of to be mentioned in the initiation of, on the initiation of learned advocate for the respondents for making necessary correction.
রেসপন্ডেন্ট ক্লেমেন্ট করে দিন কারণ একটাতে
Respondent claimants.
একটাতে অ্যাপেলেন্ট একটাতে
For incorporating enhanced decretal amount out of which 50% has been withdrawn by the respondent and balance 50% of the awarded amount lying with the learned registrar general of this court.
let that later portion of the award stand corrected accordingly বলে
Yeah, let the latter portion of the award
stand corrected accordingly and be read
stand
as
corrected accord
follows. And be read as follows কোলন দিয়ে দেন
and be read as followed.
কোলন দিয়ে এটা
এখান থেকে নিয়ে
লেটারটা যা আছে কারেকশন গুলো ইনকর্পোরেট করে আবার পুরো লেটারটা চেক
Kindly add some time, my lord. Then, my lord, we have to approach your lordship either for, not for review, then we will ask for after certain period.
we go and make prayer then.
No, that is there, my lord, we will communicate this certainly, but it is the usual practice of the state not to do anything. Not to do anything. It is the usual practice not to do anything. You know, after certain period, we have to.
They are making blame on the state, my lord, I am opposing this, my lord. It is the practice of the state, my lord, it is not. They are getting, they have received the money, we are in.
So wait for the timing. No, next column.
Very
ডাকুন কোর্টে ডাকুন একটা তুমি মেনশন 1 ঘন্টা সময় yes
My lord, belated payment of special messenger cost, my lord.
we find from the office report dated April 4 2025 that the special messenger cost was deposited belatedly. Full stop. Let such deposit be accepted. Full stop. The office shall take steps accordingly for bringing the trial court records by utilizing the said special messenger costs by treating the same to be valid. Next. Thanks.
Five lordship, this is an application for restoration
Restoration application within time.
within time. But before your lordship passes any order, lordship, I
Yes.
would like to submit something.
Yes.
This is a matrimonial suit.
Right.
The husband died. His father and his sister was, an application was filed for substitution of father and sister. Now father also died. Another application was filed for substituting instead of father, the sister. During this period, the appeal came up before his lordship, the Honorable Mr. Justice, Mr.
What
Rashid
happened?
Manthan.
Sister also died.
No.
Thank God.
And lordship, one more thing, lordship, at that point, Ms. Sheila Sarkar was the advocate on record. But after the matter was dismissed for default, a new wakalatnama has been executed by the sister.
No objection has been. Oh, sister has.
She's
Should have taken a no objection.
She was
It would
not
be
due.
better. It would be better because it's a continuation because substitution is
Because
stepping into the shoes of the original.
that is why I made this submission because the client tried a lot, but he could not obtain it. So he gave a letter to her that you are requested not to.
That letter
appear.
is with you.
At present, it is not with me. Kindly.
We can take into consideration order 2 and deem that letter to be because if a letter is given,
Yes.
no response is there, you know the law.
Yeah.
So then we
keep
can
it next week, Lordship. I will obtain the letter and place it before you.
then we'll keep the entire thing next week.
Yes.
Because otherwise you cannot appear.
Yes. Yes.
Correct. On
That
the
is
prayer
why I
of
made the
the
submission at
on the prayer of the petitioner, the matter is adjourned till May 13, 2025.
Grateful to you.
Next Tuesday,
Or no.
first working day of that week.
Or no. ঠিক আছে? দেবো?
Shall I look into order 2 and just
Yes,
make the
yes.
submission on that? I've forgotten the exact provision of order.
I will.
Yes.
Lord, I am for the petition, Lord, wife, Lord, respondent. I
Yes.
filed the application, Lord, for maintenance.
For
maintenance.
maintenance.
You Lord rejected me, Lord, to file, Lord, affidavit assets. Lord, I am filing, Lord, but Lord, and Lord, opposition was filed by my understands, Lord, client, but Lord, Lord, knee pain, Lord, my client not come within time.
Some exhibits were taken by the Ordhendu Nag.
Yes.
You.
No, no.
I mean, you means your client.
Fine.
So despite repeated attempts to intimate you, you have to file those exhibits. Those were taken back by you. The records are not complete.
Ration cards, Aadhaar cards, which are Lord, urgent requirement.
The originals have to be deposited.
My lord, and for that reason, the paperwork could not be.
Yes, yes. We won't take up the alimony application because of your fault. It's being delayed.
My lord,
First, you deposit those exhibits, then we'll consider your alimony application.
Aadhaar card, original ration card. Lord, if you deposit.
Your client had taken back
Yes, I cannot.
those documents. You 4 attempts were made to contact you for giving those redepositing those.
Gas book, which urgent require for the for every month. Lord, how can I deposit? Lord, I can.
Those were exhibited in the court below. You should have thought before exhibiting those. Those were your exhibits. Unless you put those in, we won't take up the alimony application. Sorry. You are deliberately delaying the matter and then making alimony application. No.
Urgently, that was
First you deposit and come back. We'll keep it next week. Deposit within the course of.
My lord,
by this
may I humbly submit one thing?
this
The appellant husband is suffering from eternal health issue. He has
So
undergone.
we'll consider that at the time of taking up the alimony application. But first they'll have to put in the deposit. The exhibit. Grant to 2 weeks.
No, no, Lord.
1
This
week.
week I will do
Very
it the same. Next week, Lord, let it be
The
heard.
present application is an app.
My Lord, I am submitting, Lord.
What is this?
Affidavit assets, Lord, your Lord is directed to file
Please file.
affidavit assets and Lord reply to the opposition. Lord.
Opposition you have filed.
I am filing.
Opposition and your affidavit of asset you have filed.
No, I have served, but I am filing before.
File.
Lord, I am Lord.
Your opposition is composite to both the affidavit of asset and.
Yes.
Very well. The affidavit of asset filed by the husband along with the affidavit in opposition filed by the husband be kept on record. Full stop. The learned advocate for the wife also files her reply, composite reply and affidavit of assets which are also kept on record. Full
My
stop.
lord, no copy has been served of the reply.
The parties are directed to
Yes.
the parties are directed to exchange copies thereof between themselves if not already done by today. Full stop. Next para. It transpires from the office report dated May 5, 2025 that despite repeated attempts, comma, the respondent wife has not deposited certain exhibits which were taken back by the respondent wife but were made exhibits in the suit. Full stop. It is further noted that due to such recalcitrance on the part of the respondent wife, comma, the appeal cannot be made ready for hearing. Full stop. We deprecate the practice of delaying the hearing of the appeal by withholding the exhibits which were original exhibits which were taken back and in the same breath, comma, taking out alimony application in the appeal. Full stop. Next para. Accordingly, we direct the learned advocate for the respondent wife to immediately deposit
By this week.
to immediately furnish
My lord.
the original exhibits which were taken back by the wife and were part of the trial court records, comma, with the office, comma, latest during the course of this week.
My lord.
Full stop. Next para, upon such documents being furnished, comma, the office shall furnish a revised report as to whether the documents are complete. Full stop. Next para, the application shall be listed next on May 14, 2025
My lord, great, my lord.
under the same heading.
My lord, great.
এটা অফিসে নামিয়ে দিয়ে বলবেন যে ওরা যদি জমা দেয় রিপোর্টটা করে দিয়ে তারপর আবার 14 তারিখ লিস্টে থাকবে যেন
My
পাঠায়।
lord.
I am for the appellant petition. This is the affidavit of service as per direction of earlier order passed by another bench.
What are the several applications? There are several applications.
I'm saying the application can 2 and 3 are the application. One for police help to implement
They
the
have
order.
not received. Not received.
They are even not even not contested in the suit bill. This is the
Oh, this is
affidavit-
refused.
this is the affidavit of service of the present
Refused is
application.
good service.
This is the affidavit of
Oh.
service as regards the present application 4 and 5, can 4 and 5. In this affidavit of service, my lord, I find that one of the respondent died, return
Yes.
envelope returned back.
Right.
The last one, that is for him Polle.
So you have to take out in substitution.
Yes, my lord. 2 weeks time may be given in the meantime.
Learned counsel for the appellant submits that it was found from the returned envelope at the last instance of service that one of the respondents has died in the meantime. Push up on the prayer of learned counsel for the appellants, comma, the matter is adjourned till May 20, 2025 to enable the appellants to file an appropriate substitution application in the meantime. Full stop. Leave is granted to the learned advocate for the appellants to mention the substitution application to be listed along with the other pending applications on May 20, 2025 in the meantime.
One more thing.
The affidavits of service filed to be kept on record. First of it transpired that apart from the deceased respondent, comma, the other envelopes have returned with the endorsement refused, comma, which tantamounts to good service. Full stop. Accordingly, further service is not required to be effected in respect of the applications. Yes. One other thing.
Affidavit of service as regards the direction passed in earlier occasion, that is also I have filed one of such.
Affidavits, we have said.
Yes.
Affidavits of service. Yes. Covered everything. Next. So, Akji, how are you?
Carrying on.
No, why carrying on?
The affidavit of service.
What is the application for, Mr. Bakchi? This is appealing for the affidavit of service.
Restoration.
Oh.
144.
Good service effected.
Yes, my lord, kindly comes to page 9 and 10. I had written to the postal department, they had informed me
What have they informed you?
that it has been delivered. And I have also sent another, that has also been delivered. Kindly comes to page 9, my lord, that is the report of the
track report. No, the dismissal took place on page 18, this 6th of August.
6th of August 2024.
In any event, Order 9 Rule 4 principle applies. You need not serve on the other side also.
My lord,
Because they were also not present, we will consider this good service.
other side, ওরাও appear করেন।
Other side didn't appear.
Was there any connected?
Pending application appeal has been dismissed.
No, we will restore, but Mr. Bakshi, what are
And
the
second, my lord,
other applications
we have
pending at that
paid
point?
the entire amount.
No, what is the other application? What are the other applications pending at that point?
Injunction.
In that injunction application, pending injunction appeal was dismissed.
Oh, there was a delay. What is the delay?
Therefore, my lord,
144 days.
first application will come.
No, Mr. Bakshi, what is the explanation for the delay?
144 days.
144 days.
What is the explanation for that?
Explanation, my lord,
Page
my
6.
friend's mother was ill.
No, my lord, it was Batshorik of my mother. So I missed it.
Your
6 and 7 months of state.
affidavit of service filed to be kept on record. Full stop. We find from the records that the appeal was dismissed for default on a day when the connected applications were to be taken up. Full stop. Next para. we further find from the amendments made in the applications bearing Can 4 of 2025 and Can 3 of 2025 that sufficient explanation for the absence of the appellant on the relevant date as well as the delay in preferring the present applications have been furnished, full stop. Accordingly, Can 4 of 2025 is allowed, comma, thereby condoning the delay in filing Can 3 of 2025, full stop. Can 3 of 2025 is also allowed, comma, thereby recalling the order dated August 6, 2024, passed in FMA number 2886 of 2016 and restoring the said appeal along with the connected applications which were pending at that juncture to their original file and number. Full stop. Next para. The appeal was never admitted.
Yes, yes,
Appeal was admitted.
conditional stay was given.
My lord,
And
we have on the condition that entire consideration money is to be deposited, we have.
And you have deposited. Very good. The other, what were the other applications pending? Tell us that.
Application for injunction.
Number. Can
Canvas old number is 6224 of 2016.
Acha, new number?
New number 1.
1 of 2016.
It will be 1.
You're not sure.
No, I'm sure it is 1. 2 was a modification that was filed.
Modification was also pending.
Also allowed. We prayed for extension of
No. What application revives now? Only the
only
injunction.
the application for injunction.
That was still pending when it
Yes,
was
yes,
dismissed.
yes.
Already disposed.
Application. The Can 6224 was disposed of.
By the order date is 25th July 2016.
By the very first order, it was disposed of.
No, my lord.
No. The disposal of the application.
No, my lord.
Can 1 of 2016 within bracket old number Can 6224 of 2016 shall be listed tomorrow. When will you come next? Whenever you come next.
No, you do.
You do it. Listed tomorrow under the appropriate heading. Can tak yete diye deben. Apne application heading can we want. Thank you. Next. Yes, 9.
9, my lord, I'm appearing for the appellant, my lord.
I am for the respondent number 1 and 2.
Who is the petitioner?
I am for respondent number 7 to 11, my lord.
My lord,
You are for
my
1 to
application.
1 and 2. Respondent number 1 and 2.
What about 4 to 6? 3 to 6?
My lord, as per your lordship direction, I have already served, my lord. Kindly come to the previous order, my lord.
No, affidavit of service you have filed.
My lord, along with this, I have given as per your lordship, the service would have been made from the department, and that has been made, and I have already submitted the report that has been submitted along in the department. My lord, once my lord kindly come to page 18 of the application, today's application, my lord.
Yes.
Someone has been served.
Yes.
The department.
Yes.
And my lord, just the previous page, as per your lordship direction, I have make the payment for service.
Special messenger cost has been done.
Special messenger.
What do you want now?
Now, my lord, till my lord, the order was till 31st of March. Till that date, or record has not came. Thereafter, my lord, record has came to this court as per the department report 29/4/25.
You have filed this application for getting copies of the exhibited documents.
Exhibited document as well as stay of the proceedings of the court.
Extension of interim order.
So you have to serve on the other parties also.
My lord, I have served.
They are not all. 1, 2,
1
and
and
7 to something.
Yes.
7 to 11.
7 to 11.
My lord, as per your lordship direction, I have already served.
Just deduct the as per your lordship from your submissions every time.
I'm praying for apology, my lord.
Less lordship, the better. Yes.
I have already served them.
Yes.
As per page 18, I have already served them.
As per page 18, you have already served them a copy of this application. You are retain your original self.
The three things I have served. One, the memo of the appeal.
We want only one thing. This application for appropriate order and extension you are wanting, this application has been served on all the respondents.
No.
Serve on the rest of the respondents. They are
lord.
entitled to a copy. Because if it was only for this granting you permission to take the exhibits, we could have allowed it. But you are wanting an extension of an interim order also.
My lord,
Stay is already subsisting now.
stay was till 31st April.
Expired.
And
31st April of which year?
30th April, sorry, 30th April. And this application was
Even
filed
leap years
previous to
don't
that.
leap so high.
And previous to
So
that,
30th
this-
April of which year? This year.
this year.
Then
And,
we'll extend that for a limited period, but
and this application was filed previous to that.
they had appeared on the last occasion, the other respondents.
No, my lord. My lord,
You
They
had
never-
served, you have
they
served a
never-
copy of the original application on them.
My
my
lord.
lord,
will
interim order
extend it.
expired, my lord, 31st March 2025.
What is the nature of the interim order?
My lord, the interim order needs to be extended, my lord, because we are the only respondents in the second suit, my lord.
No, what is the nature of the decree?
My lord, decree, there is
What has
two
been
suit.
stayed?
There is two suit. With regard to one property, my client has filed a suit for declaration.
Oh, a title suit has been stayed.
My lord,
Yes, my lord, my suit has
lord.
been stayed.
That is consequential with this.
my lord.
Your suit has been stayed.
My suit has.
Then you are present, we'll extend the stay. We'll dispose
lord.
of that interlocutory application for stay is still pending.
No, my lord.
Or the stay application was disposed of and a limited stay granted.
Yes.
My lord.
Acha. We'll extend it till the disposal of the appeal, Mr.
No, my lord, because of that,
My lord, kindly.
Again,
My
this
lord,
will happen.
My
No,
lord,
my lord,
kindly,
because of
kindly
that,
does
we will
this,
not
my
take
lord.
any further steps, my lord. Problem is that.
My lord, kindly does this, my
And
lord.
extend for a limited period, my lord. In the meantime, all.
What
directions
about the
should
appeal?
be-
The appeal is otherwise ready for hearing.
My lord,
lord,
paper book, I have not been able to
Lordship-
prepare the paper books because,
We'll direct them to prepare the paper. You prepare the paper.
my lord,
You
that-
bear the expenses, you prepare the paper book, those will contain all the exhibits.
My lord, and that
My
will
lord-
not prejudice
No, the
claim.
records have come.
No, my lord.
just the report has been, as per report, my lord, I show you.
Give us half a second. If the records come, you will automatically be able to prepare the paper books. Those will be incorporated in the paper books automatically.
Yes, my
What is the use of your being directed to get certified copies of those exhibits? Those will be a part of the paper book. We'll direct the paper books. You have been directed to prepare the paper books. When,
I
it,
have been
all right.
when the
directed.
records come, you'll get the paper books. From those exhibits only, the paper books will be
Yes,
prepared.
Prepared by the department, if that has been.
Whatever was the direction given to you, you know very well. Even if you direct informal paper books, there are some people, some set of people who prepare those paper books. They take the inspection and they prepare the paper books. You are to prepare the paper books. You comply with that. If the records have not come, you have put in special messenger costs. Let the records come and you will prepare the paper books. We'll dispose of this application. We'll only extend the interim order for a limited period.
And
Yes,
my
my
lord, my lord, why
That
I
limited
have-
period will be very long.
my lord, I have not been, why I have not been able to prepare, my lord, they are the defendant in the learned court will. They have taken away their originals exhibited copy.
No, you have not yet deposited those originals. Those have to be deposited.
Not yet, my lord.
You are 7 to 11 took back.
7 to
We'll
11.
direct you immediately to redeposit those.
My lord.
Otherwise, the
Unless
records will not
that
become.
has been deposited, I cannot.
That
get
is the
the-
only submission you should have made before.
My lord.
Oh. It transpires that the respondent number 7 to 11 had taken back certain original exhibits which were part of the trial court records. Full stop. The records are before this court.
Record has came
Full stop.
Data
Although
was-
the
data was-
29/4/2000.
although the records have already arrived before this court, comma, the appeal is not being able to be made ready for hearing due to such reason. Full stop. Hence, comma, we direct the respondent number 7 to 11 to furnish the original exhibits which were taken back by the said respondents within a week. Here, Mr.
Yashraj Roy.
Mr. Rai, within a week, can you do it?
My
I'll
lord,
give you a fortnight. We'll give you a fortnight.
2 weeks, my
We'll
lord.
give you a
Also, his
Also,
document
he's
is
also-
also there. Hmm.
Yes, my lord. If my client also. would do
This
the same-
piecemeal sort of submission we don't understand. Why didn't you say at the inception that all of them have taken back paper? You pointed at him. I asked you whether he has anyway. Respondent number 7 to 11 যেখানে বলেছি সেখানে শুধু রেসপন্ডেন্টস করে দাও
দিয়ে দিয়েছি।
কোনখানটা হ্যাঁ যেখানে যেখানে রেসপন্ডেন্ট বলেছি সেখানে সেখানে রেসপন্ডেন্টস করে কোথায় ছাড়লাম একটু জায়গাটা respondents shall furnish the original exhibits which are taken back by the respondents and were a part of the trial court records within a fortnight from date. Full stop. Next para. Upon such exhibits being deposited with the office, comma, the office shall furnish a revised report in that regard. Full stop. Next para. Since directions have already been passed on the appellant to prepare the requisite number of paper books, comma, we are not repeating the same. Full stop. Upon the the appellant shall comply with the same as per previous directions. Full stop. Next para. The interim order of stay granted earlier is extended till August 31, 2025 and or until further orders, whichever is earlier. Full stop. Liberty to the parties to mention the appeal for hearing as and when the same is ready for such hearing. প্রথমেই করে দেয় affidavit of service filed to be kept on record. আরেকটা লাইন অ্যাড করে can 3 of 2025 is disposed of in the light of the above observations without any orders to cost. Grateful, Your Lordship. Prepare the paper books quickly so that the appeal is.
My lord, whenever I get the certified copy, I immediately prepare.
You don't require a certified copy. Grateful, Your Lordship.
Grateful, my lord.
Thank you. Next.
I'm appearing on behalf of the respondent number 4, Your Lordship.
4 only. What about the other respondents?
Sir, I appear on
The others.
of the other.
Very good. Yes, Mr. Toll, what is the matter?
This is an application, my lord, for stay, my lord. Now, my lord, my partition suit has been dismissed.
Partition should have dismissed. What is the scope of stay? You know, Mr. Dole, you are filing this sort of application, nothing to say.
My lord,
Will impose 1 rupee cost on you personally. Or to T, whichever is lesser.
For my lord, direction, my lord, for preparing the paper book.
Will do it. Since the appeal has been preferred against the dismissal of a partition suit, comma, there is no scope of grant of stay. Full stop. Accordingly, we dispose of what is the new number?
This canny is
Can 1.
Can 1 of 20. Accordingly, can 1 of 2019 within bracket old number.
7847 I find.
Please, Mr. Bhattacharya. Accordingly, can 1 of 2019 within bracket old number can 7847 of 2019 is disposed of by directing with a direction that the trial court records be brought by special messenger at the cost of the appellant. Full stop. Such cost shall be deposited within a week from date. Full stop.
Let it be 2 weeks, my lord.
Very well. Within a fortnight from date. Within a fortnight from date. Full stop. In view of appearance of all the respondents through their respective learned advocates, comma, service of notice of the appeal on the respondents is dispensed with. Full stop. The appellant shall also prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. No orders to cost.
Only one thing.
Yes, Mr. Lord.
My lord, may I take the responsibility of preparing the paper book? দেখ তুই করতে পারবি কি?
Yes, he'll do it. If he doesn't prepare within time, then the mention will will keep it as to be mentioned and pass it.
Right. If your lordship passes that.
Whenever, if we are there, if he fails to prepare the paper books, we'll do it. We'll direct you. Yes. Yes. 11. What is the advocate on record in 11? You are for the respondent.
I'm for the respondent, but this is my.
What is the advocate on record for the appellant?
Advocate on record has here been appointed, my lord. There's 7 days time, lord, for the execution of the Vokalatnama, new Vokalatnama, because lord, they reside at different places. Your lordship kindly grant some time.
Fair enough, Mr. Mukherjee. Your application.
My application.
What is the application for?
My lord, the application is this appeal arises out of a probate. Probate has been granted.
Right.
And the testatrix had wished her entire property, especially the immovable property, to be given to university.
Opening house inventory, this will abide by whatever happens in the appeal, that will be.
My lord,
the appeal is otherwise ready for hearing, no?
No, my lord, the direction was given in 2019.
Records have not come, original will has not come in spite of, kindly see the order sheet, repeated request by the registrar.
Because the house is now closed, it's a palatial house. Property has been given to University of Calcutta for setting up a law college. The house is not being opened for the last 23-24 years. We do not know. We are unable to maintain the house. And the executrix has expired. Another executor has stepped into her shoes. Now, while the movable assets details have been available, but immovable assets required to be protected. That's why I prayed that the house property be opened under the aegis of officer appointed by lordship. And all sides may be represented when the inventorizing is done in the property.
An adjournment of a week is sought on behalf of the appellant in order to engage a new learned advocate on record, which has been necessitated due to the elevation of the erstwhile learned advocate on record. Full stop. We keep on record the affidavit of service filed by the respondent stroke petitioner. Full stop. We find from the office report dated February 24, 2025, that despite repeated reminders, the rectified trial court records and stroke or the original will have not been sent from the trial court. Full stop. We accordingly direct the learned district judge, South 24 Parganas, to hold an inquiry and furnish a report in writing as to the whereabouts of the trial court records and the original will in connection with the present case. Full stop. Simultaneously, the learned district judge shall also ensure that the said records and the original will are sent to this court at the earliest. Full stop. Such report shall be furnished within a fortnight from receipt of a communication of this order to the learned district judge, South 24 Parganas. Full stop. The office shall communicate this order immediately to the said learned district judge. Full stop. Next para. Upon the report being furnished and stroke or the trial court records along with the will arriving before this court, whichever is earlier, the office shall furnish a report in that regard. Full stop. The matter be placed under the heading to be mentioned before us on June 10, 2025 for passing further orders. Let it appear before us. We'll resolve this issue first then. In the meantime, Mr. Ghosh, please ensure that the vocal bench. Let it come as to be mentioned. We'll pass necessary orders and then take care of these applications. This application will not be required if we get the records.
Yes, and the appeal is hard out. Otherwise, the property is getting wasted.
Yes, yes, we absolutely appreciate, Mr. Mukherjee. Next.
Lordship, I'm mapping for the applicant.
Yes, please.
Lordship, there was a direction for serving the copy of the applications upon the respondents.
Yes.
That has been served, your Lordship. Only one of the respondents, it was found that addressee was not located at that particular address, my lord. It has returned back. Apart from that, remaining was there were two applications. One being CAN 5 and CAN 6. This CAN 5 was for Order 41, Rule 27, and Lordships were of the view that this would be heard during the time of the hearing itself. Now, Lordship, Order 6 was, CAN 6 was filed since there was
the person who has not been served was represented in the court below. But they are the plaintiffs in the court.
She is the legal heir of the person who was appearing before the suit. May I once again serve upon this particular respondent because
which respondent with the number?
Not mine.
Is Rashida Begum?
No, my lord. Lordship, this one KH Hoyt.
Substitution was effected already. Affidavit of service filed today be kept on record. Full stop. Learned counsel appearing for the appellant, in his usual fairness, submits that he may be permitted to serve afresh on the unserved respondent, that is respondent number 1 within bracket KHA. Full stop. Accordingly, we direct the petitioner to serve a copy of the application afresh on respondent number 1 Kha and file a further affidavit of service on the returnable date. Full stop. Should we give you a fortnight's time for that? The matter be listed next on May 20, 2025 under the same heading.
Grateful.
Thank you.
I will come then.
Please. Next.
My lord, in this matter, may I seek indulgence to appear online, lordship?
Yes, yes. What is that?
Lordship, the defects were removed in the month of August 2019, lordship. But since it is appearing marked defective, I'm submitting about defects first, lordship.
We'll just check up the, yes, you are right. Defects were removed. So We'll
Yes,
clarify
Lordship.
that. We'll clarify that. What is the application about, Ms. Gutgutia?
Lordship, there was an winding up proceedings and two vital documents.
No, this is a section
we-
5. This is a section 5.
Lordship, I have to check that. May I come back tomorrow, Lordship?
Come back tomorrow.
I'll check the defects as well.
No, we'll record that there is no defect.
Grateful, Lordship. Grateful, Lordship.
No, defective out of time. That is the endorsement. Defective out of time means because the section 5 is there, that defect does not remain.
Other defects have been removed.
Other defects have been removed. The marking in
what
the
will
list
time,
is
Lordship?
defective out of time. So there is no difficulty on that. On the prayer of
Lordship.
learned counsel for the appellant, the matter is adjourned for till tomorrow, Ms. Gutgutia.
Then if I have to file section 5, then Lordship, at least 3 days, Lordship.
You have filed a section 5. You are on change in this matter.
Yes, Lordship. Earlier
Oh.
the
Section 5 is with us.
Lordship. Then may I submit for condonation of delay, Lordship?
No, you have to move the application, Ms. Gutgutia, not as a matter of right.
Lordship,
You're-
I'm praying, Lordship. Lordship, I'm praying.
No, we have to be satisfied on the grounds. If you are not posted with your papers, please collect your papers and come back tomorrow. We'll keep it tomorrow.
Lordship, deeply
On the
grateful, Lordship.
prayer of the learned advocate for the appellant, the matter is adjourned for the day. Next.
Grateful, Lordship.
Thank you. 14 to 16, yes.
I am appearing yesterday.
Yes.
Matter, I am for the respondent.
Right.
বলুন আপনারা ফির বলুন কি বলুন আপনি বলবেন না আমি বলবো সাবস্টিটিউশন আরো অন্য ব্যাপার সেকশন 5 ও তো আছে বলুন আপনার সেকশন 5 আমার করে অ্যাপিল তো আপনার
Can 4 is not with us.
can 4 is but it will not be necessary because this can 4 is for substitution. Initially we filed the application for substitution on the date of the respondent. Now, after that, my learned friend, the state has filed the application for substitution. That has been allowed yesterday. The rest of these things, I am submitting very lawsuit. Kindly consider this act. Number 19 reference cases were disposed of. Number against this government preferred 19 appeal in this honorable court.
Right.
Number out of 19, in 16 appeals, this court directed you deposit rupees 5,000 for condonation of delay within certain period. And
that.
Yeah, and mirror the
They did not deposit, so it was.
Stage concerned, they are directed to deposit the decretal amount, entire decretal amount. These are the orders passed on the.
Those appeals we have held to be honest because they did not deposit.
Yeah, no, they don't have. They come up with an application for condonation of delay after 3 years.
অন্য appeal গুলো আমরা
অর্ডারটা ফাইলে আছে একটু দিন তো অর্ডার গুলো ফাইলে দিয়েছিলাম
এটার কথা বলছি না অন্যগুলোর কথা বলছি
after 3 years they approach your lordships dismiss those 60.
We remember, but this matter, this section 5 has not yet been heard.
So what I am submitting, let the section let the delay be condoned, but so far as the main appeals are concerned, what order can be passed because 16 appeals have been dismissed. No conflicting order can be passed in this appeal. So what I am submitting.
No, Mr. Bira, there may be some dispute on that. Those appeals were not dismissed on merits. Those were held to be non-est as time barred. So there was no adjudication by the appellate court at any point of time. We'll have to hear Mr. Dotto and adjudicate on merits these appeals.
No problem. But ultimately
the point may be the same. Those appellants, those people will get the benefit, but you won't get the benefit because there was no adjudication on merits.
No adjudication on merit. But ultimately, on those appeals, trial court order has been affirmed.
Yes.
Valuation has been affirmed.
Right.
This is not a different type of cases. If the valuation is affirmed in other appeals, how
it has not been affirmed. We have dispute there. It has not been affirmed. It was held by the reference court in a particular manner. We have to look into that.
Your lordship,
That is where there is no merger.
No.
Because there is you know better.
Question of merger doesn't arise only.
So therefore, there is no question of affirmation.
Affirmation, and in any case, valuation
will independently decide in this appeal. Section 5, what is the delay, Mr. Dotto?
3 months.
We'll condone the delay without. Again, they'll not deposit again.
No, I am not asking for same time within such delay may be condoned. Then your rest of the things I submitted, but your losses.
Or should we take a chance, Mr. Bera? We also make it conditional like the previous ones. Again, if they don't deposit, then this conundrum will not arise. We don't have to decide the appeal. we save ourselves some work,
Yes, yes.
and Mr. Dotto and you also save yourself the appeal.
Yes, yes, yes. Your lordship finally passed that kind of order.
Yes, Mr. Dotto, what was the cost? 5,000 in which year?
5,000 cost my lord.
When was it awarded?
It was about 3 years ago.
3 years ago. So we should add something to that 10,000. Public money, you will be nodding your head.
This amount.
We'll be paying for that
But
amount
that was-
also.
That was
This
passed
amount will
on.
be utilized
That
for
order was passed
welfare
on.
of the child, my lord, in the collection and home, my lord.
Yes. But that was.
Welfare of the child because of these
No,
things.
no, your lordship enhance that amount to 10,000.
No, very well. Section. What is the delay? The procedural delay.
Think about
What is the
3 months.
reason of the delay? Procedure. Your internal procedure.
According to their prayer.
Can one is delay? Mr. Vera, we are allowing the application without any condition. We'll take up the stay application and pass the necessary directions. We are allowing the section 5 application. So that will take care of many things. In any event, they will have to deposit the awarded amount.
Yes, ma'am.
I leave it to your lordship.
What is the stay application number? Do we have it?
Yes, application number. Old number it has been given to us.
Acha, this can 10923. This was for accepting the memorandum annexing photocopy of judgment dated such and such.
Yes.
With original certificate. After dispensing with filing of original certified copy of common judgment. This was allowed.
No, no,
No, no.
We'll allow this also.
Yes, yes, yes.
We're allowing this.
And so far as can 4 is concerned, kindly note it need not be pressed because substitution has been.
Can 4 টা আনি নিন না। চাইলে তো হবে না। না দিলে তো চলবে, রিভার্স দিচ্ছে না আবার।
Can 4? Can 4 টা আছে? দেখি।
So can 1 is the section 5 application? First,
Your lordship, I am handing over copy of the can 4.
we'll keep it on record then. Give 1 copy at least. I will give that on.
I am giving.
2 copies if you have, then it's. Thank you very much.
দুটো করে কপি আছে তো? 3টে মামলায় দিয়ে দাও। আর এটা can 4 এইতে দুটো আছে। এটা 495 আর ওটা।
হ্যাঁ থাক, দুজন থাক, ওটা আসুক।
ঠিক আছে।
Let us go one by one. Can 4, then we are first holding. It has become infructuous because of the learned counsel appearing for the referring claimants submits that can 4 of 2022 filed by the said claimants has been rendered infructuous. First up, can 4 of 2020 was an application for substitution of the heirs and legal representatives of the sole deceased respondent Karthik Hazra, first up, in view of a similar application at the behest of the state having already been allowed, we find that can 4 of 2024 has been rendered infructuous. First up, since the original application is not with the records at present, learned counsel for the referring claimant is gracious enough to hand over 2 copies of the said application, which we treat to be the originals. First up, can 4 of 2022 is accordingly disposed of as infructuous without any orders to cost. First up, can 1 of 2019 within bracket old number can 10698 of 2019 is an application for condonation of delay in preferring the appeal. First up, upon a perusal of the averments made therein and hearing learned counsel for the parties, we find that sufficient explanation has been furnished for the delay. Accordingly, can 1 of 2019 within bracket old number can 10698 of 2019 is allowed on contest, thereby condoning the delay in preferring the appeal. The numbers are same in all the appeals? No.
No, the appeal number.
This is with regard to FAT 490 of 2019.
490, I think.
What about the can numbers in the others?
490? না,
এটা 490 রেসপেক্টে অর্ডারটা করো। নেক্সট প্যারা
দিলাম 490
হ্যাঁ ঠিক আছে। Then application for stay is also there.
1093 টা কোথায়? 1093 হ্যাঁ আছে। Can 2. Can 2 of 2019 is an application for dispensation of filing of the original certified copy of the impugned common judgment passed in case number LA1 to 19 of 2018. First up, since such original has already been filed with in connection with other connected appeals, can 2 of 19 is allowed, can 2 of 2019 within bracket old number can 10923 of 2019 is allowed, thereby dispensing with the filing of the original certified copy of the impugned common judgment in case number LA1 of LA1 to 19 of 2018. No order as to cost. দুটো হলো, তিনটে হলো, can 4, 1 or 2. What is the stay application number?
Can 3. Can 3, it is old number 101850. Old number can 1850.
Can 1, very good. We are passing the usual order, Mr. Datto?
Yes.
Yes. Can 3 of 2020 within bracket old number can 1850 of 2020 has been filed for praying for stay of operation of the impugned enhancement award. Full stop. Next para. Upon hearing learned counsel for the parties, comma, we find that unless the said application is allowed, comma, the appeal may be rendered infructuous. Full stop. Accordingly, can 3 of 2020 within bracket old number can 1850 of 2020 is allowed on contest, comma, thereby granting stay of operation of the impugned award till disposal of the appeal, subject to the appellant depositing the awarded the impugned awarded amount with the learned registrar general of this court within 4 weeks from date.
Instead of 4 weeks, 8 weeks.
By the end of June, within June 30, 2025.
One thing we added here, for calculating interest up to June, otherwise, if the land calculated.
So it is made clear that the said amount shall include the interest calculated up to the date of deposit.
Yes. May I play one thing? You already extend some. This amount will be after calculation. Getting will be done by the
Very well, July 15. Date July, June 2030 না করে July 15, 2025. তারপরে সেন্টেন্স যেটা বললাম, include the interest calculated till date of deposit. Next para, there shall be unconditional stay in terms of the above order till July 15, 2025. Full stop. Thereafter, comma, upon the deposit being made, comma, the stay shall be deemed to stand extended till disposal of the appeal. Full stop. In the event of in the event of default in such payment, comma, the stay order shall stand automatically vacated without further reference to the court. Full stop. As and when such amount is deposited, comma, the learned registrar general shall invest the same in a short-term interest-bearing account with any nationalized bank and furnish the particulars thereof to the learned advocates for the parties, if so approached. Full stop. Such deposit shall abide by the outcome of the present appeal. No orders to cost.
May I be permitted to withdraw some certain percentage of the
50%, Mr.
Yes, that is the usual order. You kindly pass.
Very well.
In the earlier cases, your lordship.
But you will get the entire amount when you get it, Mr. Vera. What is the use of you have already got the.
If they deposit, ultimately appeal will take some time to dispose.
No, sure. It will be in the short. Let it. No such order at this point of time. Not right.
Only one sentence.
If they win the appeal, then it goes.
One thing your lordship kindly inform, but this is my duty. Section 5, your lordship allowed. Yeah, I have to deposit the. Allowing the section 5.
Without cost. Without.
Your lordship.
You're not happy with. We can modify your.
At least
no, we are trying to avoid that thing again. I mean, because
only one sentence.
What sentence?
Direction for paper books may be given. We are happy.
You're right.
And one thing, if not deposited, liberty to proceed with the execution. Kindly add that.
No. The stay will stand automatically vacated. That means you can do that. In view of the appearance of the respondents to their learned advocate, comma, service of notice of the appeal on the respondents is dispensed with. Full stop. The appellant, the trial court record shall be brought by special messenger at the cost of the appellant, comma, to be deposited by 4 weeks from date. Full stop. The appellant shall prepare and file the requisite number of informal paper books within 8 weeks from the date of within 8 weeks to 10 weeks state. Within 10 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Full stop. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. Now, Mr.
I think
Mr. Haldar, you will have to do it.
Not appear.
You will have to do what we are telling you. In the other appeals, please give the corresponding numbers and just write. There are 4 sets of applications. Can 4 is same, number is same for all?
Number is same for all.
Acha,
I am filing 2 copies in each of the next 2 applications.
thank you so much. Thank you so much. Do that.
495.
That will be done. Acha.
501. Same order may be passed so far as.
And
4 is
can
concerned.
1, 2, whether those numbers correspond, the old numbers will not correspond. So you will have to make a list in the other cases. Just take down, if you can take down on a slip of paper. One is section 5, other is stay. What else have you allowed? That dispensation of filing of original.
3 applications.
3 applications. Those corresponding numbers and the old numbers,
Old
please
number
give
and present number.
old number and present number, and just write the number of the appeal.
All right.
Please give it to our officer as soon as possible.
In course of this day, my lord.
In course of this, make it as early as possible. Otherwise, this order will take.
In course of this day.
Not in course of this day, before recess.
I have to.
Mr. Halder is there. He'll go with you.
No.
Hindu carries the law.
No. The file is, my lord, in the chamber, my lord. We have to go to chamber.
You can go through the file of the court.
They can.
Or engage somebody, some sub-junior.
They can.
You are saving on sub-juniors and then you have to take the trouble. You are earning sufficiently from the state, so you have to keep sub-juniors now.
What earning?
If you save on that, then you have to spend time on this. Please do it. না ওটা বলবেন ওটা স্টেট ফেট সব আচ্ছা সবকটা দিয়ে একটা ক্যান ফোরটা একই হবে সব আর বাকিগুলো উনি নাম্বার করেসপন্ডিং নাম্বারগুলো দিয়ে
One thing
Yeah.
I have already submitting.
In
each of the appeal, we have also filed cross-objection claiming higher valuation. So, my lord, those I'll have to prepare the paper book for the
We'll
paper.
put something in.
Yes.
You'll just serve the copy of memo to them. আচ্ছা আরেকটা যেখানে prepare the requisite number of paper books যেখানটা বলেছি ওখানটা অ্যাড করে paper books, incorporating the copy of the memorandum of cross objection filed in connection therewith. আচ্ছা আরেকটা সেন্টেন্স ওই ফুল স্টপটার পরে অ্যাড করে দাও.
We have not received the copy.
Just finish our order, Mr. Datta. You quarrel outside to your heart's
No, I am
content.
not quarreling.
To your heart's content. Let us complete this order first, then do whatever you like. Full stop দিয়ে তারপর একটা লাইন অ্যাড করে দাও. For such purpose, the learned advocate for the respondent shall hand over a copy of the memorandum of the cross objection to his counterpart appearing for the appellant by tomorrow.
Yes.
By tomorrow.
Next.
এই নাম্বারগুলো এই যে নামগুলো কি বড় বড় লোকেরা ঝগড়া করবে
Yes.
But some your lordship is perfectly right. In merit, value may be reduced or higher,
Yes.
etc. It may be, but generally there is no scope because it
Very
is a
little
question
scope.
of valuation.
Very
That I will argue at the time of final.
Yes, very
No
little
problem.
scope. You are the authority, you know better.
No.
You and Mr. Datta also. The application. দাঁড়ান শুনেছি 17 তো ফাইল দিয়েছেন তা দেখতে দিন cost settle of the memo এখানে ডিফেক্ট একটা রয়েছে cost settle of the memo কপি লিখে সেটা দেখুন সেকেন্ড মারা গেছে আফটার জাজমেন্ট ও
after pronouncement of it.
তাহলে তো কিছু রটিনেস 12 আছে হেয়ার দিয়ে রয়েছে কিন্তু কোনো অ্যাপ্লিকেশন করেন
But no application.
None appears at the time of call for either of the parties. Full stop. We find from the report of the stamped reporter that although the defendant number 11 in the trial court had died after the pronouncement of the impugned judgment and decree, and his heirs have been brought in by impleading them as respondent numbers 12 small a to 12 small c in the memorandum of the appeal, no application for leave to prefer appeal against the said respondents have been taken out by the appellants. Full stop. The appellant is directed to file appropriate application in that regard within a fortnight from date. Full stop. Liberty to the appellant to mention such application to be enlisted along with Can 1 of 2021 in the meantime. Full stop. Next para. Can 1 of 2021 shall next be listed for hearing in the monthly list of June 2025.
Before that, subject to
18.
pardon me, Mirror.
Yes, Mr. Vera, let us get over with this matter. Yes.
The only thing I may be mistaken whether I have filed for objection or not. Kindly pardon me, Mirror. If not,
Mr. Vera, if you, I mean, after the order is passed, this is not done. We have to proceed with because you are mentioning appeals for hearing every day for inclusion in the list. And if you disturb in the middle of every matter, then we cannot go ahead. We have to do some work. Not be obsessed with your cross objection and your non-filing of these things and that things. If you have not filed, please mention. Just check up and mention. Why did you mention then? Cross objection to comma if any kore dio. Yes, 18 dekhecho. 18 the same hobe naki 18 condonation করেছে স্টে করেছে কি বলি বলুন তো ক্যান 3 এটা একটা আছে
But no application for certificate.
সেম প্রবলেম কি দেখে নিয়ে একবার একই তো পার্টিদের এগেইনস্ট
Not in order dated start on
যা আগেরটা বললাম সেম অর্ডার হবে তার সঙ্গে একটা অ্যাড করে দাও the learned advocate for the appellant is also directed to furnish a certified copy of the commissioner's report filed in the court below on the next date of hearing. আর যেখানে ক্যান 1 of 2023 বললাম শুধু লাস্ট রিটার্নেবল ডেট টার্গেটটা যেটা বলেছি ক্যান 1 of 2021 এই ক্ষেত্রে হবে শুধু ওই সেন্টেন্সটা along with can 2 of 2021 and can 3 of 2023 returnable date. Next. Cross objection টা if any করে দিও Yes, 19.
My lord, kindly recall that 29 applications, that means 58 number of application. I have, my lord, draft has been prepared. My lord, now it is to be filed. My lord, kindly give us, my lord, 1 week time.
What application?
Because application, so far, memorandum of appeal is concerned, my lord, it was filed long back. But my lord,
application for what?
Application at one section 5 and another stay. My lord, that means 29 applicant appeal to be added.
And why did you mention the matter?
My lord was kind enough to make
We
an
had directed.
observation that you just mention when the matter will be taken up, and I will pass an order because, my lord, the 29 applications so far draft is concerned, my lord, that means 58, my lord, in numbers, one section 5 and one stay application. So, my lord, now, my lord, it is finally prepared and, my lord, it is to be affirmed.
Then
my
why
lord,
did you
it has to
mention
be-
it before
has to be-
filing it? We had granted you leave to mention.
Yes, mention, no.
It was not mentioned automatically.
Not mentioned.
Not mentioned.
Let
But, my
me
lord,
back-
we'll point out.
Since no application for condonation of delay has been filed, comma, let the matter.
Regarding 79 application, appeal, my lord, because it is-
79 we are not concerned. We are only taking up
Yes.
one. Since no application for condonation of delay has been taken out, comma, let the matter go out of the list with liberty to the appellant to file such an application and mention for inclusion in the list.
And, my lord,
Thereafter.
my lord, application.
State also has filed appeal. The 29 appeals. We are the private response. We are the affected manner. Let all this matter appear, manner. 29 appeals are of the.
Along with this.
First, let them file this condonation application. When we condone that, we will
Condonation
direct
and stay.
analogous hearing of all.
Condonation as well as stay application.
Stay, we are not granting you any leave. Without the section 5, we can't.
Yes,
You will also kindly take the trouble to produce the order on 21st.
We have seen that, Mr. Patil. After seeing that, only we pass this order.
My appeal is also there. Then I will be in trouble. This is my appeal. This is my appeal.
We cannot pass any order in your appeal unless we take up their section 5 application. We cannot direct. We can pass directions to file paper books. Then there won't be any analogous hearing, Mr. Panja.
Yes.
We are only allowing them to file their section 5 so that we can take up the section 5 and pass directions for analogous hearing of all the appeals. That is the purpose behind this. Yes.
Then, Milord, execution case.
You go on if there is no stay.
Up to 20, sir, up to 20.
My lord, already
Without
granted stay.
disbursement, how can it be? No.
Next.
Obliged.
Yes.
Given also.
Yes, Mr. Court.
No. Lord, first I apologize. Your lordships for not being present.
Apology accepted, Mr. Court. Please, what is the
Lord,
matter?
yesterday I came late, my lord. That's why I could not.
Not only you came late, Mr. Roy also came late. That is the difficulty.
Lord,
That was the reason why last chance was you.
Lord, it's my
Not only
apology.
you, Mr. Roy also came late. Mr. Banerjee came in right time. If Mr. Roy was in time, we wouldn't have given a last chance. Mr. Kaur, what is the matter? No difficulty.
Lord, I had filed a suit
Yes.
for specific performance of a contract for purchase of a property. The property is at,
Mr. Kaur, the suit has been dismissed.
suit has been dismissed.
This is an application for stay or alternatively injunction.
Yes.
Stay we are not granting, there is no scope because the suit has been dismissed. Injunction, why not?
Two objections, my lord. First is, my lord,
Let us take their objection first as a matter of
Lord,
default.
I will only address your lordship for 5 minutes. The ground for dismissal.
Acha, very well. Let us hear you first.
Lord, I'll not take more than 5
No,
minutes.
please take your time. Yes. What is it?
The ground for dismissal is that the agreement for sale is not registered. Lord, for the first time, I am coming to know that an agreement for sale requires to be registered in view of section 54 of the
What about section 17(1)(b), Mr. Court?
17
Registration Act. Registration Act. Not under the Transfer of Property Act.
No, my lord, Registration Act.
17(1)(b).
17(1)(b).
Mr. Banerjee, B.
Yes, my lord.
Mr. Court, please address us on that.
Very well, my lord. Lordship will. No. Registration Act now.
Junior Mr. Court, you should have brought your generation's book. Because there are certain amendments in the interregnum.
My lord, may I read from the other non-testamentary instruments?
Mr. Court, this is the amended Registration Act.
Yes, my lord. Other non-testamentary instruments.
Registration Act din.
Registration Act though?
No, we have. Just request to be found out. Alphabetically शायद কোনো দিন বাঁ দিকেরটা কি দেখি বাঁ দিকেরটা একদম বলে ওটা কি উপরেরটা কি
May I place the section?
Please, Mr. Court, sorry.
17(1)(b).
Yes.
Other non-testamentary instruments which purport to operate or create, declare, assign, limit, or extinguish, whether in present or in future, any right, title, or interest, whether vested or contingent, of the value of 100 rupees and upwards to or in immovable property.
So, any right, title, or interest, whether vested or contingent, whether in present or in future.
Yes.
So, why should this not be constituted to be other non-testamentary instrument which purports or operates to create in future a right, title, or interest in the property?
Basically.
Yes.
Transfer Property Act though?
No, it's not a right in presentee. Transfer Property Act definitely says section 54 is there.
Yes, Mil.
That is settled, Mr. Court. It's not a Transfer Property Act scenario. Not under that act. No right in presentee is created. Agreement
Right
for
in
sale.
the property is created.
No right in the property, no title in the property in presentee is created.
Yes.
Because section 54 proviso says
Correct.
that agreement for sale does not tantamount to a sale deed. There is no transfer of title. No.
Absolutely.
But the language of B is much more expansive. It says any right is created whether in present or in future. It purports, an agreement purports or operates to create a right in future in a property. Even if it's an actionable claim on the basis of that agreement, because you can file a suit for specific performance, which you have done. So therefore, why shouldn't that come within 17(1)(b)? That's an arguable question, Mr. Kaur, at least. So if you have made an arguable question, injunction. Yes, you are asking for those 5 minutes on this.
Yes.
Oh, we are convinced on that. You have got an arguable case. Therefore, we are going to Mr.
But
Banerjee.
there is no other point in the judge.
That is the only point. Fair enough. Yes, Mr. Banerjee, 2 points on which you object. Mr. Court, please take your seat. You'll just reply.
Point is, my lord,
Yes.
in 2005, my lord, they moved an application for injunction. The prayer for injunction in the suit court
Yes.
was refused by order dated 18th of July 2005. So 20 years back. Ground was, my lord, they have failed to show that they have paid the consideration. They paid a check from some other account which was returned by me. So earnest money was not, yes, earnest money. I said that I'll not accept this.
They
because
had
it is
paid a check from some other amount.
other
Other account.
other account which was not accepted by me because I said that consideration or earnest money has to come from the person who was entered into the agreement.
Yes.
That on that ground, my lord, the court
Injunction was
held
refused.
that there was no earnest money paid, there is no due diligence or readiness and willingness to show that you have a good case for specific performance.
Next, what is the other point?
On that ground, the stay was rejected in 2005. It was 20 years back. At finality. Now, after
At
20
finality. At interim injunction refused in a suit, at finally.
I'm saying
Great
that-
argument, Mr. Banerjee.
So far as the parties are concerned,
You'll get a
injunction-
spanking from me someday. Really good. Yes, what else?
Now, my lord, today, my lord, in the pleadings,
Yes.
no case has been made out after this rejection.
Readiness, willingness.
Readiness, willingness, my lord, for getting an injunction. Only one line that he may sell the property. After this order, because I have learned, my lord, from your lordship also that for getting an injunction, you have to
From
make
better,
a-
you have learned from better people.
that you have to make a pleading for the injunction. Kindly see the pleading. my lord.
Readiness, willingness, pleading.
Read-
That is not required anymore.
Not the-
In the pleading, it is not required.
No, in the pleading for injunction not required, but they have to show there is not a good case for getting an injunction. Prima facie case and
Why
a
do you
case-
say that? Because this is an appeal. Now, this appeal is on the point, this question, the question which has been raised by Mr. Court, 17(1)(b).
No. Apart from that, there's another. The main point is that they have failed to show that the earnest money was paid and readiness and willingness.
That is
the-
one.
Registration is one other ground, which is not the main ground on which the suit has been dismissed. Main ground is that they have failed to pay the earnest money, and also that.
So these are the 2 points.
So-
1 point is this, injunction and readiness, willingness.
And the pleadings do not show after
That-
after rejection of the injunction why after 20 years they now.
Pleadings does not show what?
What is the, my lord, immediate case made out by them for getting an injunction today? Because 20 years back, my lord, injunction was refused.
Okay.
So in this application, they have to show some pleading to get an injunction that today there is a threat to the property and it needs protection. So something, my lord, more than, my lord, kindly see, my lord, the statements, my lord, they've asked for a stay. Only one paragraph, I'll show your lordship, my lord.
Yes, only para 16.
Para 16.
Only
Only
para
one
16.
line that
May.
appearance that in view of the dismissal may try to sell the suit property. So in the, my lord, backdrop of this refusal of injunction, my lord, after 20 years, this is not sufficient pleading to get an injunction. Secondly, my lord, they have accepted the order, my lord. For 20 years, have not sold the
And
property.
it is at finality.
No. I say, my lord, that
Very good.
no case made out, my lord, for getting an injunction today. And unregistered and unstamped document. It is unstamped also. Unstamped, my lord, the document was exhibited. Later on, we raised an objection that this should not have been exhibited. That was turned down by the trial court.
36.
Because on the ground that since it has been exhibited, once it is
Section
exhibited,
36, probably.
61 is also there. But the court can at any time not take it up.
36, you are precluded from taking that point. Section 36 is it?
36 is not.
Stamp Act din, Stamp Act din. একটা ওয়েস্ট বেঙ্গল অ্যামেন্ডমেন্ট ওয়ালা স্ট্যাম্প অ্যাক্ট আনতে বলেছিলাম না?
Except in accordance with section 61, which says the collector can or the court can so.
Yes, can.
So, my lord,
We have adjudicated on that also, other appeals. That
So your lordship is not taking up the matter on an unstamped document. They're getting an injunction in the facts of the case. Whether they'll get that, my lord, because of this very strong case for getting an injunction, very strong prima facie case, your lordship will not exercise.
36 of Stamp Act says where an instrument has been admitted in evidence, such admission shall not, except as provided in section 61, be called in question at any stage of the same.
61 gives the
You
power to
cannot
the-
call in question.
But I can raise the legal issue. That the court can at any point look at the document. It's a
Yes,
legal
court
question.
can say.
Yes, so, my lord, I'm saying that unstamped, unregistered document, one. Secondly, my lord, the case for injunction has not been made out, especially in view of the background fact that, my lord, in 2005, injunction was refused.
Let Mr. Kaur answer. Yes, Mr. Kaur.
My lord, so far as Stamp Act is concerned, my lord, once a document is tendered without objection, later on it cannot be raised. Secondly, my lord, the other point is payment. Lord, here the evidence is that I have tendered the check, my check. It was not tendered, but he wanted a replacement check.
No, you gave it from somebody else's account.
No, from my account, my partnership account.
From not from your individual account, but from your partnership account.
And it was signed by both the partners, including me.
All right.
Therefore, it is not my failure. He had not encashed the check.
Very well. What about no averment being there appropriate? Because 20 years back, your injunction, you did not enjoy any injunction throughout the pendency of the suit. Now you come up in say para 16, you just say may try to sell in view of dismissal. But this
That is my
apprehension is,
apprehension.
but this apprehension only on the basis of, you have to say something that they're doing. They may, you have stated your statement we are reading. Your petitioner apprehends that in view of dismissal of the suit, respondents may try to sell. This is the only thing. You have not stated that they are trying to sell or attempting to sell. Nothing of that sort. But if you had enjoyed an injunction, Mr. Kaur, our point is this: if you had throughout enjoyed an injunction, this may would suffice because there was injunction all along. That's why they could not sell. Now dismissal, therefore. Now, since you did not ever get an injunction, so what is the scope of apprehension that they may sell due to the dismissal of the suit? How does it change?
May I answer this?
Yes.
It is property subject to list pendants now. Therefore, ordinarily, transfer would not be possible because of the list pendants. Here I am praying specifically an injunction because of the dismissal of the suit. Here they will be free to deal with the property unless there is some.
But they were free throughout during the pendency of the suit.
They were, but the list was pending, subject to the list pendants.
Here also appeal is pending.
Here, Malad again in the appeal is pending. Therefore, the list pendants is continuing.
Therefore, the same logic applies. You are refused an injunction. You did not challenge that further.
Very well, Millard, your lordship will clarify that in view of the list pendants, we are not granting an injunction.
Does that protect you in a specific reference suit, Mr. Kaur, list pendants? If it's a bona fide purchaser for value without notice, you are gone.
Millard, since the injunction has been refused.
No, Mr. Kaur, we are granting injunction, Mr. Banerjee.
For last 4 years, we have not sold, even after the decree.
No, we'll record. That's a very good objection. I mean, we were in two minds, but yes. The present appeal, arises out of the dismissal of the plaintiff appellant's suit for injunction. Full stop, next para. Learned senior counsel appearing for the appellant submits that, appellant submits that in view of the dismissal of the suit, the appellant apprehends that the respondents are making attempts to transfer the property in favor of third parties, which would cause irreparable injury to the appellant. Full stop, next para. Learned senior counsel further argues that the suit was dismissed on the ground, primarily on the ground that the agreement in question, the specific performance of which was sought by the plaintiff stroke appellant, was unregistered. Full stop. Learned senior counsel contends that Section 54 of the Transfer Property Act envisages that mere agreement to transfer a property does not tantamount to a sale deed and does not create any title in the property. Full stop. As such, unlike a sale deed, which mandatorily requires registration under Section 54 of the Transfer Property Act, an agreement for sale is not required to be registered as such. Full stop, next para. Learned counsel appearing for the respondents opposes the prayer for injunction and contends that as long back as in the year 2005, during pendency of the suit, interim prayer of injunction was refused to the plaintiff stroke appellant, primarily on the ground that the plaintiff had sought to make payment of the consideration amount from somebody else's account. Full stop. Next para, it is contended that in view of the same comma, it was construed by the learned trial judge that the plaintiff was not ready and willing to perform his part of the contract, and as such, the said order of injunction, comma, being unchallenged, comma, attained finality during pendency of the suit. Full stop. Next para, it is contended that the said situation has not altered in the meantime, and as such, comma, as no injunction was passed in favor of the petitioner during the pendency of the suit, comma, no such injunction should be granted at this stage as well. For sub next para, learned counsel for the respondents then places reliance on the averments made in the present injunction application and argues that no specific apprehension justifying the grant of injunction has been made out, comma, particularly in the context of the prayer for injunction having been refused in the suit 20 years back. Full stop. Next para, learned counsel for the respondent also adds that since the agreement is unregistered and unstamped, comma, particularly due to the insufficiency of stamp, comma, the same ought not to be looked into by this court by application of the principle laid down in section 61 of the Indian Stamp Act within bracket as amended in West Bengal. Full stop. Next para, learned senior counsel for the appellant, comma, in reply, comma, submits that the check, comma, in lieu of consideration for the proposed sale, comma, was paid from the account of the partnership firm where the appellant petitioner is also a partner and also signed the check along with the other partner. Full stop. It was the respondents who had refused to take such payment, and as such, comma, it cannot be contended that the plaintiff has not all along been ready and willing to perform his part of the contract. Full stop. Next para, it is submitted that in an appeal arising out of a suit of specific performance, comma, the doctrine of lis pendens applies, and as such, comma, the properties should in any event be protected. Full stop. Next para, upon carefully considering the rival contentions of the parties, comma, we are of the opinion that a strong prima facie case for hearing of the appeal has been made out. Full stop. A debatable issue has arisen as to whether the agreement was required to be registered under section 17 within bracket 1 within bracket small b of the Indian Registration Act, and as to whether due to the insufficiency of stamp affixed to the agreement, comma, the decree of specific performance as sought by the plaintiff appellant can be granted. Full stop. The interplay of sections 36 and section 61 of the Indian Stamp Act within bracket as amended in West Bengal bracket closed ought to be looked into in that regard, comma, which itself gives rise to a triable issue. Full stop. Next para, on the question of the refusal of interim injunction to the plaintiff appellant by the trial court, comma, we are of the clear opinion that the same does not operate as res judicata, not only in subsequent stages of the suit itself, comma, at the final hearing of the suit, comma, more so in an appeal preferred against the very same decree where the injunction refusal culminated. Full stop. Next para, thus, comma, there is no finality to the refusal of injunction by the learned trial judge insofar as the present appeal is concerned. Full stop. Also, comma, the appellant has raised an arguable question as to the tender of a check issued from the account of the partnership firm where the plaintiff appellant himself was a partner and also signed the check along with the other partner could be a reason for the trial court to come to the conclusion that the plaintiff appellant was not ready and willing to pay the consideration amount. Full stop. The state question raises the second arguable issue in the appeal as well. Full stop. Next para. Insofar as the pleadings in the present application is concerned, comma, we are of the opinion that in a suit for specific performance of contract, comma, unlike other suits, comma, the concept of lease pendants under Section 52 of the Transfer of Property Act is not sufficient protection. Full stop. It has been held time and again that even if the doctrine of lease pendants applies, comma, it is no bar for grant of injunction. Full stop. More so in a suit for specific performance where there is limited protection available to the plaintiff in the event the property is transferred or disposed of in favor of a third party uh, who is a bona fide purchaser stroke transferee without notice. Full stop. Thus, comma, an additional layer of protection is available to the plaintiff in a partition suit. Full stop. Since the present appeal is a continuation of the partition, যেখানে partition suit বললাম ওটা suit for specific purpose. Since the present appeal is a continuation of the suit for specific purpose, comma, the same principle applies. Full stop. Since an expression of apprehension has been made in paragraph 16 of the injunction application, comma, read in the context, comma, we are of the opinion that unless the property is protected from being transferred to third parties during pendency of the appeal, comma, there is every chance that the appeal shall be rendered infructuous, comma, thereby causing irreparable injury to the appellant. Full stop. Seen in such context, comma, we find that there is sufficient prima facie case made out as well as the balance of convenience and inconvenience factor being in favor of grant of injunction. Full stop. Thus, can 1 of 2022 is allowed, comma, thereby restraining the respondents and or their men and agents from selling, transferring, alienating, and or encumbering the suit property in any manner till disposal of the appeal. Full stop. Next para. In view of the appearance, all the respondents? In view of the appearance of the
For
respondents?
1 and 4.
1 and 4. Check up.
The others have been deleted, my lord.
Deleted?
Yes, my lord.
Died?
Deleted, my lord, recorded in the decree itself, my lord.
Only 1 and 4 are the respondents.
1 and
In view of the appearance of the respondent,
4 na 2 করা হয়েছে কেটে।
respondents through their learned advocate, comma, check up, Mr. Banerjee. In view of the appearance of the respondents through their learned advocate, comma, service of notice of the appeal on the respondents is dispensed with. Full stop. The trial court record shall be brought by special messenger at the cost of the appellant, comma, to be deposited within a week from date. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Full stop. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing.
Informal paper book I was
Very well. যেখানে paper books বলো, requisite number of informal paper books without comparing with the records. This matter is over.
I'm again attending my apology.
Mr. Kaur, please don't embarrass us. Please. No need for that.
Mr. Urjit Bolson is appearing in this matter on behalf
Start the matter.
My lord, due to medical emergency, he could not come to court.
You start the matter. You don't have any medical evidence. Start the matter. You have a file with you. What is the matter about?
It's
Mr. Abhijit Rai.
Mr. Urjit Bolson, my lord.
Abhijit, what happened to him?
My lord, there is a medical emergency in his family, my lord.
In his family. You start the matter.
There are two CAN applications, my lord.
What are those for?
My lord, one is for substitution, my
Which
lord.
has to be heard first?
My lord, the substitution application.
Within time?
My lord, no.
You're not
There's a
sure.
delay of 3 days, my lord.
3 days. Have you directed you to serve?
Yes, my lord.
You're ready with the affidavit of service?
My lord, no. We could not serve it. My lord, he came to affirm the same on Friday, my lord. That is why we could not serve it upon the other side.
No, no.
My lord, there was a direction to serve upon the
Yes.
respondents, my lord. We could not serve it because the client came on Friday to affirm the supplementary affidavit. There was
Acha. Supplementary affidavit, you are ready with the supplementary?
Yes, my lord.
You'll take that on record.
Mm.
So you could not effect service of the petition application or the supplementary affidavit.
No, my lord.
Oh, you are directed to serve both together.
Yes, my lord.
So we'll take that on record, directed to serve. File it. The supplementary affidavit filed by the petitioner be kept on record. By the appellant be kept on record. Full stop. In view of the supplementary affidavit having been filed late, comma, it is submitted, comma, the service could not be effected in the meantime. Full stop. Accordingly, we direct the petitioner to effect service of both the applications along with the supplementary affidavit on the respondents at the earliest, and to file an affidavit of service to that effect on the returnable date. Full stop. The matter shall next be listed on May 20, 2025 under the same heading.
Grateful.
Don't record Mr. Bordhan's name since he's not in court. You serve quickly and come back on 20th so that we can dispose of this application.
Grateful.
Yes. 22.
My lord, I am appealing on behalf of the appellant, my lord. This is my application for injunction, my lord.
Very well. What is the appeal against?
My lord, the appeal against the suit for declaration, permanent injunction and recovery of possession. My lord, the declaration is on the ground that the appellant number 1 is the lawful tenant. My lord, the respondent has illegally dispossessed me from the property. My lord, thereafter, my lord, I have moved the
It is a section 6 suit or
kind of a section 6, but
you claim declaration of your tenancy
Yes,
right.
absolutely.
So not exactly section 6, section 5.
Absolutely, my lord. But thereafter, my lord, the ad interim injunction was moved. Court has granted the ad interim order of injunction by way of status quo. My lord, thereafter, my lord, the defendant number 2 appeared, did not file written statement. Even he did not contest the suit.
You could not prove your tenancy.
Yes. My lord, I have proved my tenancy, but the learned court below granted the judgment with a plea that the 5 year have been passed. So my right has been go abide, and I cannot throw out from the suit. Even on the one end, he is saying that my right has not been clear at that point of time.
So
And
you
thereafter,
due to the expiry of 5 years, you are not a tenant anymore under the 97 Act.
he's
But you cannot be evicted without due process of law.
yes. So kindly see the order impugned.
Then he could have refused the declaration and granted injunction. You are saying that.
Correct.
Not a good case.
My lord, kindly see the order, my lord. My lord, the tenancy was in the name of the partnership firm, but the learned court below granted the judgment with a plea that my father was a tenant and the 5 year have been passed, so I have no right. If my lord will kindly see
This
the
is not a case of succession as an individual.
Lord, and
Very arguable question has been made out. You serve copy.
and my lord, kindly, my lord, they will the respondent will not encumber the suit property till such time. That is my injunction, my lord. I will serve, my lord.
The present appeal has been preferred against the dismissal of the appellant's suit for declaration of their tenancy rights, as well as for consequential relief of recovery of possession on the plea that the appellants were unlawfully dispossessed. Full stop. Next para. Since certain arguable questions of fact and law have been made out in the memorandum of appeal, comma, we are of the opinion that unless injunction as prayed for is granted and the property is not maintained in status quo during pendency of the appeal, comma, the appellants might suffer irreparable injury and there would be unnecessary multiplicity of proceedings. Full stop. Next para. Accordingly, the respondents and their men and agents shall remain restrained from transferring, encumbering, alienating, and or parting with possession as well as from creating third-party interest in the suit property in any manner till disposal of the application, full stop. The appellant shall serve copies of the application on the respondent stroke opposite parties, indicating that the application shall be listed for hearing on May 20, 2025, when an affidavit of service to that effect shall be filed by the appellants. What is your name?
Shubham Gupta.
Gupta.
Shubham Gupta.
Gupta. How long are you practicing?
2 years, man.
Very good. Very good argument.
I'm grateful, man.
Thank you.
23 my lord, I appear for the appeal.
Yes.
If there is a delay of 27 days, my lord, in preferring the appeal, my lord, the learned trial court, my lord, has my lord, refused the preliminary decree of partition and thereby dismissed the partition.
What is the explanation for
But
this?
the explanation is the learned trial court, my lord, relies upon my lord, the plaintiff.
No, delay.
My
Explanation.
lord, delay, my lord, the Durga Puja vacations intervened in the meantime.
So what?
On the date of reopening, I filed the appeal. But still, my lord, there was a delay of 27 days. Lordship would kindly see the
No,
explanation.
Durga Puja is not an explanation. Even if it's a one-day delay, you have to explain.
But I have explained that.
Let us see the explanation. It has to be interesting also. Unless it's interesting, we generally don't allow.
Kindly see, my lord, paragraphs 5, 6, and 7 of my application. But 15th October, my lord, he contacted with us. On the date of reopening, we filed the appeal.
No, before that,
It was passed, my lord, the judgment and decree is dated 27 June and 3rd July.
No, what is the explanation before the vacation?
My lord,
The
before the
vacation time is
vacation-
discounted, but
kindly comes to paragraph 4. My lord, it's a joint family property, my lord. We had to
they
my
took a
lord, talk
decision and all.
take a decision, my lord, amongst all. My lord, that resulted
You're
in the
allowed.
delay.
You are for all the respondents, Mr. Chakraborty?
I am for Biman, Pankaj, Surojit, and Bonani Sarkar.
Some of them. Then you have
But
to.
we have served upon all the services on record.
Oh, acha, right.
The thing is, my lord, in the judgment and decree, I suppose all the other defendants did not appear. So it was decided expired.
This arises from a partition suit.
Partition suit.
Yes.
You are against a preliminary degree?
Yes.
Or dismissal of your suit?
My lord,
Their suit decree.
preliminary decree refused, partition suit dismissed.
That suit has been dismissed.
Dismissed. Very well. Let us allow the section 5 first. Upon hearing learned counsel for the appellants and the appearing respondents, we find that sufficient explanation for the delay of about 27 days in preferring the appeal has been explained sufficiently. And sufficient explanation has been given. Full stop. Accordingly, can 2 of 2024 is allowed on contest, allowed, thereby condoning the delay in preferring FAT 350 of 2024. Full stop. The appeal be deemed to stand registered and admitted accordingly. Yes.
I have an application for injunction for restraining them, my lord, from selling, transferring, or alienating the properties. My lord, the plaintiff file not file the suit, the defendants file written statement. But both the parties, my lord, paid for partition. Now, my lord, the learned trial court has absolutely made out a third party case which is beyond the pleadings. The learned trial court says suit property is partitioned in the year 1961. My lord, the DW1 has proved it. Now, but I have annexed the evidence of DW1. My lord, the DW1 is in his evidence said that about the deed of 1961, I have no knowledge whether the suit property is partitioned or not. But kindly sees the evidence of DW1.
What is your...
The only my contention was that since there is already a partition deed, they cannot seek partition of that.
That has
same
to be
property.
decided on merits.
Yes.
Because the DW1 he says couldn't
But page
prove it.
51, kindly sees the evidence of DW1 and the learned trial court.
You have not made any application for injunction. Then
I have not.
Should have made a counter application. The present appeal arises out of the dismissal of a suit for partition. You also asked for partition. How could
Yes.
have asked? How could you ask for partition if you say that?
I don't have any document.
But this is the written statement, my lord. I have a copy of his written statement. Kindly sees paragraph G. This is badly marked. But kindly sees paragraph G. This is the written statement filed by different numbers 1 to 3.
1,
1 to 3. My lord, they were only.
You are 1 to 3. Mr. Chakraborty, are you within 1 to 3?
Yes, yes.
Sees G that if the quantum of the said land is finally allotted to these contesting defendants by way of partition, as per their physical possession, the defendants have got no objection.
We'll extend both parties in this case, Mr. Das. You also don't.
Grateful.
Learned, the present appeal arises out of the dismissal of a suit for partition. First of learned counsel for the appellant submits that the learned trial judge acted dehorsed the law in refusing partition primarily on the ground that there was a partition by meets and bounds by a deed of 1961. Full stop. However, comma, DW1, comma, the defendant's witness, comma, himself denied having knowledge of the said deed in his evidence. Full stop. That apart, comma, it is pointed out from the averment made by the defendant numbers 1 to 3 in paragraph number 8 within bracket small g of their written statement, comma, a copy of which is filed in court today and kept on record, comma, that the said defendants expressed that they have got no objection to formal partition if the quantum of land as finally allotted by you of partition is as per their physical position, comma, thus in principle conceding to the relief of partition. Full stop. Next para. None of the other defendants contested.
No. But only 1 to 3 contested this.
You are for 1 to 3.
1, 2, 3, and 4, my lord. Bonani Sarkar has also given wakalatnama.
You are appealing for her also.
Yes.
Very well. Next para. Then we'll dispense. But this is a partition suit. No, sir, the appeal notice has to be served on. Heard learned upon hearing learned counsel for the parties, comma, we find that only the defendant numbers 1 to 3, comma, who are represented before us.
1 to 4, my lord.
No, 1 to 3 contested. They are
Yes.
who are represented before us by learned counsel who is appearing for the said defendants as well as respondent number 4, comma, service of notice of the injunction application. Did you direct it to serve? No.
Your Lordship had directed us to serve only the section 5, but we have served the section 5 as well as the injunction.
Service of notice of the injunction application on the other non-contesting defendants in the court below is dispensed with. Full stop. Accordingly, can 1 of 2024 is allowed, comma, thereby directing all parties to maintain status quo with regard to transfer, sale, comma, transfer, comma, alienation, and or creating any third party interest in respect of the suit property till disposal of the appeal.
Grateful.
Push up in view of the appearance of the respondent numbers 1 to 4 through their learned advocate, comma, service of notice of the appeal on the said respondents is dispensed with. The appellant shall put in due requisites for service of notice of appeal on the other non-appearing respondents within a week from date. Full stop. The trial court records shall be brought by special messenger at the cost of the appellants, also to be deposited within a week. Full stop. The appellants shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of the arrival of the trial court records on the learned advocate for the appellant. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing.
Great. My lord, one liberty may be granted to file the wakalatnama. I hold it, but I
How soon can you file it? Today?
Today.
Liberty is granted to the learned advocate having instruction to appear for the respondent numbers 1 to 4 to file his wakalatnama for the said respondents in the department by tomorrow. Do it today, but we have granted you till tomorrow. If by any chance you can't. Yes.
Well, I am for the petitioner.
Yes.
As per the direction of your lordship.
You have served, Mr. Court?
And it is effected.
Good, sir. You are appearing. What is the matter about, Mr. Court?
Probate, my lord. Probate.
Refused or granted?
Yes, my lord.
Refused?
No, my lord. Probate was decreed, my lord, in absence of ourselves. We preferred an application under order 32 rule 15. That was turned down. Thereafter, we preferred an application before this honorable court. Honorable court admitted our petition, but my lord, during the pendency, my lord, that was.
You had preferred a revision before this court?
Yes.
What is your claim to caveat interest? You are not heirs.
Yes, my lord. I am one of the heirs.
Oh, you are one of the heirs. Why was it refused by the trial court?
But I did not find any opportunity to place my points, as because I am mentally, my lord, retarded person, my lord, not fit state in mind, my lord. Thereafter, my lord, my son applied for order 32 rule 15. That was turned down. Thereafter, I preferred an application under article 227. It was somehow admitted, but during
no, but here you are filing in an independent capacity.
Yeah, my lord, that is, my lord, I prayed for, my lord, special leave to file. So that, my lord, leave may kindly be granted so that matter I can prefer this appeal.
You are the son.
I am the son.
But during the lifetime of your father, you don't have a habitable interest. The appeal should have been preferred by the father, and you could have made a similar prayer for
My mother.
your mother.
Yes.
The appeal had to be filed by your mother. How can you be granted a leave?
How the mother will file, my lord?
Mother will file through you. The mother will be the appellant, and you file an application for your appointment as an next friend. Order
But
32.
actually, yes, because my lord, this petition is pending, my lord. No final order was passed by this.
But that has become infructuous in the trial court. Although yes, but same
that
point
order was communicated before the learned trial.
same order, same ground. The said order can be challenged in this appeal also because the revision was never disposed of. You can set that up as a ground for. Yes, Mr. Bhattacharya, what do you say?
Two things, my lord. Today, my lord, we are considering, my lord, two applications. One, my lord, leave to file by the son himself, as rightly pointed out by your lordship. One. Number two, my lord, is application, my lord, can two is for stay. Now, my lord, stay, my lord, after that, we have, my lord, grant, after, my lord, probate being granted, we have also, by putting, my lord, maximum court fee, we have, my lord, also taken the grant.
Stay we generally don't grant. It's a judgment in name, but they have also paid for transfer alienation injunction in the prayer portion.
Yes.
And made the amendments. We have checked that up. But Mr. Court, this is we cannot allow this leave application. You don't have a right to prefer the appeal. Mother has to file the appeal, and will dismiss your appeal with leave to the mother to prefer an appeal, granting you liberty to apply for just the same copy paste of the same memorandum, but this will be divorce the law. You don't have a right.
But their application 3215 will order 30 was
Certificate copy may kindly be returned, my lord.
rejected. On their-
Rejected, even then we can take it within the scope of section 103, 105, 105, 105.
But my lord, it says, my lord, where there is a right of appeal, but no right. They are challenged it by way of a revisional application. They
Revisional
moved
application was rendered infructuous. It was not rejected.
as of today, but kindly appreciates one thing. They challenged it, but they did not, my lord, proceed with it, my lord. In whatever way they should have mentioned it was running in the list, does not running in the list. Admittedly,
It was pending at the time when they did it.
There was no stay. There was
So
no
what?
stay.
Stay
No,
does
court, therefore, it did not prevent, my lord, the learned trial judge,
Even to
my lord,
prepare for,
to
prepare for
It's
adjustment.
not saying it was
proceed with the matter.
No,
One.
not
Number two, my lord, I have the, my lord, order sheets, my lord, of the learned trial judge, my lord, at least 4 occasions I can show to your lordship where the defendant number 3, that is, my lord, the mother of the present appellant, personally appeared through their advocate. Not, my lord, and on the 4th day they filed order 32 rule 15. They prayed for time, my lord, for filing written statement. The defendant number 3, that is recorded in the impugned order.
We'll consider that for on a future date when they file this appeal. The present appeal has been filed. What is the name of your mother? Maluti Samantu.
Maluti Samantu.
The will is of your father?
Yes.
The mother.
Grandfather.
The present appeal has been filed by one Pradip Kumar Samantu, the son of late, the son of Srimati Maluti Samantu, the latter being one of the heirs of the deceased testator. First of the present appeal arises out of the grant of a probate in favor of the respondent. First of next para, learned counsel for the appellant submits that Can 1 of 2025 has been filed by the son of the said Maluti Samanto, who had a caveatable interest in the estate, in view of the said Maluti Samanto being mentally unsound and unable to represent herself. First of learned counsel for the petitioner submits that in the probate court, an appropriate application under order 32 was filed by the petitioner praying for representing his mother as the next friend. However, such application was rejected, against which a revisional application under Article 227 of the Constitution of India was pending before this court, at which juncture the impugned probate decree was passed. It is thus submitted that leave may be granted to the present petitioner to prefer the appeal on behalf of his mother, Malati Samanto. For sub next para, learned counsel appearing for the respondent contends that due to repeated absence of the due to the negligence of the petitioner, the revisional application remained pending during remained pending after its filing, and as such, since no stay order was passed in connection therewith, there was no impediment on the probate court to grant the probate. For secondly, it is contended that the mother of the present petitioner stroke appellant had contested and appeared on 4 dates in the probate case, 3 dates in the probate suit, and only on the 4th date did the petitioner make the application under Order 32. As such, the probate court was justified in rejecting the said prayer. Next para. Be that as it may, we find that the petitioner, during the lifetime of his mother, Srimati Malati Samanto, the latter having caveatable interest in the property as an heir of the deceased testator, does not have any right to the estate. Consequentially, the present petitioner stroke appellant Pradeep Kumar Samanto, during the lifetime of his mother, does not have a caveatable interest in the property in the estate. Thus, there is no scope of granting any leave to the present appellant stroke petitioner to prefer the appeal at the behest of his mother. The appropriate course of action might have been for the mother to prefer the appeal before this court, and for the present petitioner to take out an application for being appointed as next friend to represent his mother. Despite a similar application having been rejected by the probate court itself, fact remains that a revisional application was pending before this court, during pendency of which the probate decree was passed. As such, within the contemplation of section 103 of the Code of Civil Procedure, this court can also look into 103 or 105, please check 105 of the Code of Civil Procedure, this court is not debarred from looking into the veracity of the order rejecting the petitioner's application under Order 32. Be that as it may, the present appeal is not maintainable at the behest of the petitioner. Accordingly, Can 1 of 2025 is dismissed on contest. Consequentially, FMAT 505 of 2024 is also dismissed along with Can 2 of 2025. However, it is made clear that nothing in the above order shall preclude Malati Samanto, the mother of the petitioner, to prefer an appeal against the probate decree, subject to limitation. If such an appeal is filed, it will be open to the petitioner to take out an appropriate application for seeking to represent his mother as next friend. However, we do not express any opinion at this juncture on the legality or outcome of such application, if at all made. Next para. The learned advocate we hereby grant leave to the learned advocate on record for the appellant to take back the certified copy of the impugned judgment and decree upon furnishing photocopies of the same for the records. Next time, Mr. Kaur, please ensure that it's described as an appeal from appellate decree or a deemed decree, so that its regular first appeal is registered, not a misappeal. No rest to cost.
Has been already converted. Regular first appeal has been
Oh, acha. Very good. তাহলে FMAT নাম্বার বললাম
লিমিটেশন মাই লর্ড
যে এই মেঘনাথ তাহলে FAT নাম্বার হবে ওটা FAT আছে
that period of limitation be waived.
No, we cannot do it here. Subject to limitation, you file a section 5 also. This will be section 14 scenario.
Yes, my lord.
Mr. Bhattacharya will help you on that. He's unhappy already that we are advising people.
Oh,
No, it will be taken from the department. We don't have that infrastructure in the
Yes. I love it. Don't know.
There is a section 5 application, there is a dealer 378.
Appearing for the first time?
Yes, my lord.
না এটা অ্যাপ্লিকেশনটা রিজেক্ট কনসিকুয়েন্সিয়ালি হলো তো এমনি অর্ডার ফর মি সরি ইয়েস ইউ হ্যাভ সার্ভড
No, no, my lord.
ফার্স্ট টাইম
Yes, my lord.
will direct you to serve any other this arises out of what
Decree from a partition suit, my lord.
preliminary decree
Yes, my lord.
will direct you to serve copies of both the applications subject to section 5 then the appellant shall serve copies of can 1 of 2025 as well as can 2 of 2025 on the respondents indicating that the applications shall be listed for hearing on May 21, 2025, when an affidavit of service to that effect shall be filed by the 21st.
May I please, Your Lordship?
Yes, please. You are for the other side, Mr. Shur?
I'm for the caveator.
Caveator.
I've served, my lord,
Caveator, defendant number 1 or 2?
Both.
Both. So, for both the respondents?
Yes.
Yes. Caveator, we thought that one of.
Caveator, my lord.
Very good. What is the matter against?
My lord,
Appeal against?
my lord, this appeal, my lord, for declaration injunction, my lord, and my lord, the
Suit was for declaration injunction.
suit for declaration injunction, and my lord,
Dismissed.
suit is dismissed, and there is a counter claim that has been allowed.
The declaration of your title or tenancy.
My lord, there is a agreement between the parties. Plaintiff number 1 and 2 agreed to sell A and B issued property to the defendant number 1 and 2, my lord. And that for my lord, an agreement has been preferred. And during the
You wanted to sell to him.
yes,
Then
my lord, within the time the payment has been not been made, my lord. So my lord, second agreement has been preferred. But even that period also, my lord, the
what
payment has not
he
been
sought for
made.
declaration of what?
In the meantime, he has got the my lord position of the shoot. So my lord,
Position in terms of the agreements.
yes, my lord, that's for my lord, the suit is that
What is the declaration sought by you?
declaration, my lord, for consequences A, my lord, for return back of the property and also declaration that agreement is failed, my lord. Agreement does not exist due to time bar, my lord. And
So
the
you have
trial
sought
court
for declaration that you are the absolute owner of the
absolute on the
property,
and my lord,
recovery of possession,
recovery position.
and permanent injury. Only that. What is their counterclaim? Let us see.
My lord, the specific
Specific
performance of
Specific
contract, my lord, I have paid my lord 25
So
lakhs.
that was
I
granted
have
and
paid 25 lakhs of 15. There are the remaining dues of 12 lakh. I have several times tendered to make the my lord,
Out
get
of
the
time.
register.
ready and willing.
Out
This
of
is
time.
my lord copy. This is my lord
Keep it
copy.
with
I have
you.
several times the
What-
learned court, my lord,
With you. Keep
directed.
it with you. What sort of stay are you wanting?
My lord,
Specific
in the meantime-
performance.
Yes, my lord. In the meantime, court has proceeded for my lord.
If you execute the degree of what remains, the specific performance degree.
My lord, specific performance of contract, my lord, they have been, my lord, they agreed. My lord, they have been, my lord, not too willing to transfer the register the
Yes, we
document.
can appreciate that, Mr. Shur, but
My
in
lord, I am
pendency of
in
the appeal,
possession. I am in possession of the suit property. They have filed appeal before this court asking for the, my lord, the stay of the proceeding. I am in possession. I am using.
no, stay of your the counterclaim.
But
Yes.
why the
Don't be
counterclaim?
so naive, Mr. Shur.
Counterclaim.
Declaration suit has been dismissed. We
Dismissed,
cannot.
yeah.
There is no effective purpose can be served by staying that. Staying a dismissal of a suit does not mean that the suit revives. No, but your counterclaim, yes, counterclaim that has to be stayed. What is the stay sought?
My lord,
We'll stay the operation of only the decree pertaining to the counterclaim.
my lord, counterclaim, my lord, they have been, my lord, I have asked for my lord time for today to I will pay the money. My lord, they have Larned trial court, my lord, directed 151 to make the payment. I am ensured to make payment. They have been changing the bank account. So
What
this
is your
why this
ground against this specific performance decree?
My lord, within time, my lord, first of all, my lord, within time, the payment has not been made, in spite of the two agreements.
Time was the essence.
Yes, time was the essence.
In
And
the
also-
agreements, there was a clause that within
Yes,
it has to be executed within.
The unregistered agreement. This is the
Unregistered agreement, but
Unregistered.
both-
Don't
both of-
shout so much on unregistered. You have got a specific performance. Oh, that is another ground. There is another ground you have.
Yes, sir.
Arguable
That
question.
that is one of the
Unregistered agreement whether the specific performance degree could be passed.
My lord, that
That ground is also available.
my lord, in case of my lord, the unregistered degree agreement, my lord, they have been, my lord, the such agreement has not been, my lord, followed the terms and conditions they have been stated. My lord, they have been also filed an application sought for, my lord, supply of the copy of the agreement in here.
Yes.
Arguable questions have been made out.
But
You
kindly,
have supplied the arguable question.
I may supply. But question is that, my lord, after the payment of the entire amount, but the balance amount who have been changed out by the running trial court, my lord, directed to
Client
make
present, Mr. Shur. Client present.
payment.
Present. Argue a bit more. Yes.
My lord, the 151, my lord, the application running trial court is allowed to make payment. And I am changing the payment. They have been changing. They are not registered in the marketplace. There is another second agreement. They have been annexed. I'll kindly see. Then just like a paper, page 70. Just like make a paper, they have been asked for the payment of 37 lakh, 75 is the agreed amount. I have been 25,000, 25 lakhs, 15 I have been paid. Remaining amount 12 lakhs or something, my lord, I am ready to agree to pay the amount. Kindly come to page 70. Second Chukti Patra.
That is exhibited.
Oh, exhibited to maybe. Into what you have done. Yeah. In the marketplace, you ask your client to make an agreement and sign the agreement. My client so bona fide, they have signed the agreement. And now that before this court enforcing that the suit to counterclaim should be stayed in here.
The present appeal has been preferred. You have preferred 2 appeals or 1 appeal?
One appeal.
No.
Two can is there. One
1
for
minute.
stay.
You have now that appeal is against the counterclaim or the suit dismissal. You have to check that. Otherwise, you cannot grant a stay.
Appeal against my lord.
You have to prefer 2 appeals because your suit has also counterclaim has the same footing as a suit. You have to choose. If you have to stay the counterclaim, the appeal has to be against the counterclaim.
For stay, my lord, counterclaim is the main thing because my suit has gone. That's gone, my lord. But
The appeal has been preferred against the counterclaim. Then, unless there is a decree, you will never get specific performance of that. You will never get recovery of possession then. But Mr. Should non-filing of an appeal against that does not necessarily mean that this appeal will become bad. Because suppose they win in the appeal against the specific performance, that you don't get specific performance and they don't get possession. You'll stay there forever. You'll stay there forever.
That is
So therefore, it does not, what we mean to say is that non-filing of appeal does not automatically vitiate this appeal, not dependent directly. Very well. The present appeal has been preferred against the counterclaim for specific performance filed by the respondents having been allowed by the learned trial judge. Full stop. The matter arises out of a suit for declaration of title and recovery of possession filed by the plaintiff's appellants. Full stop. The said suit was ultimately dismissed, whereas the counterclaim was allowed. Full stop. Next para. Although no separate appeal has been preferred against the dismissal of the suit, comma, it is clarified by learned counsel for the appellants that the present appeal has been preferred against the component in the impugned decree whereby the counterclaim was allowed. Full stop. Next para. Learned counsel for the appellants contends that the respondents did not tender the consideration amount within time. Full stop. Next para. Learned counsel for the respondents opposes such contention and submits that even by a subsequent written agreement, comma, the appellants agreed to convey the suit property in favor of the respondents, comma, pursuant to which considerable payments have, you say entire consideration has been paid.
Entire 25 lakhs 50.
Substantial part of the consideration amount has already been paid to the appellants. Full stop. Next para. Be that as it may, comma, we find that certain arguable issues have been raised in the appeal, comma, including as to whether time was an essence of the contract and the respondents tendered the part consideration within time, as well as whether the agreements in question, comma, being unregistered and insufficiently stamped, comma, could be relied on by the learned trial judge in passing the decree of counterclaim on the counterclaim. Full stop. Accordingly, the appellants have made out a strong prima facie case for hearing of the appeal against the counterclaim. Full stop. Next para. Hence, can 2 of 2025 is can 1 of 2025 is allowed, comma, thereby granting stay of operation of the portion of the impugned judgment and decree whereby the counterclaim of the respondents for specific performance of contract was allowed. Have you levied execution, Mr. Shur? Execution case has been filed? Not yet.
Court below has proceeded to
Very well. Till disposal of the appeal. Full stop. Next para. It is made clear that this appeal is construed to be an appeal against the allowing of the counterclaim of the respondents and not an appeal against the component of the impugned decree whereby the suit of the appellants was dismissed. Full stop. However, comma, nothing in this order shall prevent the appellants from preferring such an appeal subject to limitation. Please prefer an appeal against that. Otherwise, that goes.
50,000 rupees is the court fees, my lord. 50,000.
Don't file your choice. Your choice. Your choice. Very well.
50,000 rupees.
In view of the appearance of the respondents through their learned advocate, comma, the appeal is otherwise ready as regards service. Full stop. The trial court record shall be brought by special messenger at the cost of the appellants to be deposited within a week from date. Full stop. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of the arrival of the trial court records on the learned advocate for the appellants. Liberty to the parties to mention the appeal for hearing as and when the same is ready for hearing. Full stop. Can 2 of 2025 is in the nature of an application for production of additional evidence. Full stop. Would you like to use an affidavit against this? No scope.
Which is the no scope. There is a
You will argue on law. Yes, very. The said application shall be heard along with the appeal.
My lord, there is a 2 defect, but my instance is that all the defects have been cured, my lord. The decree has been already submitted and the 50,000 rupees cost has already, court is already paid.
Cost has been paid.
And also decree has been
Certificate copy of impugned.
also submitted. And also, my lord, it is overlooked, my lord, that the respondent number 2, there is a typographical mistake in
the name.
Name, my lord. In lieu of Kumar is a Mumar. It's only typographical mistake, my lord. That may be corrected here and now, my lord.
Respondent number 2 name.
Name.
Oh, Kumar instead of Kumar.
Yes.
Very well. Leave is granted to the learned advocate on record for the appellants to rectify the cause title of the memorandum of appeal and the pending application insofar as the surname of the respondent number 2 has been misspelled. Full stop. Such corrections shall be carried out during the course of the day. Full stop. What else remains? Acha, the office shall furnish a revised report as to whether the defects, the remaining defects have been removed by the appellants in the meantime. Thank you.
Grateful.
Thank you.
For the respondent number 1.
Lordship, I beg to appear on behalf of the appellant. I have been led by Mr. Shiva Prasad Mukherjee. He is appearing on virtually, Lordship.
My lord, I am for the appellant.
Yes, Mr. Mukherjee. What is the matter about?
My lord, this suit was filed by the respondent's mother or the party's mother seeking for a declaration and cancellation of a document. Now, the suit has been decreed in their favor and we have come over in appeal in view of the fact that the gift deed was executed in favor of my client in respect of the property which was there in respect of the property which was there, and the mother was in possession of the property. Now the mother has unfortunately died and the son has taken over the mantle to see to it that the sister is thrown out of the property. That's why we have sought for
a degree has been granted holding that the gift deed is void.
Yes. No, my lord. No, the suit has been dismissed against us.
That is what your lordship is asking.
No,
that the instance should be the same has been decreed on contest as against
It's 78,
but
Lordship.
without any order. declaring that gift deed is void and liable to be cancelled.
Yes, my lord.
Yes.
We have filed an application for injunction seeking for an
No,
order so
they were
that
the defendants in the court will. So
Beg
then
pardon?
it has been decreed. Mr. Mukherjee, you are the defendant in the court will.
yes, I am the defendant in the court.
It has been decreed against you.
Yes.
It has
Yes,
been- must have been declared that the gift deed is void.
yes, my lord.
Yes, Mr. Rai will continue the injunction. Don't transfer the property.
No, no. Injunction in both parties, Lordship. Let me file my affidavit in opposition because there are certain allegations we have been.
Very well.
Yes.
Learned counsel for the appellant. Learned counsel for the. You're for how many respondents?
I am for respondent number 1.
You are the only contesting respondent.
No, others are pro forma respondents.
Did they contest in the court below? Mr. Mukherjee, the other.
No, my lord, they didn't come.
Will dispense with service on them.
Yes.
Yes, sir.
Learned counsel for the only contesting respondent number 1 seeks to use an affidavit in opposition to the injunction application. Full stop. Next para. Accordingly, the respondent number 1 is directed to file affidavit in opposition to the injunction application within a fortnight from date. Full stop. Reply, if any, shall be filed within June 13, 2025. The application shall be listed next for hearing on June 16, 2025. First up, since we have already granted injunction till disposal of the application, comma, no further order need be passed to that end for the present. Did we dispense with service of notice on the others? Just let us. Yes, we had. Mr. Mukherjee, it will come up on 16th of June.
Yes, ma'am. Yes.
Sir, please come back on that.
Grateful, madam.
Thank you. Defect our head. T-shirt against state average.
Pursuant to the direction passed by your law.
You have mentioned it as a may appeal from original order.
That is because on earlier occasion no leave was granted, my lord. That is the given why my lord we could not correct.
Now you have corrected.
No, I have not corrected.
We'll give you leave today, correct it. No difficulty. We'll take up the application. The application is appearing for the first time.
No, my lord, this is for the second time, my lord. We pursuant to the direction I will start copy upon the opposite parties.
All have received.
2, 3 this delivered, and the other one is received. Like indicates, my lord, upon the 3 delivered. That's so far.
No, item delivered to sender.
No, my lord.
Sender is you. The first one, page 6 of the affidavit service. Item delivered means bracket within bracket sender. It was delivered back to you. The next one, page 7 is to addressee. Half item bagged one is received and all this. Not yet. This arises from partition suit.
Final decree partition suit 63 days delay. Only 63. Though there is no report from the stamp reporter that there is a.
No, you did the right thing in filing it. But you are the defendant, obviously, one of the defendants. The other pro forma respondents contested, please check up. Check up. No, you are the plaintiff.
We are the defendants.
Oh, sorry, you are the defendants, yes.
Defendant number 1 and 2.
Plaintiff, obviously, plaintiff has been served. Ajit Kumar Ghosh.
No, my lord. It appears, my lord, it has been
Delivered to send. Then you'll have to. Proper service. It appears from the affidavit of service filed today that proper service has not yet been effected on all the respondents. Pushed up. Accordingly, the appellant shall serve afresh copies of the. There are 2 applications, CAN 1 and 2.
but only one application.
Copies of CAN 1 of 2025 on the respondents and file a fresh affidavit of service on the returnable date. Pushed up. The matter shall next be listed on May 20, 2025 when the said affidavit of service shall be filed.
But it is a Uttara Dina case. It would take some.
That's very well. May 20 na kore on June 10, 2025 When such further affidavit shall be filed by the appellants, full stop, the affidavit of service filed today be kept on. Sir, application.
Leave be given, my lord, to correct.
Leave is given to the learned advocate on record for the appellants to carry out the necessary corrections in the heading of the memorandum of appeal by classifying the appeal as an appeal from appellate from original decree during the course of the day. Please do it.
It should be appellate decree.
Appeal, no, original decree.
Original decree. Sorry.
Original decree. First appeal. You have mentioned original order.
Original order. It should be decree.
Yes, Mr. Rai, what is the matter?
My lord, I am appealing on behalf of the opposite party.
Evidence service. Only one opposite party?
Yes, my lord.
Very good.
My lord, I am praying.
You're praying?
I'm praying.
You're consenting to the prayer?
I am praying for vacating the order of injunction, my lord.
Why do you make such illegal prayers? Mr. Rai is appearing for the other side and you have dared to do it. You have filed a vacating application or just asking?
What happened, my lord, on the earlier occasion? Well,
Yes,
suit
what
filed by the petitioner before your lordship for
Right.
partition. Suit was dismissed on the ground because by way of purchase, the plaintiff became the owner of the property. Such purchase was subject matter of preemption in another proceedings. Both are heard.
Don't go so far. You are the defendants. They filed a suit for partition.
I am the plaintiff. I filed a suit for
Oh,
partition.
you filed a suit for
for partition on the basis of a deed, which the defendant have filed an application for preemption. Both the
preemption under section 8.
8.
Then
Both the suit and the preemption application heard analogously. Preemption application allowed, my suit dismissed because the court is of the opinion there is no occasion to file any declaration for the share in question. Because by way of preemption, the right and interest based upon him. Now, this is a challenge against the partition suit. I advise my client to file a preemption application and ask for the taking this both the matters before.
preemption appeal has been filed.
That, my lord, I must be candid with your lordship. Till today, my lord, I do not have any information, but they have
So as on today, you don't have a prima facie case.
if any, my lord, whether, my lord, the share can
On
be
the last occasion,
that was the precisely, my lord, I have also mentioned to your lordship regarding the pendency of these proceedings.
we had grant partition on the
Not to transfer subject to question, my lord.
Let us just give us up.
No, suit. Sorry.
No, you said that
No, no, suit filed by me.
has been challenged in an appeal. On the last occasion, you submitted. We recorded that learned counsel
Yes,
for the appellant submits that they said order of preemption has been challenged in an appeal before the appropriate court, which is now sub judice. On that ground, we had granted it. Check up.
My lord, I need to be checked up, my lord. Because
If you have not filed an appeal, that then we'll vacate.
Yes, sir.
Yes, do you have any idea whether an appeal has been preferred?
My lord, as per my instruction, no appeal has been preferred.
Then
No,
we'll-
my instruction. Secondly, partition should and preemption should filed by the opposite party plaintiff, both. My lord, firstly, my lord,
No, partition suit was filed by them.
filed by the plaintiff, my lord.
Plaintiff,
I
my
have-
lord, I beg to get it. It is filed by them.
I
My
have-
lord,
I
I
have
beg
two
to
order- I have the two orders. Preemption.
You filed the partition suit.
Yes, I have filed the partition suit and preemption. Yes. My lord,
Partition was decreed.
my lord, partition was failed as the preemption suit. We have
So what happened to the partition suit?
partition should fail. Partition should fail as all the shares of the plaintiff vested to the
So then this order was passed on a misconception. Our order was passed on a misconception.
well, kindly,
We proceeded on the premise that they had filed a partition, just as Mr. Rai was submitting to.
my lord, preemption should and the partition should both are disposed by the learned trial court.
That may be. You filed a partition suit.
I have not filed. I have filed the partition suit and the preemption suit.
How could you file a partition suit without getting the preemption order? You are not a co-owner before you get the partition order.
I am not.
Don't place anything. Just submit before us
Your
first.
Lordship.
Keep the papers with you.
My lord, both partition suit and preemption suit.
How can you file a partition?
Analogously tried.
First, answer our question. Your partition suit preemption application was on the ground that you are a co-sharer.
I'm the co-sharer. I'm the co-sharer, and he is a third party stranger.
Well, may I correct it, my lord?
He is a third party stranger.
I am the existing co-sharer.
Kindly allow me one submission,
I-
my lord. At the time of
No, he's let him complete.
your
Yes.
lordship has to dispose the civil refusal application, my lord. At the time of disposal application, my lord, Your lordship directed the trial court to both shoot and preemption shoot and partition shoot analogously.
So that has been
And
done.
And also the directed the trial court to give the judgment first preemption shoot and then
Obviously, because if there's a no, keep it with you for the let us hear you first.
Your lordship.
Don't be so eager to hand the papers. First, make your submissions. If you require papers, we'll call for the papers. Yes. So then what happened?
Thereafter, the partition.
We directed the preemption suit to be heard.
First.
It was not a suit. It was a Section 8 application.
Section 8 application.
Very well.
Thereafter, on the same date, both suits have been
Your partition suit was dismissed because you had already got the preemption.
all the rights of the contents of all the right vested to the preemptor. That's why my.
So how could they prefer this appeal against the dismissal of your partition suit?
No.
Mr. Rai, it was a misrepresentation before the court on the last occasion on your part.
If there is no co-owner, there is no partition.
Your partition suit dismissed. They don't have a locus standi to prefer an appeal.
No, this was filed on the ground that after passing of the order of preemption case, the instant defendants have no left with the initiate to suit property. The plaintiff gets the ownership of the defendants in the suit.
Mr. Rai, how could you prefer an appeal against the dismissal of their partition suit?
Yeah. But I turn to the portion.
Let us see for ourselves.
Yes, page 20, paragraph 27, my lord.
Yes, their partition suit was dismissed.
Dismissed whether the findings I can, because 27.
Can an appeal be preferred against findings? We'll dismiss the appeal itself. Not maintainable. You don't have locus standi to make any application. Prefer an appeal. What prompted you to prefer an appeal, Mr. Rai? What is the ground? Let us see. It will be interesting read. You didn't even look into the memorandum because you submitted that it was your suit. Yes, your first ground is that dismissing the suit filed by the appellant, which is wrong.
This is honor. I might be corrected on this.
The present. Now, when we take up the application for hearing, learned counsel appearing for the respondent points out that the interim or that the ad interim order passed in connection with the injunction application by this court was obtained on a misrepresentation before the court. Pushed up, it appears from the order of this court dated April 7, 2025, that the premise of the said order was the submission of the appellants that the appeal has been preferred against the dismissal of the appellant's partition suit on the ground that a preemption order had been passed under Section 8 of the West Bengal Land Reforms Act in favor of the respondent. Full stop. Next para. However, the fact was just the reverse. Full stop. The appellant, the respondent himself had filed a partition suit and simultaneously an application under Section 8 of the West Bengal Land Reforms Act for getting preemption of the property in question on the ground that the respondent is a co-sharer. Full stop. By a revisional court of this court, the two suits were directed to be heard together and the preemption case was directed to be decided earlier. Full stop. In consonance thereof, the preemption application of the respondent was decided first and allowed in favor of the respondent herein. Full stop. Consequentially, the respondent's suit for partition was dismissed, since by virtue of the preemption order, the respondent had become the exclusive owner of the property. Full stop. Next para. We find upon hearing learned counsel for the parties that undoubtedly, the order dated April 7, 2025 was obtained by misrepresentation on the part of the appellants. Full stop. Not only was it submitted that the partition that the appeal arose from the dismissal of the partition suit of the appellants, comma, we also find from the grounds taken in the appeal that the appeal has been also filed on the same premise. Full stop. In fact, comma, the very first ground in the memorandum of appeal is that the learned court below erred in dismissing the suit filed by the appellants without considering the materials on record. Full stop. Next para. Thus, comma, we find that the order dated April 7, 2025 was passed by way of misrepresentation and as such ought to be vacated on such ground alone. Full stop. Consequentially, we vacate the order dated April 7, 2025. Full stop. Next para. On a wider premise, on a more basic premise, comma, we find that the present appeal is not maintainable at all at the behest of the defendant stroke appellants. Full stop. The appeal has been preferred against the dismissal of a suit for partition filed by the respondent, and as such, comma, the decree went against the respondent and not against the appellants. Full stop. Learned counsel for the appellants seeks to impress upon the court that the appellants are agreed with certain findings in the judgment of the trial court. Full stop. However, comma, it is well settled that no appeal lies merely against findings of the impugned judgment, comma, if the decree itself went in favor of the appellants. Full stop. Thus, comma, the present appeal is not maintainable at all at the behest of the appellants. Full stop. It would be unnecessary and a wastage of valuable time of the litigants and the court if the appeal is kept pending, comma, despite having held that the same is not maintainable. Full stop. Accordingly, although the application has been the application is appearing in the list today for hearing, comma, in view of our above observations, comma, nothing remains to be decided in the appeal. Full stop. Accordingly, FA 132 of 2025 is dismissed on contest as not dismissed as not maintainable. Full stop. Consequentially, the connected application being CAN 1 of 2025 is also dismissed. Full stop. There will be no address to costs. Urgent certificate copies.
It's my fault. When somehow
Should have been careful.
I
We
should have.
blindly
No. I should
rely
have.
on.
I should have.
Yes.
Escape from my notice somehow.
এটা এটাকে জাজমেন্ট ফর্মেই করতে হবে, কারণ অ্যাপিল ডিসমিস এজ নট মেইনটেনেবল বলেছি, কনসিকুয়েন্সিয়ালি অন্যগুলো বলেছি, এটা জাজমেন্ট ফর্মে। ইয়েস, নেক্সট। None appears for the parties at the time of call. Let the matter stand adjourned for the day. দেখি একদিন দুদিন দেখে নি।
Your Lord, appeal for the appellant, my lord. An application for my lord early hearing.
The appeal is against what?
Against my lord dismissal of a suit for dissolution of marriage.
Oh. Since the present application is for early hearing of the appeal, comma, we do not deem it necessary to direct prior service of notice on the respondent. Most of the appeal has been preferred against the dismissal of the appellant wife's suit for divorce. Full stop. Next para.
Appellant is the husband.
Oh, sorry. Appellant husband's suit for divorce. Full stop. Since there is implicit urgency in a matrimonial appeal, comma, we deem it fit to to pass appropriate directions for early hearing of the appeal. Full stop. Accordingly, CAN 1 of 2024 is disposed of without any orders to costs on the following with the following directions: colon, Roman 1, the appellant shall put in requisites and postal costs for service of notice of appeal on the respondent within a week from date. Full stop. Roman 2, the trial court records shall be brought by special messenger, cost to be deposited by the appellant within a week from date. Roman 3, the appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Roman 4, leave is granted to the Roman 4 দিও না Roman 3 টা আগে শেষ করে দিয়ে তারপরে এমনি প্যারাগ্রাফ করে দাও. Leave is granted to the parties to mention the appeal for inclusion in the list for hearing as and when the same is ready for hearing.
Great.
We'll continue after this. Yes.
I beg to appear on behalf of the husband respondent.
Lord, I am appearing on behalf of the appellant wife. My lord, may I?
This application is for?
My lord, there is two application, my lord. Before my learned friend starts, my lord, I am proposing this. Two application, one is for stay of my lord,
Divorce degree.
Divorce degree, but second marriage has been conducted. I file opposition. They today probably they have filed their reply. Now in between they have filed an application for maintenance, and that maintenance application is required to be heard, my lord. I may be directed to file my opposition and the reply thereto, and both the application may be heard together. No problem.
The application we are rejecting right now.
No,
What
my
is the use of?
No, my lord, that I have to make submission on this point, my lord.
Then we'll hear the stay first today. Yes. What is your submission?
My lord, they have filed an application, affidavit in opposition against the stay application on the last occasion stating that they have married. My lord, my submission on that date was that decree was passed on 5th December 2020 and marriage was solemnized after the decree.
This was the Hindu Marriage Act
special
divorce suit?
No,
Special
it was
marriage.
special
Special marriage act to din na? Divorce obtained on 5th of December 24?
24.
Marriage?
And marriage on, my lord, 24th January 2025. My submission is that it is within the, before the expiry of statutory period of appeal.
There is no sanction in law for that, unfortunately.
My lord, there is. I want to make submission on this point, my lord. And thereafter, they registered the marriage on 13th March 2025 as it appears from the affidavit in opposition filed by my lord.
It was a Hindu marriage, second marriage?
Yes, that is in Hindu marriage. My lord, my specific allegation in my written statement against the Section 27 application that the respondent herein, husband, had marital affairs during the existence of marriage. And it is specifically mentioned in paragraph 15 of my written statement. While passing the decree, court holds, and their application for divorce was only on the ground of cruelty, which has not been proved. It has been gone into the judgment passed by the learned judge. Only on the ground that since my allegation, extramarital affairs has not been proved, it has been held by the court, has not been proved by the wife, that is tantamount to cruelty and decree was passed. Only on this ground. And from the affidavit in opposition filed by my learned friend, it will crystal clear that my allegation was totally correct, because my allegation was that she has the husband has extramarital affairs with one Nobita Das, and in their affidavit in opposition, Navanita Das, and in their affidavit in opposition, they have admitted that they have married that lady. They have married that lady after getting the decree. My respectful submission would be that appeal is the continuation of the suit. 90 days period has not expired. They have married within 50 days of the decree. And my lord, there is a provision in Special Marriage Act, Section 44, punishment for bigamy. That is there, my lord, where it has been held that every person whose marriage is solemnized under this act and who during the lifetime of his or her wife or husband contract any other marriage shall be subject to the penalties provided in Section 494 and Section 495 of the Indian Penal Code for the offense of marrying again during the lifetime of husband or wife, and the marriage contracted shall be void. So my respectful submission would be that since the suit is continuation of the appeal is the continuation of the suit, here it is well within the knowledge of the respondent that appeal period is 90 days. So he can wait for the 90 days, whether the appeal has been preferred or not, whether the appeal has been filed or dismissed. only then he was entitled to marry. Since the suit appeal is continuation of the suit, my respectful submission would be the marriage which has been solemnized by the husband respondent on 24th January 2025 is contravention to the provision of Special Marriage Act. So, and more thing, my lord, this is first appeal. First appeal is right to admission, my lord. So if appeal is admitted, I am entitled to stay. What I have done, I have preferred the appeal within the statutory period. I have filed stay application. What mischief they have done? They have married. So this is the mischief on the part of the husband, not on my client, my lord. I have done what has been permitted by law, I have done. So knowing it fully well, when this act has been done, which is according to my respectful submission illegal, that cannot be legalized by only saying that I have remarried. And my stay should not be blocked only for the unlawful marriage according to my respectful submission, because this was done during the pendency of the appeal. And
yes.
And I have already stated the lady whose name has already been there, he has married to that lady. So it proves my case.
For that, you may have a good case in the appeal. But regarding the second marriage, sections 24 and 25 contemplate void and voidable marriage. Void marriage, if it's in contravention of section 4, it's a void marriage. Otherwise, in certain other cases of section 4 and other cases, voidable.
My lord, after the...
Now, the difficulty is it is section 30 which provides for remarriage.
My lord.
Section 30 unfortunately does not have a sanction.
No.
It says that after leaving the appeal period, either party may marry again. If a person violates that, remarries within that period, what will happen? The effect has not been put either in section 24 or in section 25. If the legislature was intending to hold that is a void marriage for contravention of section 30, then contravention of section 30 would come within one of the provisions of either section 24 or section 25. Since this is a peculiar provision which has been held time and again, that section 30 and similar provision is there in the Hindu Marriage Act also. It's a provision without a teeth, without a sanction. A marriage, if contracted in violation of this, there is no sanction against them. There is no penalty against them. Bigamy may happen only during the subsistence of a marriage, a remarriage occurs. Once a decree is dissolved, a marriage is dissolved by a decree, there is no legal fiction which validates the same, which revives the same, even if you prefer an appeal. But unless you win an appeal and that is set aside. This is one of the few conditions where probably the only situation where a Hindu can marry twice.
But my lord, that decree has not attained the finality, my lord.
That decree attains finality the moment it is passed. A decree attains finality the moment it is passed, unless set aside in appeal. That appeal is that.
The appeal has been prepared in time, my
lord.
lord.
An inchoate decree. A decree definition is rights have been determined between the parties. Decree remains a decree despite pendency of the appeal. And Order 41 also says that mere pendency of an appeal is not even a stay, let alone setting aside. You have to win the appeal for that decree to be set aside, for it to be called that it's not a decree in the eye of law. Otherwise, till an appeal is preferred and allowed and the decree is set aside, that decree is a valid decree in the eye of law. There is nothing in the world which vitiates that decree unless it is set aside in appeal. In the interregnum, if somebody violates section 230 and remarries, it is neither a void nor a voidable marriage. Therefore, we have to recognize that marriage. And if you ultimately, yes, you have a point that your allegation regarding their affair might have been reiterated and reinforced by this marriage of the same person.
That is not true, as well.
Subject to that, that may be an arguable issue, but that we can decide only on the appeal we can decide that, not at this stage. We cannot say that we'll grant stay despite him having remarried, because the stay application has become infructuous by the second marriage. Neither is the second marriage void or voidable. It's a valid marriage in the eye of law. There is nothing in law to prevent that marriage. Section 20 does not prevent that marriage. Section 30 does not prevent that marriage. That
But
is
my
the
lord, Section
difficulty. So
30
stay order, your stay application has to fail. But your appeal does not become automatically infructuous because of the second marriage. They cannot, by their own action, by their own rather unlawful action in a sense, because Section 30 has been violated, they cannot render your appeal infructuous. We'll have to hear the appeal on merits.
My lord, may I, for my satisfaction, may I read
Please
Section 31?
Yes, absolutely.
Where a marriage has been dissolved by a decree of divorce, and either there is no right of appeal against the decree, or if there is such a right of appeal, the time for appealing has expired without an appeal having been presented, or an appeal has been presented but has been dismissed, either party to the marriage may marry again. But here, appeal is there. Appeal has
It's
not
not
been
couched in a negative language that they cannot marry. Even if it was couched in a negative language, there is no sanction for it. If they violate this, show us one provision in any law under which we can penalize them for violation of Section 30.
I am not asking penalization, my lord. I am
The
just
marriage
only-
cannot become rendered void or voidable.
that is after hearing of appeal. But since I
Even after hearing of appeal, that is what we tried to. We wasted 10 minutes on you for this to make you understand this. This is the only situation where a Hindu can marry twice. Both marriages will be valid. So that if you win the appeal, that will be his punishment. Bigamy will be his punishment, not the offense for bigamy. Let him suffer from that if you win the appeal. Yes, Mr. Monique, if you have to add anything to what we said, then only.
Factual aspect, no one can go beyond the factual aspect. The specific averments made by the wife in her written statement that I had a relation with one Nomita at Kalna.
This person is somebody else.
And this person whom
Married,
I
yes.
married is Nobonita Das from Nodia.
So that is Navonita
this
Das.
may be a coincidence, but the same name cannot be said.
Yes, Navonita
No, Nomita, allegation was against Nomita.
Nomita from Kalna, Katwa, and I married Nobonita from Nodia. And this is
address may be same, my lord, but name is the same, my lord.
Address is not same. Name is Nomita and Nobonita.
No, Nobonita, my lord. Kindly come to my lord.
Not
my
Nomita.
Yes. my
Allegation
written
was
statement-
against Nobonita.
Yes, my lord.
Your lordship kindly sees page 4 of the judgment. On the other hand, the wife alleged that the petitioner husband was involved with one Nomita of Katwa, and subsequently they married. This is the specific statement that they married already. This was allegation was made by the wife in her written statement that he had conducted marriage with Nomita of Katwa, page 4, paragraph 3.
Nomita, yes.
Okay.
And not only that, it was not your. No.
It is Navonita.
Once it is mentioned as Nomita, then Navonita.
Navonita, because in my written statement, is it Navonita?
First it
That is-
stated
that is
Nomita,
by-
then Navonita
that
in the
is by-
first.
That is by her sister. Your lordship kindly sees Sagorika Haldar.
But my
Her
written
elder
statement,
sister-
my lord.
On the other hand, wife alleged that the petitioner husband was involved with one Nomita of Katwa. Subsequently, they married. On doc, this witness as well as her elder sister Sagorika stated that the petitioner husband maintained extramarital with one Nobonita of
Navonita.
Katwa.
And that is my written statement
Again, this he states, although it is pleaded in the written statement during subsistence married Nomita, no document or witness. Your written statement, a copy is
Yes,
with,
yes, yes,
it
I have-
says Nobonita.
Navonita.
Because this is the subject matter of Milos.
That is different, but it was not your divorce suit on the ground of cruelty for his
That is true,
extramarital.
my lord. That is true.
Let us dispose of the stay application first. The stay application bearing can 1 of 2025 is taken up for hearing first. Full stop. Heard learned counsel for the parties. Full stop. The appeal arises out of a decree of divorce obtained by the respondent husband against the appellant wife. Stop. Learned counsel, in support of the application for stay of operation of the impugned judgment and decree submits that despite the respondent husband having disclosed in his affidavit in opposition to the stay application that he has remarried after obtaining the divorce decree against the appellant, such second marriage is palpably unlawful. Full stop. It is contended that the divorce decree was passed on December 5, 2024, whereas the second marriage allegedly took place on January 24, 2025. That is much within the limitation period of 90 days for preferring an appeal. Full stop. It is contended that under Section 44 of the Special Marriage Act 1954, the respondent is guilty of bigamy. Full stop. It is further argued that in view of Section 30 of the Specific Relief Act, Special Marriage Act, specifically providing that marriage can only be contracted after the appeal period from the date of dissolution of the marriage, the second marriage allegedly contracted by the respondent is bad in the eye of law and cannot be taken note of. For next para, learned counsel for the appellant further argues that in the appellant's written statement as well as evidence in the court below, the appellant specifically alleged that the respondent husband had an extramarital affair with one Nobonita, who is the specific person which the husband has now remarried, thereby vindicating the allegation of the appellant. Full stop. Next para, learned counsel for the respondent submits that the respondent has now married one Nobonita who resides in Nodia, whereas the allegation was that the respondent had an extramarital affair with one Nomita of Katwa. Full stop. Next para, learned counsel relies on certain observations in the impugned judgment in support of such contention. Full stop. Next para, that apart, it is argued that in view of the second marriage of the respondent husband, the stay application has been rendered infructuous. Full stop. Next para, upon careful consideration of the arguments of the parties, we find that the written statement of the appellant wife contained the name of one Nobonita with whom the husband allegedly had an affair. Full stop. Next para, be that as it may, since it was not the wife's suit for divorce on the ground of such extramarital affair, but merely a defense in the suit, the same can be dealt with appropriately while deciding the present appeal. Full stop. Be that as it may, coming back to the stay application, Section 30 of the Special Marriage Act is not couched in a negative language. Full stop. It provides that where a marriage has been dissolved by a decree of divorce, and in case where there is a right of appeal, the time for appealing has expired without an appeal having been presented, either party to the marriage may marry again. Full stop. However, there is no bar in the said section specifically in negative language preventing a party from contracting a remarriage even within the appellate period. Full stop. More importantly, the said provision is in a sense, toothless insofar as there is no sanction or penalty contemplated for violating the same. Full stop. We cannot lose sight of three important provisions of the Special Marriage Act in the above context. Full stop. Section 4 of the said Act provides for the conditions relating to solemnization of special marriage, whereas Section 24 provides the situations in which a marriage under the Special Marriage Act can be considered to be void. Full stop. Section 25 provides for voidable marriages. Full stop. Next para. Although Section 24 stipulates the ground, sections 24 and 25, between themselves, stipulate the grounds on which a marriage under the Special Marriage Act will be void or voidable, there is no stipulation within the four corners of the said two provisions to the effect that in the event there is a violation of Section 30 and a person marries a second time after obtaining a divorce decree, even within the appellate period, comma, the same would be treated either to be a void or a voidable marriage. Full stop. Next para, section 4 within bracket small a stipulates that one of the conditions of a valid marriage is that neither party has a spouse living. Full stop. The expression within double inverted spouse has a meaning. Spouse obviously contemplates where there is a subsisting valid marriage between the parties. Full stop. With the dissolution of a marriage by way of a decree of divorce, comma, the said divorce decree become binding and the parties, comma, inter se, comma, lose the character of spouses. Full stop. Thus, comma, the present situation does not come within the fold of section 4 within bracket small a of the Special Marriage Act, and comma as such cannot furnish a ground to render the second marriage void under section 24 within 1 within bracket small I of the said act, which stipulates that in case any of the conditions specified in clauses small a, b, c, and d of section 4 has not been fulfilled, comma, the marriage will be severed by a decree of nullity. Full stop. Insofar as the allegation of bigamy is concerned, comma, section 44 provides that every person whose marriage is solemnized under this act and who during the lifetime or his or her তারপর double inverted মধ্যে wife or husband double inverted clause contracts any other marriage, comma, he or she shall be liable to the punishment for bigamy. Full stop. However, comma, double inverted মধ্যে wife or husband double inverted clause indicates a subsisting marriage. Full stop. On the passing of a divorce decree, comma, the marriage is severed and as such the parties do not remain a wife or a husband to the other. Full stop. Hence, comma, the provisions of bigamy are not attracted in the present situation as well. Full stop. Next para. In fact, comma, this is one of the peculiar circumstances where a Hindu person can have two spouses, comma, both marriages being valid, comma, if he or she contracts a remarriage, even during pendency, during subsistence of the limitation period, for preferring an appeal. Full stop. As such, comma, although we find that the respondent husband has apparently violated section 30 of the Special Marriage Act 1954, comma, the same does not render the second marriage either void or voidable. Full stop. As such, comma, there is no further scope of grant of any stay of operation of the divorce decree, comma, since the said divorce decree has already fructified in a subsequent marriage of the respondent husband. Full stop. Next para. As such, comma, can 1 of 2025 is dismissed as infructuous without an order as to cost. Full stop. Next para. However, comma, we are aware of the situation that the respondent husband cannot take advantage of his own wrong in flouting the provisions of section 30 of the Special Marriage Act by contracting a remarriage during the appeal period after the divorce decree which has been impugned in the present appeal, comma, thereby rendering the appeal infructuous. Full stop. Thus, comma, the appeal is very much alive and we shall take it up for hearing at the appropriate time. Full stop. Next para. Can can 2 of 2025 is an application for payment of alimony made by the appellant wife. Have you filed your affidavit of assets in connection therewith?
First time appeal. No, my
We'll give you liberty. How soon can you do that? Your affidavit of assets?
2 weeks.
2 weeks. On the prayer of learned counsel for the appellant wife, comma, we grant liberty to the appellant wife to file her affidavit of assets in support of her alimony application within a fortnight from date. We'll give a date within May 20, 2025.
Not I supposed to file the opposition because I am the husband.
We'll give you that liberty. She has to file first an affidavit of asset in support of her
She
application.
is a housewife. There is
In
hardly
terms-
there is something.
Whatever every asset has to be given. So if she's a housewife, if she does not have any asset, it can be done within a week also.
But she has to come from my letter,
Very well.
Murshidabad.
Then
that is
within
the
May
problem.
20, May 20. Murshidabad is not Murshidabad.
That is true, my lord, but so many problem is with
Well,
her,
May
my
20, we're giving you 2 weeks.
lord.
by May 20, 2025, full stop, a composite affidavit in opposition to the alimony application as well as the affidavit of assets of the wife shall be filed by the husband by June 13, 2025. Full stop. Along with the same comma, the respondent husband shall also file his own affidavit of assets. Full stop. Reply, if any, a composite reply, if any, comma, to the affidavit in opposition of the husband as well as the affidavit of assets of the husband shall be filed by the wife within a week within June 20, 2025. Full stop. The alimony application shall be listed next on June 23, 2025.
Some interim, my lord.
What interim? But first you
Must
file
it
your
be
affidavit of
says
no,
without
no, when
any
we pass the application, when we pass our orders, we'll pass the order from the date of filing of the application.
Oh, interim order has been prayed for as such.
There is no scope of interim order. Now, in view of that judgment, you Rajneesh versus Neha,
Yes, boss.
without affidavit of as both sides have to file affidavits. Otherwise, we don't have jurisdiction to pass an order.
Much.
Yes.
If we are the defendant in the suit, or if the suit was dismissed on the ground that 90
You are the defendant, the suit was dismissed, their suit.
suit was dismissed initially. Now, Lordship, the suit was dismissed on the ground that 2001, the predecessor interest of the plaintiff filed a suit. It was amicably settled and it was dismissed. Now, subsequently raised the issue and Lordship, the learned civil judge junior division straightway dismissed the suit. Subsequently, plaintiff preferred an appeal, first appeal.
No, dismiss the suit on the ground of res judicata.
No, Lordship, the
suit was for declaration of title and injunction.
Title and injunction, Lordship, as predecessor interest filed on the same issue, the predecessor interest filed a suit at 2001 that was dissolved in amicable settlement.
Oh.
Now, subsequently, on the same plots number, the present suit was filed. That suit was dismissed on the sole ground. Now, Lordship, the plaintiff preferred an appeal, first appeal. Now, first appeal, Lordship, the judgment and decree of the Lordship, the learned civil judge junior division has been set aside and Lordship remanded back.
On what? Why was it done?
Remanded back because evidence is required now, Lordship, for determination whether this dismissal order is the 2001
same issues were involved
or not. Now, Lordship, against this order of remand, Lordship, a decree has been passed in the remand. This first miscellaneous appeal has been preferred.
Decree? How can a decree be passed?
Lordship, that is also I have been confused. Lordship, kindly come to my second appellate court judgment and decree. Decree হয় নাকি?
Order 9, Rule 9, not a compromise decree.
But it was a compromise, Lordship.
How does Order 9, Rule 9 come in?
Lordship, kindly come the TS 1981 passed by the learned civil judge junior division first court Rampura, where learned court dismissed the suit as not maintainable in the law. Now, Lordship, kindly come the next paragraph. Present appellants being the plaintiff filed a suit for declaration of permanent injunction against the present respondents. The respondents number 1 to 5 as defendant contested the
Come
case.
to the next page. Based on the pleadings of both sides, page 2, second paragraph. Based on the
185 of 2001 against the predecessor of since the dispute was amicably settled between the parties, suit was finally dismissed for non-prosecution.
So it was dismissed for non-prosecution.
Non-prosecution.
Amicably settled. It was not a compromise decree.
Amicably settled and this suit was dismissed.
No, there's a difference, huge difference. One is under Order 23. This was not an Order 23 suit. The parties said that we have amicably settled, but that was not made a part of the decree. then it would be order 23.
Yes. Order 23.
Whatever might be the reason, the plaintiff came and said that we have settled, I don't want to proceed with the suit. Suit was ultimately dismissed for non-prosecution.
Now,
Since the dispute was amicably settled between the parties, the suit was finally dismissed for non-prosecution.
yes, yes.
Now, the reason for non-prosecution, the plaintiff not proceeding, is not germane. Just because they say that there was an amicable settlement, it's not a compromise decree under Order 23. If it was a compromise decree, then the terms of settlement had to be a part of the decree. This was not a Order 23 decree. Suit was dismissed for non-prosecution. Reason, plaintiff said, I don't want to proceed with the suit. Amicable settlement or otherwise, or something, some other reason. Ultimately, it was dismissed for non-prosecution. That's why appeal court applied Order 9, Rule 9 and said that. But ultimately, you were right. The appeal court remanded the matter.
Remanded the matter, Lordship, with the decree.
Court is required to examine factual aspects going into evidence of both sides, particularly whether cause of action was identical. As a result, but ultimately in the ordering portion, court says the impugned judgment and decree is set aside. Learned court below is directed to proceed with the case as per direction. Decree is wrongly drawn up, we'll say that. It has any office report has been given, or our stamp report has given in defective report. The classification of the appeal in words being erroneous calls for rectification, bereft of the name. Acha, name of learned trial judge, please put in. That will direct you right now.
Now,
How soon
Lordship,
can you do?
there are presently three applications before your Lordship.
Your classification should be not memorandum of appeal from appellate order, but original order, because this was an original.
Yes.
Previously, it was a decree. So for the first, just will grant your learned advocate. Do you know the name of the learned trial judge?
Lordship, yes.
It is there in the judgment. Certified copy. Probably no. How soon can we ascertain? Trial judge's name?
That's why I will.
No, how long will you take?
I will collect that before three applications before your Lordship. One is one of the appellant has expired. That is Dost Mohammed. Kindly can number 2.
Can 2, yes.
Can 2. That's the appellant Dost Mohammed expired.
You will have to prove your pleading. You have said sudden death. You have to prove that it was not a gradual death and not. Why do you put in these unnecessary things in a sudden death of unfortunate demise of
3rd September 20.
this person? This is within time.
No, Lordship. There is a delay. I have stated the delay.
What is the
520 days delay.
520.
5 days.
Serve copy then. Come back.
And Lordship,
Serve copy of all the applications on the response so that we can dispose of lock, stock, barrel on the next.
Lordship, so far can 3 is concerned, Lordship, I am withdrawing this application because I have under impression that there is a decree.
No. Can 3 of 2025
withdrawing
is dismissed as withdrawn. To sub next para, we find that by its very nature, the impugned judgment was a judgment of remand, and as such, no decree could have been drawn up. Full stop. Hence, the decree drawn up by the first appellate court is erroneous. Full stop. The impugned judgment, being a judgment of remand, is to be deemed to be a judgment and order and not a decree. Full stop. Hence, the present appeal has been rightly classified and numbered as a first miscellaneous appeal. Full stop. Leave is granted to the learned advocate on record for the appellants to rectify the caption of the memorandum of appeal to the extent that the same has to be described as a memorandum of appeal from original order instead of appellate order. The appellant's the learned advocate for the appellant shall also delete the redundant words in the title of the memorandum. This number of 2017, this you have to remove. Here. Yes. You know. Everything else will go. Memorandum of appeal from up to that it will remain. Appellate will score through. You will put in original order. And this number of 2017 also has to be deleted. The name of the learned trial judge shall also be incorporated in the preamble of the memorandum by the learned advocate for the appellant within a week, Mr. Mukherjee. Within a week from date, full stop. Next para. Can 2 of 2025 is an application for substitution of the heirs and legal representatives of appellant number 2. But you have not filed, not prayed for, oh, in this it's a composite application. You have not asked for condonation of delay.
Yes, yes.
You asked for setting aside abatement only. How the delay is of how many days?
520 days. Lots of the last page 11 last.
Page
Also
11
pray for-
last. Yes.
Also pray for condon the delay of 520 days.
Achha, Can 2 of 25 is an application for substitution of the heirs and legal representatives of the deceased appellant number 2 upon setting aside abatement on condonation of delay. Full stop. The appellants shall serve copies of the said application on the respondents, indicating that the application shall next be listed along with the appeal under the same heading on May 20, 2025, when an affidavit of service shall be filed by the petition, by the appellant. On the next day, it will appear under the same heading, Order 41 Rule 11. You will file that affidavit of service. We will first dispose of this substitution application, then take up the appeal for Order 41 heading. There is a stay application also. What is the number?
Can 1.
Acha, only the jekhane na shall serve copies of can 1 of which year? Can 1 or can 2 দুটোই serve করবে?
2070. Can 1 of 2017.
2017.
1 to 1.
Oh, serve copy of said application বলছি। না 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 said application বলছি can 2 তার আগে তার বললাম না can 2 has been filed for of the said application along with can 1 of 2017. Yes. What happened, Mr. Mukherjee?
So 20th lordship. I don't know lordship. Can we change lordship there?
What?
I will be out of station.
For some very personal reason, your smile is very.
Lordship, I have brought ticket. I don't know whether I am able to go the outside.
Why Kashmir?
Lordship.
Why don't you know whether you'll be able to go?
This situation, lordship,
Actually, Kashmir. Go there. This is the right time, Mr. Mukherjee. Security will be beefed up. Costs will be less. Nobody to disturb you. This is the best time to go to Kashmir.
If the war starts, lordship,
Go there. Go there. We'll keep it on some other day. 20th. When should you keep it? Tell us.
June, in the month of June.
May 20 na kore June 10, 2025. This is the best time to go to Kashmir. At 20th, by that time the security will subside a bit. It will be well protected, cheap. People will be welcoming you. Nobody to disturb you. Go there. Go there. By all means. Next matter. Yes. 34 who is appearing.
Lord, 34, I am on behalf of the appellant, Lord.
Yes.
I am led by Mr. Learned Senior Counsel, Lord, Arenbag, Lord. I am praying for not to my Lord.
How long are you practicing?
2 years, Lord.
Move the matter.
Lord,
Start the matter. Start the matter.
My Lord, I
No,
tell you,
we'll
Lord,
dismiss it.
difficult is the matter, Lord.
You'll have to start.
Lord,
Sorry,
in this matter, Lord, earlier what happened, Lord, before the suit court, Lord, in Sirampur Junior Division, Lord, order for injunction was passed in favor of plaintiff, Lordship, and that order was challenged before the first appellate court, Lord, and that order was set aside, Lord, and subsequently, Lord,
No, the suit was for injunction only. Injunction suit.
suit for it was also eviction suit, Lord.
You are the defendant.
I was a plaintiff over there.
Acha, your eviction suit was dismissed by the trial court.
Yes, my Lord.
You preferred a first appeal.
No, defendant placed a first step.
Then you got a decree of eviction in the first in the suit.
Yes, my Lord.
On what ground?
Lord.
So that first appeal has now been allowed. Against that, you have preferred this challenge.
I have challenged the first appeal. My Lord, what happened in this matter earlier? There was an advocate record, my Lord. The matter came up for hearing, my Lord. He didn't appear. That's why it goes out of list, my Lord. And subsequently, my Lord, I got the brief, and I have been given the Bhokalanma new. I got the power.
Very well. You are Mr.
I'm Sheikh Mohammad Wasim Akram. My name is
Mr. Akram. You just go through this. There is a report of the stamp report. You will find it on the reverse of the first page of the memorandum. You will have to rectify. You just take down these defects. These have to be cured by you.
My Lord.
There is some superfluous classification in the appeal. take help of somebody and just rectify these defects. We'll give you a week for that.
Within a week, my lord.
Within a week, rectify
My
the
lord,
defects.
grateful, my lord.
We'll give it next week.
About on, my lord.
We find that there are several defects in the appeal. Full stop. The learned advocate for the appellants is directed to remove such defects by the end of this week. The matter shall next be listed on May 13, 2025.
Grateful.
Yes.
May please, Your Lordship.
Yes, Mr. Miller.
There is a section 5 possibly that has to be heard by the single bench, possibly subject to correction.
We treat it as an application in connection with order 41 and allow it. So we allow that?
We have prepared an affidavit in opposition to that. So may I file it here?
Then we'll allow it all the more.
The section 5 is filed after 6 years.
Only
Appeal
6
filed
years?
to 2019. Section 5 filed in 2025. In the meantime, 3 applications allowed.
Socio-economic condition of the appellant. That's
But
it.
in the meantime,
good
3
ground.
applications allowed.
Three
Without the
applica-
section 5.
Substitution.
Substitution and setting aside of abatement all have been filed in connection with the appeal
No.
without
Substitution-
filing section 5.
Section 5 also, in the section 5 also, substitution also operates in respect of the section 5.
But that
Can a
is-
section 5 order be passed in the name of a dead person?
I understand. but-
Substitution has to come first, rightly done. Whoever did it, rightly.
But
Despite your criticism.
my submission is that the appeal was filed in 2019. The can for substitution was filed in 2024.
For can,
For substitution.
you mean to say 137 comes in?
Possibly because because if the section 5 is filed after 6 years, then what remains of the
The
appeal?
appeal was filed
In
what was the
2019, there was a delay of 130 odd days in filing the appeal. But the section 5 file
Yes.
is after the applications were allowed. Section 5 in connection with the appeal is filed after the applications.
They need not explain the delay in filing section 5. Section 5 needs to explain the delay in filing the appeal. The appeal is pending.
The appeal is
In a
pending.
pending appeal, they have filed a section 5.
But in the appeal, that appeal was not borne because the delay was not condoned. So
Now it will take its what? 130 days delay. What is the explanation? Socio-economic condition. What do you do?
This was my file by my
Any
father.
supplemented affidavit? No. What is the explanation for the delay, Mr. Medra?
The explanation, my lord, I'll be honest, my lord, it was filed by my father, my lord, who passed away during the COVID time. And my lord, my socio-economic condition is bad.
No. When your father filed this, it was already delayed.
Yes, I do not know why there was a delay on his part. So it's a little difficult for me.
You have not read your section 5, Mr. Medra.
No,
You have not read your section. Say paragraph 5, you have
Yes,
not
yes.
read.
I came to know about it recently.
What
That
you came to know? Read
paragraph-
paragraph 5.
Yes. That the appellant has been advised by the learned advocate
This
engaged on their behalf by the
is a
High Court.
legal aid matter, probably.
Yes, it is. It is.
That is the first ground.
It was not a legal aid matter initially when it was filed. Now it is a legal
Your
aid
father, your father died when? When was the decree passed?
Decree, my lord, was passed in 2019.
Decree was passed in the name of a
Fa-
father.
husband, possibly. That's not
Sorry, husband. I stand corrected. Husband.
This is a very dangerous concept.
There's a daughter also involved, which is why I said father by mistake.
So now we are confused. Your husband was the original. He suffered the decree.
He suffered the decree. Yes.
It was passed in the name of the husband.
Yes, right. Husband was alive then. Husband filed the appeal.
Yes.
So what was the explanation for the husband filing late?
Husband filing late, my lord. For me, my lord, as the wife after his
No, no.
death to
You
explain.
have to give an
My lord,
explanation.
the
He's right on that.
I have given, my lord, the explanation that I was not conducting the case. I was not aware.
No, your
and upon-
explanation won't do.
And upon
You have
being
to
ad-
explain why the husband filed the appeal late. Otherwise, there is no explanation. Your conduct came only after the demise
Yes,
of your
that's right.
husband.
That's right. That's right.
So at the inception, your husband has filed this appeal.
That's right. That's
And
right.
husband passed away on 10th of July 2023.
Yes.
So that is much beyond 3 years after the date of filing
You are
of the appeal.
stepping into the shoes of your husband. So if your husband's appeal is time barred, you suffer for that.
No, sir.
This is no explanation at all, sir. There is no explanation at all for that delay.
May I then be permitted to file a supplementary affidavit?
The
my lord?
first question we asked
I know. I know.
on the prayer of learned counsel for the appellant is granted leave to file a supplementary affidavit within a fortnight from date with an advance copy to the learned advocate for the respondent. full stop, all questions regarding maintainability of the application for condonation of delay are kept open for being
May I file the
argued at the
affidavit in
time of final
opposition?
hearing of the same.
I file the affidavit in opposition to the section 5.
You can file it, or you can file a composite section 5.
No, or composite file.
The respondent shall file a composite affidavit in opposition to the application for condonation of delay, as well as the supplemented affidavit within June 13, 2025.
Could I get 2 more days? Just 2.
June
15.
June 15 is, you'll get Saturday and Sunday. June 16, 2025. Reply, if any, shall be filed by June 23, 2025. The applications shall be listed for hearing. The pending applications shall be listed for hearing on June 24, 2025.
That may I get some protection? At least even my learned friend's undertaking will suffice for me.
The challenge is against what?
The decree for eviction. The bailiff has been ordered to hand over possession. That is my only concern, my lord. Otherwise, my lord, I can expedite my filing of the supplementary affidavit.
Do that.
I'll file it within 2 days, my lord.
Very well. তাহলে পুরো টাইমলাইনটা চেঞ্জ হবে.
If my learned friend agrees, my lord, that's no problem.
No, he's not agreeing. Because he's taking a serious point. Your appeal is.
I agree.
And after 6 years, you come with an application. You also have to consider whether 137, Article 137 of the Limitation Act is applicable to a Section 5. Please come prepared on that also. Otherwise, you just have to explain. Even there are instances where on oral prayer we can also condone. So it is probably not applicable, but we'll have to think out a way. You have to think out a way out of 137. And Mr.
But I'll tell you, Lordship, why I'm opposing.
Gupta, you also think
the appellant was alive till 2023 July. The appeal was filed
apart from
2019.
that is one of the reasons why he's filing the supplementary affidavit. Apart from explanation for that period, he has to fund that is the first thing. Secondly, whether this application, whether Article 137 of Limitation Act schedule applies to a Section 5 application. And if so, when is the cause of action? When you file the appeal or what?
I'll try to do
That think in that line also and come prepared on that also. Both of you. তাহলে ওই যা বললাম তাই, শুধু সাপ্লিমেন্টারি এফিডেভিট উইদিন 2 weeks বলেছি, না বলে বাই May 8, 2025 full stop, composite opposition যা বললাম, do it within a week then.
I'll do it by the 14th. I'll not even take a week.
Excellent. Within May 14, 2025 full stop, the application shall be listed. Reply, if any, shall be filed on the returnable date. The applications shall be listed next on May 19, 2025. So by 8th, opposition, supplemented affidavit. By 14th, your opposition. By 19th, which is the returnable day, they file that reply. They'll file the reply on the returnable date, but give an advance. Yes. 19th, we are taking up this matter.
Grateful, my lord.
Thank you.
But I am for the apple.
Yes.
But I am the defendant number 1 and 2 in a suit for partition. The partition suit was dismissed. As against that, there was an appeal that the appeal court had remanded. So, the scope of this appeal is whether the remand should have been proper by the appellate court or not.
Open remand.
Open remand. Now, dear Lordship will kindly have a look at the finding by the
You are going by order 14/24.
Lordship. There was a evidence by the PWs 1 to 3 and the DW 1 to 4 also adduced evidence. These evidences are all on record. Apart from that, the documentary evidences are on record by the trial. The trial court was of the opinion that the suit cannot proceed because there were the common vendors of the parties who were not arraigned as a party in the partition suit. Therefore, it was for non-joinder of party. That was one of the reasons. Then there was no prayer for recovery of possession, also because that the possession was not with the plaintiffs. That is proviso to section 34. And it is also held by the trial court that since the plaintiff claimed that they have purchased a demarcated portion of 99 decimal, therefore there was no cause for a partition. So these are the 3 points on which the trial court had dismissed this. Now, my lord, if your lordship will kindly come to, my lord, the reasoning given by, my lord, that
You are
appeal
you are
court.
the defendant.
I'm the first and second defendant in the partition suit. Number internal page 8 and 9 of the appeal court, my lord.
But Mr. Mukherjee,
My lord.
in this case, if the suit was dismissed on those grounds, those are all virtually technical grounds. So there was no adjudication by the first forum. If the appeal court assumes that jurisdiction, yes, you are right, order 41/24 is applicable. But although that would be the first forum virtually, both of you lose a forum of appeal. If there was an adjudication on merits by the trial court and then there was some lacuna and it was remanded, then if the evidence was sufficient, court could have done it. But here it's a question where the first court, the court of first instance, did not adjudicate on merits at all on any of the issues, relevant issues. So if the appellate court assumes that jurisdiction, then it will be a, I mean, it will be an illusory, not illusory. I mean, you lose a forum.
But I understand what is falling from your lordship. But may I just indicate, my lord, the salient points of the trial court and the appeal court first? My lord, in the light of my lord's observation, my lord. But your lordship will kindly.
Why don't you even, if you go back to the trial court, you will have an adjudication on merits then. If it's an open remand, why was it remanded? Because those defects were corrected by them.
No, my lord, all those points were not taken by, my lord, the first appellate court.
Oh, then
first appellate court ought to have seen, my lord, whether the evidences were sufficiently there on record for the appellate court to decide, my lord, the points that have been taken by my learned friend in appeal. Now, my lord, your lordship will kindly first come to, my lord.
You are speaking about the evidence regarding these non-joinder and these points also.
Lord, about, Lord, whether, Lord, it is a partiable property or not. Because, Lord, the first of all, Lord, one of the issues, Lord, that the trial court said that the property is already partitioned because the purchase was by metes and bounds.
Yes.
So, Lord, that was
also not adjudicated by the appeal court.
No.
Achha.
I'll just not indicate before your lordship.
No, if the questions on which it was dismissed, those were also not adjudicated despite there being, those had to be.
The first appellate court, Lord, the observations are at page 8, 9 of the appeal court. But prior to that, Lord, may I just indicate about, Lord, the internal page, Lord, 6 of, Lord, the trial court, your lordship will find the trial court has not evaluated the evidences. Now exhibit 4 is the purchase deed and all this thing. Lord, I'm just taking your lordship schematically.
Trial court which page? Sorry.
Lord, internal page 6.
6.
Lord, it starts from the decision with reason. Starts from previous page. I'm
just place the relevant portions.
Now the exhibit 4 is the purchase deed. Lord, these are, Lord, the observation. Real controversy lies.
How can Mr. Mukherjee? You need not go to the, because this is as a matter of course questions of fact and law are involved. So we'll have to admit this appeal ultimately.
True.
So
True.
Just satisfy us prima facie for the grant of stay.
So, Lord,
let us see the appeal court's order first, judgment first. 4th April 2023.
Lord.
Just see. Several documents.
Lord, the findings of the appeal court is at page 8.
Yes, court below not having not even applied.
It is a specific case of the respondent that they are in possession of the entire land from that portion. Heard the argument advanced by both the parties, and the admitted part remained that Indubala Ghosh is the owner of 8.42. Thereafter, my lord, how it had devolved. Delivered possession. Defendant is also a co-sharer in plot number purchase 1.31 acre of land from Shankar Prasad Ghosh, who purchased the plot from Shourendra Bishas. That Shourendra purchased the entire land of the same Amulya Ratan Mahapatra by a later deed. At the time of second sale, Amulya had only 0.52 decimal in his title and possession. The court below admitted the existence of both the deeds of the parties, but failed to ascertain the fact of co-shareship. The suit land as sold is a defined and demarcated portion. There is no need to include the co-sharers of the land exceeding 1.51 acres of land, because the original land was 8.42. The defendants by later deed obtained the left portion of the land as it is available. the judgment, yeah, such and such is not maintainable. Here, as the court ought to have offered the plaintiff to establish the position. The court may not try to make out a third party case by
Even those points were not decided. Mr. Srivastava, why don't you agree to the demand to the appellate court? Let the appellate court decide.
Other division bench, earlier division bench said that we'll hear out the appeal and dispose of the matter.
We have heard out the appeal. Why don't you agree to a remand? This is the entire scope of the appeal because the appeal court has decided nothing.
Nothing, yes. No, what the appeal court,
It was your appeal actually.
Yes.
So nothing has been decided, again remanded. You will also suffer. If it is done in the appellate court, then
No.
why keep it pending before this court?
No, I don't want to keep it pending.
Hmm.
It will go to the trial court or to the appeal
That
court.
is the only thing.
point.
Yes.
I'm modern.
Yes.
Your Lordship, the truth was that on the ground of section 34, that I have not made a prayer
Yes.
for recovery of possession. Your Lordship, the plaint or the prayer is to be judged on the averments made in the plaint.
There's a Supreme Court judgment in your favor, Justice Aniruddha Bose.
Yes.
Which says that at the inception, you cannot say 34
Yes.
proviso comes in.
Because
if it's subsequently discovered that it's...
then I'll get the opportunity.
You will get the opportunity.
That opportunity was not given. That is why it has been sent back to the trial court. To give me the opportunity and to decide the matter.
Is that stated here?
Yes.
You could do that before the appellate court itself.
Yes, that is what I say.
You could, Mr. Srivastav, you could just implead the left out parties for abundant caution.
No.
And in
the other point on which the trial
non-joinder.
court, that the common vendor was not.
Yes.
The defendant had deposed, he is dead.
So that has nothing has been considered by the appellate court.
And the trial court also did not consider anything that he is dead. The evidence.
But the evidence is on record. That is what we are saying.
Yes.
So Srivastav,
And with regard to possession, Your Lordship, he is saying the trial court has held that I am not in possession. But my evidence is in the averments made in the plaint, I say I am in possession. He is threatening to dispossess me.
If that evidence is there.
And in the evidence, I say that at present I am not in possession. So during the suit, I have been dispossessed. So the question of what I have made prayer in the plaint.
Yes, Mr. Srivastav, we get your point. So you all 3 points on which the suit was dismissed, you have good grounds, good arguments. But since whatever you submitted before us, from that also we can gather that the evidence was there on record. You preferred the appeal because the trial court did not consider this at all. So if these were overlooked by the trial court and the evidence was there before the appellate court, why shouldn't Order 14 Rule 24 apply? To cut short the matter, the appeal court, let the appellate court decide all these issues.
And Your Lordship will...
And hold that this trial court is wrong if it goes in your
what I'm submitting humbly, Your Lordship. If further evidence is required, kindly give me the liberty to the parties to adduce. On the basis of the amendments I'll make.
The evidences were adduced by plaintiff number 1 to 3.
You yourself argued, Mr. Srivastav, that sufficient evidence is there on record.
There is some evidence on record that was not considered by the trial court. But what I'm submitting, I'll have to make a petition for amendment of the plaint.
But that liberty has not been given in the remand order.
No. It is an open remand.
Open, right.
It's an open remand.
Yes.
So I'll take the steps that the appellate court has held that these are the opportunities were not given to us.
But does it hold so? Just shows that.
Yes.
Yes, if necessary by way of amendment.
Yes.
Page 9.
Yes.
It is the duty of the court below to give proper scope to the parties if necessary by way of amendment, right?
Justice is to be done. It's not that
True,
on technical grounds.
No, you're right. Amendment, if necessary by way of amendment or survey of the cause schedule or the prayer. Achha, yes.
For that reason, it was an open remand.
Yes, Mr. Mukherjee, we rather like to agree with Mr. Srivastav on this technical ground. I mean, even if there was no prayer for recovery of portion, it could be permitted by way of amendment.
But this blanket observation of the appeal court that they should be permitted to amend and thereafter
it's right if two of the grounds are that recovery of portion ground is not there and
But let them not take the amendment, whatever that is there before the appeal court. Appeal court will decide not on the basis of what that is there on record.
Then evidence.
Evidence there are evidences of not at least 3 not the plaintiff's witnesses and 4 not the defendant witnesses on record. That is always there. If he requests not any other evidence not to give for betterment of his case, not your lordship will put that liberty before the appeal court. Either the appeal court may take that evidence or may not for the limited purpose not ask
Because
the trial
appeal
court
court
to
held
record
that
and
if
send.
necessary way of amendment or survey of the cause schedule,
Yes.
which
Further
is
survey is
rather
required.
justified. Rather justified. Amendment at least is very justified because
No, Advocate Commissioner, your lordship, my suit was for partition and also for demarcation. So for demarcation, survey pass commissioner is required to be appointed.
But then
So that follows not after the decree is passed. But now the suit was dismissed.
Demarcation, your lordship.
No, that is in the final partition degree stage when the demarcation is called for. Prior to that,
the
the
partition has
affairs of
not.
the party.
You have this is a partition suit. Oh, you have asked for
partition and
Alright,
demarcation.
But this is at the threshold, it was not dismissed.
Then Mr. Mukherjee it should go to the trial court because there will be a preliminary decree, there will be a final decree if they get a preliminary decree. Then how can the appeal court does not have the wherewithal to do this? Then if they win the appeal, then this will be a preliminary degree and it will then go to the trial court.
Honest Lord, I being the defendant, I am benefited by if it goes to the trial court.
Yes,
But
precisely. Precisely. We'll
But
dismiss your appeal under order for
trying to give a quietus, my lord. If the appeal court decides, my lord, then
Mr. Mukherjee, in a partition suit, I actually forgot, not my brother, that it was a partition suit. So if it's a partition suit, it has to go back to the trial. It has to go back. Otherwise, it will be unworkable if a preliminary degree is passed. Let us dismiss your appeal under order for Rule 11. So that will cut short all these problems. It is appear under order for Rule 11.
Lordship.
So we'll.
But if it was before the appeal court, my lord, subject to what my lord says, my lord, let them effect, my lord, an amendment to the plain.
Suppose they do that.
Lordship.
An amendment is made, this cost schedule, everything is done. This cost schedule, because survey of cost schedule property, if that is done, that will be a new evidence.
Kindly have a look at, my lord, what the appeal court says at page 9. If necessary by way of amendment or survey of the cost schedule on the prayer of the party with the eye of proper adjudication. Therefore, Lord, on this, if it is a question of Lord, a survey, an amendment is not even necessary. Kindly have a look at Lord, how at paragraph.
No, not only a question of survey, survey on the other points also, the non-maintainability because of this recovery of
Court
person.
may not try to make out a third case by travelling beyond the A schedule. It is the duty of the court below to give proper scope to the parties.
Mr. Mukherjee,
If
frankly
necessary
speaking,
by way of amendment or survey of the cost schedule on the prayer of the party with a view of proper adjudication of the justice.
Yes.
And the cost schedule is 1 acre 51 decimal. So it is nobody's case whether that particular the schedule has to be not inspected as of now.
No,
but even if we go by how the appeal court has disposed of the appeal, this is unworkable in my respectful submission.
No, the dispute
Now,
is your
let
lordship,
me specify in what manner that he wants an amendment of the plain to be effected. Because going by the appeal court's dicta, it is unworkable. It is not necessary at all.
Your lordship, the dispute is that I purchased in 60. The plot is, your lordship, court schedule plot is 1.51 decimal. Now what happened? I purchased by a registered deed from the owner 99 decimal. The balance 52 decimal he'll get. He can't get more than what his vendor had at that point of time, which was because his purchase is subsequent to my registered deed. The dispute is.
Mr. Mukherjee, there is nothing in the trial court judgment.
But,
You have seen the trial court judgment.
At least it is a bit better than the appeal court.
No, we respectfully disagree. Trial court says that he has filed a partition suit. Instead, he should have filed a declaratory suit and a recovery suit, recovery of person suit. Partition suit includes both.
He did not consider that at the point of filing the suit. Your lordship, my averment was that I am in possession, I have been threatened.
রাজা চ্যাটার্জি কে কি লিখেছিস পার্টিশন শুট করেছে তো দেখো ডিক্লারেশন টাইটেল আলাদা করে চাইবে রিকভারি চাইবে তো অ্যালটমেন্ট হলেই তো হয়ে যাবে Mr. Mukherjee, the trial court was pathetic. It's section 34. Partition should they have not paid for. Partition should they have not asked for recovery portion.
For that reason, the appeal court could have done it. But the
No.
appeal court's reasoning, your lordship,
No.
sees blood at page 9.
Open remand ultimately, whatever be the reason. And appeal court doesn't deal with it. We could have, you are right, appeal court should have decided, but decided in their favor. And remanded, no amendment of plaint is necessary, Mr. Srivastava. Why do you require an amendment of pleadings?
No.
We can hold from here, see, we can give this solution. We can hold from here that amendment is not necessary. Because in a partition suit, you need not separately ask for declaration of title or pray for recovery of portion. That portion we can clarify from here, one.
Yes.
Secondly, this cost schedule property partition, this survey, why is a survey required in a partition suit? No necessity. Preliminary degree court will only declare the shares of the parties. Then partition commissioner will go and, as Mr. Mukherjee rightly submitted, then partition commissioner will go in the final degree proceedings and then have a survey.
No,
In any way, we have a survey.
in the plaint, I had a alternative prayer,
Yes.
not alternative prayer. One was partition or demarcation.
Alternative prayer is not necessary. Partition itself is sufficient. Demarcation cannot be does not come on either under section 9 of the Civil Procedure Code. There cannot be a suit for demarcation only without any. It can be consequential.
Yes.
Mr. Srivastava, you know from both sides. You know from both sides. You are the culprit here, not your learned friend. Suit for demarcation. It's under section 9 of the CPC or section 34? Let it, we'll say from here that no amendment is necessary. Partition suit is very much maintainable. Mr. Mukherjee will hold that. We cannot help ourselves. Partition suit is maintainable. It is not barred by section 34 for not claim.
Milord, I also do not support the trial court's.
No, particularly, I mean, so we'll hold that in a partition suit, separate prayer for declaration is not necessary. Recovery of portion is not required to be paid for separately. So section 34, it is not barred by section 34. But then what do you do, Mr. Mukherjee, if you say that even then the preliminary degree has to be passed?
But
appeal court will do what? Pass a preliminary degree and then a final degree by appointing partition commissioner, Mr. Mukherjee.
But appeal court can very well not declare the share of the party.
But we are afraid of this only because in your appeal virtually it will be like
no, it is their appeal. I was a different.
Here before us.
Yes.
In your appeal, they will get an advantage because we will be setting aside the trial court decree and they have not preferred an appeal. But order 14 rule 33, we can look into anything. In your appeal, we can look into that. But that will take care of the entire issue. I mean, you want to cut short the matter by sending it to the appeal court. If you send it to the appeal court, Mr. Mukherjee, appeal court can at best, I mean, what will it do? If it holds
based
in
on the evidence, can not declare the shares of the parties.
And
yes.
then again, it has to go to the trial court.
It has to go back to the trial court for a lot.
So that would be a futile exercise then. We'll give these reasons and dismiss under order for 20. No, under order for 20 we cannot because we cannot say these things then.
Your Lordship will dispose of them.
We'll dispose of the appeal.
Dispose of the matter. Final disposal.
Because the observations might prejudice Lord.
Even if we dismiss this, we have to give those observations.
So that will be only confined to the observation of the appeal court that appeal court was justified in remanding. But if your lordship goes into Lord the propriety of the trial court's order, in that event, in any event, Lord, the appeal court has already Lord set aside the order of the trial. That has been done by the appeal. Now, if your lordship says that it was rightly remanded, Lord,
but amendment, it has directed amendment.
Yes, that portion your lordship.
That portion your lordship will do what?
Will kindly
if you don't find some it's we'll have to give some observation. I mean, this is
appeal
You have preferred this appeal against the appellate courts. We will allow your appeal and do whatever. We are allowing your appeal. Setting aside the appeal court's judgment, its entirety.
Your Lordship, what about the trial court?
Remanding to the trial.
Yes.
No, but we'll have to make these observations. Mr. Mukherjee, take instruction.
I have taken instruction, Lord.
We'll have to hold that this trial court is.
I also do not agree, Lord. To be very honest.
Cannot be. I mean,
the three observations, Lord.
We hope this does not go to any further court. I mean, with these observations.
But I would rather, Lord, let me take instruction. I would rather say, Lord, that I should be, Lord, withdrawing the appeal. That will solve the entire purpose, Lord. My learned friend doesn't want an observation to come from the Lord, the superior court.
You should have preferred an appeal. You had preferred an appeal. That no, against the remand order also you should have preferred an appeal, saying that that would be a second appeal, because that would be a judgment of affirmance. Take instruction whether you will withdraw the appeal. We'll keep it next week.
Wednesday, Your Lordship.
Wednesday, very well. Wednesday.
Next week.
Next Wednesday.
Wednesday week.
Wednesday week.
So Wednesday week.
14th.
14th.
After the matter was taken up for hearing under Order of Rule 11 of the Code of Civil Procedure, it transpires that certain further instructions are required by learned senior counsel for the appellant. So accordingly, let the matter stand adjourned till May 14, 2025.
Agreed.
Under the same heading.
Yes, the same. They should have prepared an appeal. You should have prepared an appeal. We'll take up both together and do whatever we would like to do. Now it's too late. Time but
Wait, section 5, Your Lordship. That is there.
do it.
Lordship, plaintiff is the appellant here. Lordship, trial court decreed the suit in favor of the appellant. The first appeal preferred by the.
What was the suit for?
Suit for declaration of share.
Declaration of your share only.
Only.
Share is
two plots of land.
Did not ask for partition.
No.
Why was the suit dismissed?
This suit was allowed.
Oh, decreed in your favor.
Degree was in
declaration without any consequential relief. Is barred by section 34 proviso then.
Well, Lord, kindly see what is relief granted by the trial court.
Let us see that.
It is hereby declared, page 12 of the degree.
Achha.
It is hereby declared that the plaintiffs have right, title, and interest in respect of 1/3 share upon the schedule.
No, not page 12. Trial court's decree is. Oh, sorry. We are looking at the appeal. I was looking at the appeal court. You have put the trial court degree later.
That is not properly.
Very well, no difficult.
12, my lord, page 12. It is hereby.
Yes, you're right.
It is hereby declared that the plaintiffs have right, title, and interest in respect of 1/3 share upon the procedural property. And procedural property. That is the 2 plots of land.
Achha, very well. Oh, you are also asked for injunction.
Yes, declaration and injunction.
What was the counterclaim?
The counterclaim was the partition.
Why was it dismissed?
Claim was dismissed.
On what
defendant's claim was partition.
Rightly.
That was dismissed by the trial court. So in this suit, you cannot seek partition of 2 plots.
You should have conceded to their prayer. You should have conceded to that partition. That would solve your issues. Because you have got a decree of declaration of your 1/3 share, and God knows what you will do with that injunction.
Well,
how can you enforce the injunction?
Not all properties. The defendant brought on record to only 2 plots of land. That's why partition suit was.
Oh, achha. They are not co-sharers in respect of the entire property.
Entire property was not brought
No.
into record.
Acha, that was not brought into the hodgepodge.
My lord. That's why that was.
But then your suit is also not meant. How can you claim choose a particular portion of the joint property?
My lord, that only those two plots of land there was trouble. That's why. Other plots are they are amicably settled.
How did the appeal court deal with it?
Appeal court found that it is a matter for the Land Reforms Act. There the authorities there. They will correct the record. All right. My lord, kindly see.
Both the trial court and the appeal court are on equal footing. Both are equally
Page
good.
12, same page 12 of the appellate court judge. It is clear from the plain that.
Yes, it is clear from the plain. No relief.
That there is no relief sought for regarding declaration of erroneous entry.
The entry was erroneous.
That is not the case before the trial court.
But we don't understand this. There were those, apart from those plots, other adjacent plots also you are co-owners.
Yes, my lord, there is no trouble of the.
No question of trouble. How can you assert your exclusive position and title? How can you get a protection of your position in respect of a?
Only two plots.
How can you call out two plots? How can you segregate two plots? The entire thing, they also have a right, title, and interest over every inch of that.
They have 2/3 share. I have
2/3 and 1/3 are abstract concepts, right? Now, over this entire property, suppose over these 2 pages are the entire property.
Joint property.
Joint property. You are in occupation of this, but ultimately both of these are joint properties. You are in occupation of this physical possession. But if it's a joint property, he also has a right over every inch of this property. So how can you get an injunction restraining him from disturbing your possession in respect of this particular portion of the property? How can you get a permanent injunction? Temporary injunction in a partition suit you can understand. For the time being, to save the possession till a partition commissioner is appointed and final degree, the allotments are made. But at this stage, I mean, how can you get an injunction regarding your exclusive possession in respect of this? Your possession is unprotected because it's joint.
Yeah, trial court only held that I am entitled to 1/3 share of the 2.
1/3 share, very well. You are entitled. You cannot segregate the.
So I can approach the authority to correct the record by virtue of this degree.
How can it be recorded in your name exclusively?
Not
you are 1/3 share.
Only 1/3 share. Two plots of land. There is 2 sotok in plot number 20 and land measuring 5 sotok in plot number 64. Only 2 plots of lands. There's a trouble. They file a suit for declaration and injunction. Appeal court held that it's a matter of the authority under Land Reforms Act.
Appeal court বলেছে যে suit is specifically barred under section 50.
Appeal court taken additional evidence.
No, appeal court has also held that the suit is barred under 51(c)(2) of.
And appeal court allowed additional evidence.
What additional evidence?
My lord, they allowed defendants to give additional evidence. My lord,
on what?
My lord, page 15. The record reveals that White order number 21 dated such and such court has been pleased to allow prayer for the defendant appellants order 41 rule 27 and defendants appellants are granted permission to adduce additional evidence.
Jabbar Mondal was your common predecessor? Who is Jabbar Mondal?
3 owners are 3. 3 brothers are there. And plaintiffs are the legal heir of 1 brother.
Jabbar was whose predecessor?
Predecessor of the plaintiff. Original land belongs to Jabbar Mondal. Yes. 3 sons are there. Jabbar Mondal has.
All of you claim through Jabbar.
Jabbar Mondal, original owner of the land.
Hmm.
Hmm.
You are
Abdul-
co-sharers being his heirs. You claim through him.
Abdul Khalek Mundal, the total property one third share of I inherited of the property of Abdul Khalek Mundal. The one third share.
At the end, the appeal court says, hence petition under section 5 of Limitation Act allowed means.
Hence petition.
After allowing the appeal, the section 5 was allowed. There was a section 5 in connection with the appeal.
Well, I find there is no section 5 application. There is no discussion prior to delivery of judgment.
Take instructions.
Well, before taking the appeal for
No, you have to know the facts at least. You are not prepared with the facts, whether there was a section 5 application. That itself would be a good ground. The appeal could not be, the judgment could not be, that would be the first substantial question of law. You have to ascertain whether there was actually any section 5. Please come prepared tomorrow, we'll keep it tomorrow.
So
Take instruction whether there was actually any section. That would be the first substantial question of law. The entire appeal is allowed, not a single line of discussion on section 5. And after allowing the appeal, the court is saying section 5 is allowed. That itself would be the first ground of admission.
Allow me one.
Please take instruction, come back. Can you come back tomorrow with that?
No, my lord, only time.
Very well.
Change to a court.
On the prayer of learned counsel for the appellants, the matter is adjourned till when should you keep it?
Next week, my lord.
May 14, 2025.
Deep, lord.
Next Wednesday week.
My
For not today.
On the prayer, you are for the appellant?
Yes, ma'am.
On the prayer of the appellants, the matter is adjourned for the day.
My lord, in this matter, my lord, this is an appeal under section 82 of the ESI Act.
কি হচ্ছে কি বকবক করে
82 of the ESI Act. My lord, the question involved in this case is whether a government-sponsored school can come within the purview of the ESI Act. Now, my lord, section 2, subsection 4 of the Act says, my lord, if your lordship kindly turns to section 2 of
Have you got an extra copy of the Act?
My lord, I have got, my lord.
But you require one copy. ESI Act কি আছে আমাদের ছিল that act because we have the determination, we had brought it. Just give us some time, we'll just find. Yes. You are for the employer.
I am for the employee. The school.
Employer.
A school, I am appearing for the school, government-sponsored school. My lord, there is no, my lord, in this case, my lord, the school has got no own funds. The salary is given by the government to the persons, directly to their bank account. And, my lord, the non-teaching staff also being paid by the government to their account. Now, headmistress is asked to deposit the 25%. My lord, where from I shall get it? My lord, section 4 says it applies in the first instance to all factories, including factories belonging to the government, other than seasonal factories, provided that nothing contained in this subsection is applied to a factory or establishment.
You are reading which provision?
My lord, section 2, my lord, subsection 4.
Yes. Section contribution, yes.
Yes.
Some of them payable to the corporation with the principal employer in respect of an employee includes any amount payable by your. You are the principal employer.
Yes, I am the principal employer.
Yes.
I am the headmistress of the school.
Right.
And, my lord,
it is a government sponsored school. Entire funds goes to the employees. There is no separate funds to the school. Government does not pay for that. Lord, now the ESI says it is within the purview of this act. Lord, I am praying, Lord, let for the time being the order which has been challenged here, that is 25% has to be deposited by the administrators. Where shall I get the fund? There is no fund. Government does not pay fund. For the time being, let them to come.
But what is the difficulty in that? I mean, you are the principal employer. The incidence is on you.
I am not the
government is not the employer.
Government
maybe government sponsored.
Government sponsored, my lord.
But the incidence of payment is first on the principal employer.
Unless the government grants the fund, my lord, where should I get?
Under the law, you are the principal employer. You have to pay it.
Ask me, lord. My submission is, my lord, my humble submission before your lordship. Unless the funds has been given, can I get me from my own salary?
But that cannot be a consideration under the law, because if the legal incidence is on you, that is a question of you have to recover that amount from the government. That's your headache.
My lord, I cannot. I cannot.
But then we have to say that the government is the principal employer.
Yes, I have said so. I have said in my representation also. He was the, I am always ready and willing to pay if the government gives the money. And not three conditions.
Let us come to the definition of principal employer. So, 217. Two applies probably. Roman 2 probably applies. 17 subsection 2 subsection 17 clause 2.
17, Lord.
II probably. In any establishment under the control of any department. This is not a no, not that. You come under 3.
Yes.
In any other establishment, any person responsible for the supervision and control, you squarely come under the definition of principal employer, sir.
In any other establishment, any person responsible for the supervision and control of the establishment.
You are in control.
And if your lordship kindly comes to section 1, subsection 4, your lordship kindly come.
Yes.
Section 1, subsection 4.
Subsection 4, yes.
It shall apply, this act shall apply.
Yes.
In the first instance to all factories, including factories belonging to the government, other than seasonal factories, provided that nothing contained in this subsection shall apply to the factory or establishment belonging to or under the control of the government, whose employees are otherwise in receipt of the benefit of the substantially similar or superior of the benefit provided under this act.
They are not, it is nobody's case that they are in receipt of benefits substantially similar or superior to the benefits.
Yes, I am saying so. Lord, I have from the pay sheet, Lord, it will appear that medical allowance has been given to the employees by the government.
Those were before the forum.
My lord.
Those were before the employees insurance court. Those documents.
Yes. I have. My lord. I have annexed the entire petition of the entire employees court.
So, which annexure should you look into to find out whether it comes under 1.4? Because for that you have to show that
if your lordship kindly turns to page, my lord, annexure P1, page 14.
Yes, page 14.
My lord, MA, medical allowance. Your lordship got it, my lord?
Yes, MA.
But they are getting.
How was it dealt with? You raised this point before the court below.
Yes, my lord.
Please show us how it was dealt with.
My lord, page 190 of this application, my lord. If the judgment is there, my lord. But order dated 9/1/2024.
Yes. Page 190. Yes. Where is the relevant portion where this was dealt with?
My lord, the Lordnet advocate submits inter alia that the applicant is not covered under the ESI Act. As amended, the Lordnet advocate also submits the applicant establishment is a government-sponsored school as per cabinet decision and concerned notification. Lordnet advocate advances that the order of the ESI corporation is illegal, bad, and violative of the provisions of the ESI Act. Lordnet advocate emphatically submits that there is a gazette notification regarding the coverage of establishment, and there are so many government papers which show that the government applicant school is not covered by the provisions of the ESI Act, and the impugned order and notice issued to the applicant from time to time by the corporation should be set aside. And my lord, next turn, government Lordnet counsel for the corporation appeared there, ultimately submits that the applicant's establishment has been validly covered and quantum of contribution has been rightly calculated by the OP, and so that the prayers of the applicant should be rejected and direction should be issued to the applicant for depositing the claimed amount. Now, my lord, on perusal of the case record, it is seen the applicant challenges the coverage of the establishment submitting inter alia. The applicant is a public institution under the affiliation of the West Bengal Board of Secondary Education, and all the activities of the institution are guided by the government rules and orders. It is also contention that the applicant that the institution cannot be covered as per the provisions of ESI Act, and they are not liable to deposit contributions of the staff. But it is prima facie seen that the applicant's establishment falls under the item of Roman 7 of the schedule of the Kolkata Gazette Notification Labour Department, February 10, 2011. It is also fact that the applicant may legally exempted from the deposition of the contribution of the concerned staff. But in that situation, the applicant has to show the court that the required documents, but the present case, the applicant fails to produce any prima facie convincing documents that the applicant institution is exempted from the deposition. Mere filing of some government papers are not sufficient to hold that the present applicant is exempted from the purview of the provisions of the ESI Act. Previously, this court dealt with the then previous case. It has been stated. Now, lastly, my lord.
No, it was remanded to the.
Yes, earlier it has been because no hearing was granted. After granting the hearing, this again we have to hear.
But then ultimately, head minister and the SSO then recommended for coverage of the establishment under section 1(5). 1 within bracket 5 of the ESI Act. 1(5) is that has to be an extension of the provision, which is not proved by them.
Now, my lord, three things is there. First, for ESI can come under the ESI. First, my lord, it should be a private institution. Second, there should be 20 heads.
You have 33 heads.
Yes, I am. So far as second is concerned, I am totally covered. And third, Lord, the salaries below 21,000. There is no person in that institution where the salary is below 21,000.
But we get that. We are not.
Yeah, Lord,
I am not very acquainted with this.
Yes, my lord. I am also.
You will have to train me on that.
My lord, if your lord.
Brother might have had previous experience, but
turns, my lord.
Yes.
Page, I am showing to your lordship. Page 50, Rule 50. I am reading, my lord, for your lordship's convenience.
Rule 50 for 50.
50. Wage limit for coverage of employee under the Act.
Yes.
The wage limit for coverage of an employee under subclause B of clause 9 of section 2 of the Act shall be 21,000 rupees a month.
No, that is for that particular employee.
Yes. Here, my lord, yeah, all the employee above 27,000. A transport staff's also getting 21, above 21,000.
In your case?
Yes.
Oh, you don't have a single employee who
It's
is
not a single employee.
even the group D staff and all everything.
Yes, they are 21,000 getting. That is my instructions, my lord.
But your instructions won't do that. Nothing, no paper. That is what the court said, that papers were not produced.
Yes, that has therefore, my lord, I may let them
It's
to
an
come.
arguable question, but the difficulty is that this is we are being very candid to you because we are more sensitive we don't hear so much at this admission stage, but you are more sensitive because this concerns interests of employees. That is the reason we are more sensitive on this. So even if you stay this admit the appeal, because the arguable case you have made out is under 1/4, section 1/4, it's an arguable case definitely. But if you have to stay the operation, we'll have to. We have to protect the employees' payment in some
limited, my lord, limited stay.
But then we have to say it's in the nature of a money or degree. So therefore, we have to.
Your lordship kindly
have to
consider
directly
also
to deposit.
my condition also. But I have no fund. I have to give it to the from my own salaries. Government does not give me any fund.
But a money decree, if we grant a stay, we have to at least direct you to put in some security. If ultimately you lose them at a
security, 25% has been given by the ESI court. You interim order. 25%.
You have put that in.
No, I have not. That's why I have come up.
But if we stay there, we have to direct you to deposit that somewhere. At least bank guarantee to that effect. Because money suit also, if your money decree is stayed,
yes,
you know the principle. We have to direct, because ultimately if you lose, the employees get nothing. We'll consider bank guarantee, but not a demand draft, bank guarantee.
Lord, kindly.
You'll take instruction?
Yeah, I shall take instructions, sometimes.
Come back tomorrow. Can you take instruction within a day?
Within a day, it is not possible, Lord.
Whenever you want, you come back. Give us a date, we'll keep it on that date.
Next week. Next week, my lord.
Next week, then next week we start from 13th. We'll keep it on 13th.
14th?
Whenever you say, 13th also we can give.
14th, your lordship, I will make it.
13th is unlucky.
No, that is not.
Very well. On the prayer of learned counsel we are not giving the reasons. You take instruction, come back, on the prayer of learned counsel for the appellant, the matter is adjourned till May 14, 2020. 14th May, please come back and just apprise us on this. Sorry. And you are, what is your full name, please? I'm sorry.
Ashok Nath Ghosh.
Mr. Ghosh, can you please just show us on the next date the documents, the exact documents apart from that MA? As per our understanding, you are also paying these ESI deductions were being made from your school.
I am not paying the ESI. Government is giving the MA. Medical allowance.
If you can show us that money trail from your papers which you produced in the court, just indicate the relevant portions, like you showed us MA. That is being given. So similarly, if you can show us something for our satisfaction that government is paying that, nothing is being paid from you, from your end.
It is government sponsored schools, my lord.
Yes, that is generally yes.
My lord, it is the government who pays, not the school. School has no fund at all.
And you also come prepared on the principal employer, because you are in charge. You fall under Roman 3.
Yes.
So you are in charge. Here it is a question of incident, Mr. Ghosh. Incidence of it is on, even if the government does not pay, the first incidence of payment is on the principal employer. So you have to, being the principal employer, you have to pay first. You will be saddled with that. Then you will recover from the government.
What is fallen from your lordship, I understand, my lord, what is fallen from your lordship. But at the same time, I have to consider the plight of the headmistress.
True, the headmistress, she herself draws salary, she'll have to.
He also wants his employees to pay.
The school is run by a trust or what?
No, direct by the government.
Show us those papers also on the next occasion.
And my lord, this is the only school in West Bengal where this has been done.
Oh.
Not no other schools.
Then we can consider whether, because then we'll have to saddle somebody. I mean, then the government has to pay up if the government is to pay.
My lord, we have made
Somebody
the
has to
DI the
pay. The
first.
employees cannot be deprived entirely of this ESI benefits.
I have made DI a party.
DI is a party here.
Yes, my lord.
Very well, we'll consider that. We'll consider.
My lord, then my lord, may I serve to the DI? Let them to come and say, they know we are not paying.
So very well, then we'll just do this. We'll admit the appeal.
My lord.
This is a misappeal.
My lord.
We'll admit the appeal on one ground for the time being, whether it comes under section 1(4).
My lord.
And we'll direct you to serve copy of the memorandum as well as the application on
My
all
lord.
respondents.
My lord.
We are not granting any stay at this moment. So then we'll keep it 1 week after that, I suppose. Because within 1 week you cannot serve.
No, we cannot.
Or should you keep it after the vacation?
After the vacation.
We'll keep it just after the vacation.
Vacation.
Very well. তাহলে একটা order record করুন. The present appeal will be heard on the the present appeal is hereby admitted and shall be heard on the question as to whether the headmistress herself is the appellant or the school.
School on behalf of
Whether the appellant school comes within the purview of the Employees State Insurance Act 1948 on a proper interpretation of section 1 within bracket 4 read with its proviso of the said act, as well as the other grounds taken in the memorandum of appeal. Full stop, next para, the appellant shall serve copies of the memorandum of appeal and the applications on all the respondents, indicating that the matter shall be listed under the heading application on June 10, 2025. We are reopening on 9th June. We have kept it on the very next.
My lord. My lord, one thing, my lord, your lordship kindly ensure that the DI should come. He's never come. That my
serve copy on them, then
I shall serve, my lord, no doubt about that.
you serve, then we before you serve copy, we cannot ensure.
My lord, my lord, he's not coming. He's coming. If he comes, not entire problem will
Yeah,
be
himself should not come. I mean, he should be represented by
some advocates will come.
You please take care that service is effected immediately. That's why I have directed you to serve a copy of the memo also, so that if you can decide the appeal, we'll decide it.
My lord, my lord.
Thank you.
I'm grateful to you, lord.
Thank you so much. Next.
I am for the appellant.
Yes.
In this matter, your lordship, there was a defect. So your lordship directed me to file a section 5 application which was for 4 days, and your lordship also observed that I should not serve to the other side. Today your lordship will kindly allow
Direct
me.
you to serve everything.
Yes, your lordship.
The appellant shall serve copies of the application, serve both applications. Copies of the applications on the respondent, indicating that the matter shall be listed under the same heading on how soon can you serve?
1 week, your lordship.
On under the same heading on May 19, 2025.
May 19.
We're giving you 1.5 weeks. কমা দিয়ে শঙ্খ যা শেষ করলাম ফুলস্টপের জায়গায় কমা দিয়ে when the appellant shall file an affidavit of service to that.
I'm grateful.
Please give the names, please.
Yeah.
Defectuous.
Caveat for
Mr. Rai, defect is trial court judge's name is not there. Just put it in.
The certificate copy was not there because it was mentioned. There was the certificate copy, my lord. There was a certificate copy. And I came to learn from my learned friend that he lost the caveat, but my
Lost the caveat for the decree holder of a respondent herein.
Oh.
Plaintiff, decree holder, respondent herein. Lost the caveat.
Then you have to be given a copy.
Yes, yes. Sir.
Give a copy today.
I'll come back tomorrow, my lord.
We'll come back tomorrow.
Yes, sir.
Very well. The certified copy of both judgment and decree, Mr. Rai, of trial court.
I just
Yeah, we'll check. The certified copies of the
the
certified copies of the judgment and decree.
What happened?
The certified copies of the judgment and decree of the court of the trial court are filed today by the learned advocate for the appellant and kept on record. The appellant shall furnish a photocopy of the
Yes,
same.
I have handed over already for the order change.
তাহলে যেখানটা বললাম certified copies of the judgment and decree of the court below along with the learned second judge's copy have been filed today and are kept on record. Full stop, next para. The learned advocate on record for the appellant is granted leave to rectify the memorandum of appeal insofar as the name of the learned trial judge has to be incorporated in the preamble of the same. Full stop, such correction shall be carried out during the course of the day. You are giving a copy to him right now?
Yes, 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 yes.
A copy of the connected application is handed over here and now to the learned advocate for the caveator. Full stop, the matter be listed under the same heading tomorrow. Just carry out the correction from this you'll get. From the certified copy itself you'll get.
My appearance can kindly be noted. Shivnath Ganguly, advocate.
Yes, yes. Please write on a slip of paper.
এই হচ্ছে নামটা trial court এর।
Siddharth without a.
Memorandum
Siddharth Ganguly.
Shivnath Ganguly.
Shivnath Ganguly.
দেখিয়ে দিচ্ছি হ্যাঁ।
Yes. You have not given a copy to Mr. Ganguly, Mr. Rai. What are you doing?
I am helpless. Just I am informed that there is no caveat.
What is happening nowadays?
My desert.
You have a bad day today.
Item number 42, my lord.
42, yes.
My lord, Mr. Nirmallo Das.
Yes, Mr. Rajgupta, we can't see you. Literally can't see you. Not that
Yes.
you're not in robes or something like that. You park your car at the side of the road and then communicate with us. Because your voice is being disrupted, you can't be seen. Please interpret every line he's saying. He's reading you. Not our fault, you just interpret. Just repeat whatever he's saying. Yes, what did he say?
My lord. This is the virtual problem, my lord. I even not.
Problem is real. Mode is virtual.
This is
Problem is very real. Mr. Dajuto actually can't hear you. Come back tomorrow.
this is the partition. This is the partition suit, my lord.
You move
Yes,
the
Judge, my lord.
FMAT, the injunction has been granted or refused?
It has been refused, my lord.
Why?
Because, my lord, the court's view is that we have mentioned in the plain that the possession is in the defendant number 1. Defendant number 1 is the co-sharer. So therefore, there is no requirement. But whereas, my lord, in the plain itself, my lord, an injunction application.
Property is under control.
And the business.
business-
Am I audible now?
Yes, better.
Yes.
So that- we requested you to park the car.
Yes,
Thank you
yes,
very much for that.
congratulations.
Yes.
No, I had parked. I was there, Millard, before your lordship, but just now I have left, Millard.
Oh.
No, Millard, the issue is, Millard, the partition suit. Millard, between the legal and the all only which
Your voice is coming garbled, Mr. Dajuto. First of all, you are frozen. Your picture is frozen. Your voice is coming garbled. And whoever is behind you is sometimes coming and going. So that's distracting us.
Wait a minute, I'll switch off my video.
Now
I
better.
switched
Now
off my
better.
video.
We can hear you
I
now.
switched off
Actually.
my video.
Yes.
Yes. Now, Millard, yes. Now, Millard, the Millard will find from the custodial of the plaintiff, Millard, all are Millard of Millard, the brother and sisters, Millard, and the ancestors, Millard are common. Millard, one Dhendranath Banerjee. Now, Millard, the property, Millard, the family property, which Millard, the brothers and sisters are Millard seeking partition of. Millard, the order of injunction, which Millard usually being passed in a partition suit at the first day, that has been refused because Millard, the court is of, if Millard kindly comes to the impugn order, page 28. Kindly see.
You have seen the order. Defendant number
From the
1 is in
above, it
control
reveals-
and you are asking for injunction.
Control of Millard, yes, Millard defendant number 1 is in control of one shop room. One shop room which has been, is running a liquor shop. Millard, that doesn't create any dispute, Millard, that Millard, he is running a liquor shop, Millard, given by the father, the license. Millard, what he has done, he has handed over the license to a third party, that is respondent number 3. Now, Millard, the issue now evolved between the brothers and sisters, that Millard really apprehensive, Millard, if the third party rights have been created over the Millard family properties. That's all, my lord, was sought for declaration and injunction, my lord,
Mr.
declaration and
Dashgupta,
partition.
there are two
My lord, that
components of
injunction has been refused.
Mr. Dashgupta, there are two components of the injunction you have sought.
Yes.
One is that
Yes.
they cannot disturb your lawful access and enjoyment to the suit properties. The suit property is confined to that liquor shop.
Yes.
Then we cannot
No,
grant
no, no,
that
no, no.
injunction.
The entire, my lord, no.
But
No, the suit property, kindly see the schedule, my lord.
schedule, we are seeing the schedule, yes.
Kindly see the schedule.
1182
At
square feet in the RS plot number.
Yes, at page
1182.
60.
Probably that is the only thing. That is the, yes. The suit property is the liquor shop.
Suit property is, my lord, part of the liquor. My lord, part of this, my lord, the liquor shop is part of the, my lord, the entire suit property.
We are not claiming, my lord, the liquor shop.
No, no, you are wanting, Mr. Dasgupta, you are telling it. Para 3, you have stated, whoever is listening, we are telling them that after purchase of the said land, said Dhirendranath Banerjee developed the said land and also started business of country liquor in the portion of the said land being an area of 1182 square feet. So he started liquor shop in that 1182 square feet, and that is precisely the subject matter of your suit. So therefore, the entire suit property 1182 square feet liquor shop is going on. We cannot grant you injunction permitting you entry and access into the at this
No,
stage.
I am very well, my lord, as on very well.
Creating third party interest. Creating third party interest, Mr.
Yes, may not
Dasgupta.
be created. May not be created.
We are with you. We'll
Yes.
grant injunction. We'll admit the appeal.
My lord, let there be no third party interest.
Very well.
My lord, let there be no third party interest. Yes. Kindly don't pass any order of status quo, because status quo, my lord, will create, my lord, a difficult for me, because third party interest in some of the properties may have been created in the meantime. So, my lord, I can proceed, my lord, with the eviction then. Kindly pass an order of injunction, dealing and
Very
not
well.
transferring.
Whatever is. Anything else, Mr. Dasgupta, that we should do?
No, no, that will do. That will do for the time.
That will do.
I will come back.
We are sending you a transcript to
That will
sign
do.
it.
For the time.
The present appeal has been prepared by the plaintiffs in a partition suit against an order whereby the plaintiff's prayer for ad interim injunction has been refused. First up, the refusal appears primarily to be on the ground that the defendant number 1 is in occupation and control of the business at the suit property. First up, learned counsel appearing for the appellants submit that the injunction prayer pertains to creation of third party interests as well. First up, next para, moreover, it is contended that the defendant number 1 has created third party interest, and as such, the learned trial judge was committed a legal and factual error in refusing ad interim injunction. First up, next para, we find from the averments in the plaint that the suit property is comprised of 1182 square feet in RS plot number 3167 in the concerned Khatian. Full stop. Next para. It is not clear before the court at this stage as to who is in control of the said shop. Full stop. As such, we are not inclined to accept the contention of the plaintiffs stroke appellants that injunction or ad interim injunction ought to have been granted, restraining the defendants from preventing the plaintiffs access to the said shop room. Full stop. However, learned counsel for the appellants has a point in arguing that if third party interests are created in the property, the rights of the plaintiffs in the suit may be affected adversely. Full stop. Moreover, keeping in view the nature of the suit, this is a partition suit. Nature of the suit, which is a partition suit, irreparable injury may be suffered in the event third party interests are created. Full stop. Next para. Accordingly, the appeal will be heard. The appeal is admitted and shall be heard on the above questions as well as the grounds taken in the memorandum of appeal. Full stop. The appellants shall serve a copy of Can 1 of 2025 on the respondents, indicating that the application shall be listed for hearing on May 21, 2025, when an affidavit of service to that effect shall be filed by the appellants. Full stop. The respondents shall remain restrained by an order of injunction from selling, transferring, alienating, and or creating any third-party interest in respect of the suit property till disposal of the application.
Oblige.
This defect, my lord, it's showing in the cost title.
Yes, sorry, you're right.
Yes, I think, my lord, the appeal,
No, somebody's, probably the trial judge's name is not there. We'll just check.
trial judge name is there, my lord, Uttam Dash.
We'll just check.
The valuation perhaps is.
No, yes, you're right. Valuation statement is not there. Give the valuation statement in consonance with the.
Yes, madam. Please may I please grant
আচ্ছা
it to-
একটা লাইন অ্যাড করে দিন ওই the learned advocate on record, you're the advocate on record.
Yes, madam.
The learned advocate on record for the appellants is granted leave to rectify the memorandum of the appeal by inserting the valuation statement during the course of the day. এখনই করে দেবেন উনি?
Oblige. Deeply obliged.
Thank you. Next.
It pleases your lordship, my lord. I beg to appear for the petitioner, my lord.
Yes.
There is no caveat, my lord.
But he is there.
Then, my lord,
You have instruction to appear for the respondent.
My lord, then I was praying for your lordship, my lord, if my lord can kindly grant me an opportunity to file a supplementary to this application. My lord, I want to bring on record all the orders passed in the court below, my lord. And then I shall serve copy upon my learned friend as well.
Who is on record in your name?
Chita Sarkar.
Ms. Sarkar, learned advocate, having instruction to appear on behalf of the which respondent?
My lord,
there is only one.
One respondent, my lord.
Of the respondent, along with a senior, submits that a copy of the application be given to her, despite no caveat having been lodged. Full stop. Learned counsel for the appellant seeks leave to file a supplementary affidavit in connection with Can 1 of 2025. Full stop. Such leave is granted. Full stop. The appellant shall affirm the said supplementary affidavit within a week.
Within a week, my lord, I will
Within a
try to
week
get
from
the
date and
copies
file
from-
it on the next returnable date. Full stop. In the meantime, copies of the application as well as the supplementary affidavit, along with a copy of the memorandum of appeal, shall be served on the learned advocate, having instruction to appear for the respondent. The matter shall next be listed on 19th, May 19th. We are keeping it Monday week.
Lordship.
May 19, 2025.
Grateful, lordship.
Give a copy by.
I will give a
whenever
copy
you
of the application and I shall serve the
supplementary
supplementary
before
I come back to your lordship.
Give it in advance. We have kept it on 19th
I shall,
deliberately
my
so that he has the weekend to.
I shall, man.
Good.
I shall.
I'm grateful, Lordship.
I am for the plaintiff appellant. My lord, against an order refusing ad interim injunction.
Why refuse, Mr.
For
Bakshi?
specific performance contract where I am plaintiff.
Yes.
My lord, I have a notarial agreement with the owner, respondent number 1. My lord, who subsequently entered with the bank an agreement for loan and taken loan.
Your agreement was for?
My agreement is earlier.
Your agreement
by
is
6 months.
Your agreement is for what?
Agreement for purchase.
Then, Mr. Bakshi, you are not a pre-mortgage tenant. You are not protected. Your agreement, you may have an agreement for sale, but that gives you.
My agreement is earlier.
Yes, but agreement does not confer a right under Section 54. You have an actionable claim.
My lord, that agreement contains that possession has been delivered
to you.
Yes.
Why was injunction refused?
On the ground that
Surfacing.
there is no possession, therefore there is no injury.
Regarding possession, have you produced any other document?
In the agreement, notarial agreement, my lord, or there is a paragraph.
Only that, no other document to substantiate your possession?
No, there is no other.
Then
Because
this
on
is
the basis of that document I entered.
Sir, Bakshi, this is a plausible view. Why should the appeal court interfere? One of the possible views.
No, my lord, absence of reading. He has said no document is produced.
Just let us see that portion.
Yes.
Having heard, we'll just read that portion.
No document is produced. There is no prima facie document from which
No,
That is a
something
prima
else is
facie
also there.
document.
Prima facie appears you are in one hand challenging the intention of the defendants.
That is a prima facie document. And my lord, I am in possession. If I am evicted, my lord, the
No, if you are in possession,
and
then
at this stage, my lord,
yes, if you are in possession, we'll consider that. We'll just check up.
agreement to देखिए. Page 57. ये तो स्टे एप्लीकेशन दिया ना.
Page 53 onwards.
Where has the position been stated? That position is
in the agreement annexed to the application. Manor, kindly see, this is the agreement.
the position where has been stated that position is being given.
Yeah.
You don't find that. It is where is it stated in the agreement that position is being given? No, which clause? We are
in the application.
57
Application
C.
for injunction.
First party with the execution allows the second party to enjoy.
Allows the second party and his family members to enjoy the said property.
This was prior to the mortgage with the bank.
Yes, 6 months prior.
The present appeal has been preferred against the refusal of ad interim injunction in a suit for specific performance filed by the plaintiff. Full stop. The plaintiff plaintiff stroke appellant's case in the suit is that a pre-mortgage agreement for sale was entered into between the plaintiff and the borrower, comma, whereby the borrower, that is defendant number 1, comma, agreed to sell the property in favor of the plaintiff, full stop, relying on clause C of the agreement, small c of the agreement, comma, it is argued that the possession and enjoyment of the property was also handed over to the plaintiff prior to the property being given in mortgage to the respondent number 2 bank. Full stop. As such, comma, it is argued that the principles applicable to pre-mortgage tenants is also attracted to the plaintiff stroke appellant, comma, as prior right on the basis of an agreement was created in favor of the plaintiff before the mortgage was given by the defendant number 1 to the bank. Full stop. Next para. Since a prima facie case has been made out, comma, the appeal is admitted to be heard on the above questions and on the other grounds taken in the memorandum of appeal. Full stop. The appellant shall serve copies of the application bearing Can 1 of 2025 on the respondents, indicating that the same shall be listed for hearing on May 20, 2025, when an affidavit of service to that effect shall be filed by the appellants. Full stop. The respondents shall remain restrained by an order of injunction from disturbing the peaceful possession of the appellant in respect of the suit property and or from creating any third party interest in respect of the suit property till June 30, 2025 or until further order, whichever is early.
Another point, whether such possession is amount to encumbrance.
Mr. Bagchi, we have...
Because, my lord, in the order of taking possession,
yes,
it is written
unencumbered.
Unencumbered must be.
But that is not germane for creating your right in your favor, because that the bank may take. But here the principal attracted is you have cited 20.
Lordship will decide against us.
That will be decided in the suit.
I am not
decide so many points. The principle applicable to pre-mortgage tenants, you have cited a judgment on this 2016. The question is whether that will apply to an agreement holder also.
Again, my lord, your lordship may kindly be. This is the application on which loan was sanctioned. That is.
You need not look into that. We have admitted the appeal and granted it.
But I'm
you-
appearing before your lordship, my lord. I am myself hesitant very much.
no question. But keep extra copies of that, Mr. Bagchi, at the time of hearing of the application, because the other side will be citing this. Unless
I may, my lord, I can give this.
not right now. At that point of time, keep extra copy.
My lord, I am for the appellant.
You're for the appellant?
Yes.
Yes.
There is also an application for my lord the stay as well as the my lord the for permission to visit my son. This is my lord the appeal my lord under section 27 of the Guardians and Minors Act my lord passed my lord the against the order passed under section 25 of the Guardians and Wards Act. And my lord I am the plaintiff there.
Signed copy, my lord.
Nete page যাবেন স্যার নেটে পেয়ে যাবেন তো নেটে অর্ডার পেয়ে যাবেন
Mr. Bagchi, server copies, website copies, you are obsolete on this. You don't even submit on this.
Tomorrow is the position. Now they will take.
This evening you will get the order on the server.
হ্যাঁ নেটে পেয়ে যাবেন আজকে Lord,
Yes.
Lord, I filed the application under section 5 of 25 of the Guardians and
You are the father of the child.
I am the father of the
The child is aged about
11 years, more than 11 years.
son or daughter?
Son.
Son. What has been passed? What is the impugned
My lord,
order?
can you see impugned order, my lord?
Yes.
My lord, I have annexed with the, my lord, the memo of appeal. Can you see?
Right. Your application, it was your application.
Yes, but this is my application.
Yes, rejected.
My wife, my lord, she appeared before the learned trial court, my lord, up to the stage of the order, my lord, granted by the learned judge to visit my son. That order was passed on 30th September 2024. But and my lord, the learned judge my lord, directed the produce the my lord, the boy in the office of the DLSA. But she never, my lord, then my lord, thereafter she never produced the boy as well as the never appeared before the court. And this order was passed after that order, that is on 28th. My lord, the
difficulty is we cannot pass an ex parte visitation that will direct. How soon can you serve and come back? We'll admit the appeal right now. We'll direct you to serve. How soon can you serve?
My lord, by registered post here now. Tomorrow, my lord, I can serve.
Tomorrow will serve, but the track report has to be produced before us.
My lord, then my lord, kindly fixed on 28th or 22nd.
28th we are keeping it. Let us take a chance.
Yes.
The present appeal has been preferred against the dismissal of an application filed by the appellant father under section 25 of the Guardians and Wards Act 1890 in respect of guardianship and custody of his of the minor son of the parties who is aged about 11 years. Push up next para. We find sufficient grounds on fact and law having been made out in the memorandum. Push up accordingly, the appeal is admitted and shall be heard on the grounds taken in the memorandum of appeal. Push up, the appellant shall serve copy of both the application and the memo.
Record one. I have already served upon her. But she
No, but
received that. Yes,
without a caveat was lodged.
no caveat was
Before
lodged.
admission, we cannot take note of that.
In anticipation, my lord, I served. My lord.
The appeared we could have taken. That would have
all right.
The appellant shall serve copies of the application as well as the memorandum of the appeal on the respondent, indicating that the matter shall be listed next under the heading application on May 20, 2025, when an affidavit of service to that effect shall be filed by the appellant.
But kindly make it either on 19th or 21st. 28th.
May 21st. May 21st. 21st May.
Great.
Thank you.
That the learned trial judge never took into consideration section 5.
No,
And
we have seen the order is a bit unhappy because nothing has been considered.
Nothing has been considered.
Just because you have failed to show that the mother has failed to look after 11-year-old son, and also intelligent preference has to be taken.
Yes.
Because 11-year-old son,
he will give
that
statement.
Yes, should be taken.
Good.
Yes, Mr. Banerjee.
This is from an order refusing to grant ex parte ad interim order of injunction in a suit for specific performance of contract, declaration, perpetual injunction, mandatory injunction, cancellation of multiple instruments.
You just tell us what you have not asked for. That will be easy.
The facts are a little checkered.
Specific performance is the main relief.
Main relief. But coupled with, of course, instruments which have been executed in breach of the contract entered into with me. The facts are little checkered, but will take some time. Kindly bear with me further. The land was initially owned by one Lajpat Rai Bhagat. Lajpat. Lajpat had 3 sons and a daughter. After Lajpat, the property came to them. 2 of the sons, Ravi and Kiran, they executed will. Wills were probated by different fora. After that, the person who got the property under the probated wills, he executed development agreement, registered development agreement with me. 2 development agreements were executed in my favor.
That could be only in respect of share of Lajpat's property. because
Undivided 1/4. Yes. After that, I spent money, started developing. In the meantime, what happened?
Undivided share you started developing.
Yes.
Anyway, you have done that. So
that was done. Now, 2 applications were filed for revocation of grant of probate in both the 2 matters, which are pending.
So Ravi and Kiran got by way of that will.
Ravi and Kiran were sons of Lajpat.
No, who got by
Narayan got it through will.
Narayan got from whom?
Ravi and from Kiran, both.
Oh,
through
he
will.
got it through will.
Yes. Narayan got it from Ravi through will.
Narayan entered into this development agreement
With me.
With me. 2 revocation applications, what happened?
Those are pending. In the meantime, what happened? There were multiple suits filed. Some purchases, who are respondent numbers, 10 to 12 here.
Who's filed against you?
Yes. Some against me, some, where I am not implicated. These purchases have now come up. They say they have entered into, an agreement for sale with the, legal heirs of, Lajpat. 3 suits are filed, for that. There is a suit filed by Narayan, against, and would be, promoter saying that, the development agreement is bad. By that promoter, there is another suit filed. Multiple suits, are filed. All are pending. The applications for, revocation of grant of probate are also pending. I filed a consolidated suit saying that, I want specific performance of the development agreements entered into with me. Cancellation of the development agreement, which, was surreptitiously entered into by, the legal heirs of Narayan. And Ravi and Kiran also, some legal heirs of them, with a third party. I also wanted cancellation of the purported agreement for sale, declaration that that is null and void. So there are multifacets in the litigation. I implemented everyone, filed a suit for declaration, specific performance of contract, asking everything under the sun, and also prayed for an injunction that let no one do anything with regard to the property till a decision is taken. That was refused on the ground that the development agreements entered between me and Narayan had an arbitration clause. That's the ground of rejection. And says that development agreement had a forum selection clause. Firstly, this is absolutely suit for land.
No, you are asking for specific performance of that agreement also.
Not only that. I am asking for specific performance of that agreement. I am asking for cancellation of the subsequent instruments. I am asking for the cancellation of the agreement.
The present appeal will admit. The present appeal has been preferred against an order of refusal of ad interim injunction in a suit filed by the plaintiff stroke appellant for multiple reliefs, apart from seeking specific performance of an agreement of 2 agreements, primarily for development of the suit property, the plaintiff appellant has also sought the cancellation of certain other deeds.
But kindly say instruments, agreements are also there. So
certain other instruments which affect the rights of the plaintiff stroke appellant in respect of the suit property. Full stop. In brief, comma, one Lajpat Rai.
Yes, my lord.
One Lajpat Rai was the original owner of the property who left behind as heirs
3 sons and a daughter.
3 sons, comma, namely Ravi and Kiran.
Ravi, Kiran, Laj, 3 sons and Hemi Kapoor daughter.
Ravi, namely Ravi, comma, Kiran, comma, Raj. Laj and a daughter. Full stop. Subsequently, wills were executed by Ravi and Kiran in favor of one Narayan Chandra Sarkar. Full stop. The said Narayan Chandra Sarkar allegedly entered into a development agreement with the present plaintiff.
2 development agreements.
Entered into the 2 agreements in question with the plaintiff. Full stop. Next para. However, comma, the property has a checkered career inasmuch as several suits are pending, comma, some challenging the agreements entered into by Ravi, Kiran and others with third parties in respect of the property, as well as other collateral documents, comma, all affecting the suit property. Full stop. Next para. When the plaintiff stroke appellant filed the present composite suit and took out an injunction application in connection therewith, comma, the learned trial judge, comma, by the impugned order, refused the ad interim prayer of injunction primarily on the ground that the agreements between the plaintiff and the said Narayan contains a jurisdiction clause restricting courts in Kolkata to have jurisdiction to try the suit. Also, comma, there is a specific arbitration clause for settlement of any dispute emerging between the parties. Full stop. On such ground, comma, the ad interim injunction order was refused. Full stop. Even in the event there is an arbitration clause in the agreements in question, comma, the same per se does not operate as a bar to the civil court exercising jurisdiction unless an appropriate application under Section 8 of the Arbitration and Conciliation Act 1996 is taken out in the time as stipulated in the said provision and is allowed. Full stop. Arbitration is a waivable right, waivable right, and as such could not per se be a premise of refusal of injunction. Full stop. The learned trial judge, comma, prima facie, comma, ought to have entered into the merits of the case. Full stop. Next para. We also find that a prima facie case for grant of injunction has been made out in view of the property being in jeopardy of being transferred in favor of third parties, thereby creating unnecessary multiplicity and probably, in all probability, rendering the suit infructuous. Full stop. Accordingly, the appeal is hereby admitted and shall be heard on the questions formulated above, as well as the other grounds taken in the memorandum of appeal. Full stop. Next para. The appellant shall serve copies of Can 1 of 2025 on the respondents, indicating that the application shall be listed for hearing on May 20, 2025, when an affidavit of service to that effect shall be filed by the appellant. Full stop. The respondents and or their main and agents shall be restrained till June 30, 2025 or until further orders, comma, whichever is earlier, comma, from selling, transferring, alienating, encumbering and or disposing of the suit property in favor of any third party, till June 30, 2025 or until.
Grateful. Thank you. My lord, the next appeal, my lord, after refusal, I filed a section 151 application saying that, my lord, arbitration is not a bar, cannot be a bar and all. That section 151 is
I filed.
This is from the dismissal of that section 151.
151 seeking what relief?
My lord, the same relief, my lord, I prayed for, saying that arbitration cannot be, my lord, cannot stand in the way. My lord.
What is the prayer of the?
My lord, 151 application, my lord, will kindly get, my lord, in the paper book. Paper book bar code is the page. But at 4:31, my lord, it starts. My lord will get it, my lord, 4:31, no? 4:31.
You sought for a recall of that order?
Yes, my lord, kind of. Kind of.
This 151 was not maintainable. 150, your 39(1) is there.
Yes, my lord, I also asked for, my lord, an interim order again there.
No, we'll hold that, we'll dismiss this appeal.
Right.
এটা ইয়ে করো, এটা order নিন. The present appeal has been preferred against an order rejecting an application under section 151 of the Code of Civil Procedure filed by the plaintiff stroke appellant in a suit for multifarious reliefs, including specific performance of 2 agreements for development. For sub next para, we find from the records that by a previous order passed by the learned trial judge dated January 29, 2025, the ad interim prayer of injunction of the plaintiff appellant had been refused. Full stop. By way of the present application under section 151, virtually the self-same prayer for injunction was reiterated. Full stop. Next para. In the since the application, though captioned under section 151 of the Code of Civil Procedure, was effectively for an order under Order 39 Rules 1 and 2 of the Code, we deem the appeal to be maintainable. Full stop. However, since at the juncture when the application was made, and a proper injunction application under Order 39 Rules 1 and 2 was pending, and an ad interim prayer in connection therewith had been refused, the second application under section 151 was not maintainable in law. Full stop. As such, the learned trial judge was justified in rejecting the said application. Full stop. Next para. In effect, by way of the section 151 application, a recall of the previous order has been sought, and the injunction prayer refused earlier had been reiterated. Full stop. Next para. In view of the above, we are not inclined to admit the appeal under admit the appeal. Accordingly, FMAT 100 of 2025 is dismissed under Order 14 Rule 11 of the Code of Civil Procedure. Full stop. Accordingly, Can 1 of 2025 is also dismissed without an orders to cost. Full stop. However, it is made clear that the dismissal of the present appeal shall not in any manner influence the adjudication of FMAT number, which is the
99.
FMAT number 99 of 2025, which is pending before this court. FMA number.
But I'm just now reminded, 20th, I may not be there. Maybe on 19th, 21st, subject to, of course, my lord.
21st করে দেবেন।
Grateful.
এইটা অনেকদিন তো 21st হবে।
Grateful.
FMA নাম্বার গুলো ঢুকে যাবে তাহলে দুটো।
My lord, grant of ad interim order of injunction in a partition suit. My lord, what had happened was, my lord, I've challenged that. My lord, no, what had happened was initially the same plaintiff, my lord, had filed a suit for declaration and injunction. My lord, that declaration and injunction he had obtained, my lord, an order of injunction before the learned civil judge junior division.
Yes.
Now, my lord, that order was challenged by us, my lord, in misappeal. My lord, the appellate court found that he has no right, title, and interest over the property. Operation of that order was stayed. Now, my lord, what he does is, my lord, he suppresses the earlier suit and files another suit, my lord, before the civil judge senior division. That is a suit for partition. And my lord, obtains an order of injunction.
Will a misappellate court at interim stage finding operators
But kindly says, my question is, he has suppressed the pendency of the earlier suit. It's a same parties, same suit property.
Will admit the appeal.
Grateful. But I was praying for a stay of operation of that order. Kindly.
Injunction.
But kindly, I was praying for a stay of operation of that order. Because based on that order, he will sell, transfer, and alienate. But kindly sees, the order.
Status quo in respect of nature character.
Kindly sees the order of the appellate court once. The order of the appellate court is at page 89.
Your present impugned order is status quo regarding nature character
possession. But he is no one in respect of the suit property. Kindly sees.
How can I take advantage of this and transfer the property?
But I was praying for a stay of this order, because. But kindly sees the order of the appellate court once. But that is at page 86.
No, you take your arguments on face value even then.
But kindly sees the order of the appellate court once in misappeal. Well, at page 86. But the appellate court found that he has no right title of interest, even his name is not there in the record of rights.
Record of right does not create title.
And he could not produce any document with respect to his title.
Here he must have produced some document.
No, nothing. Kindly sees the order passed by the learned. Page 83 is the order passed by the learned civil judge.
Change nature and character. Prima facie possession and co-shareship. Certified copy of deed of conveyance. Alert information has been given here.
That was in respect of title suit 455. But he has filed.
In the present impugned order, please come to the impugned order.
Lordship.
You have not seen the impugned order you have challenged. Mr. Das, please come to the fourth paragraph of that. There is a clear finding.
But he does not
conveys alert information. Everything was given.
But he will.
No injunction, no stay. Learned counsel for the appellant argues
but
that.
So far as the fact of suppression.
We are admitting that for that. Otherwise, we would dismiss it at the outset. Learned counsel for the defendant's appellants in a suit for partition has challenged. The defendant's appellants in a suit for partition have challenged an order of grant of ad interim injunction in a partition suit. For sub next para, learned counsel for the appellant submits that in a previous suit for declaration of title and injunction filed by the plaintiff stroke respondent number 1, similar relief had been sought. Injunction was granted by the trial.
Granted.
Ad interim. Ad interim injunction was initially granted by the learned trial judge in the said suit. However, the appellate court, in an appeal preferred against the said order by the present appellants, had stayed the operation of the said ad interim order of injunction on the specific finding that the plaintiff stroke respondent number 1 herein had failed to prove his right title and interest in the suit property, in the self-same suit property. So it is argued that during pendency of the same, suppressing the said fact, the present suit was filed, and as such the plaintiff stroke respondent number 1 was not entitled to injunction in equity and in law. Next para, since arguable questions have been raised, we admit the appeal to be heard on the questions as taken in the memorandum of appeal. However, since we find from the impugned order that a certified copy of a deed of conveyance and alert information was furnished by the plaintiff stroke respondent 1 before the court below, we are not inclined to stay the operation of the impugned order at this stage, more so since grant of such order shall tantamount to allowing the appeal before it is heard on merits. The appellants shall serve copies of the application and the memorandum of appeal on the plaintiff stroke respondent number 1, indicating that the application shall be listed for hearing on May 21, 2025, when an affidavit of service shall be filed to that effect by the appellants. Service of notice on the defendant numbers 2 to 8 stroke respondents is dispensed with for the present.
Grateful.
Order putting this
exhaust.
Exhaust.
Yes.